took me a little while.
All right, should we take
Think we're going to go ahead?
Can we speak from seated positions? What do you prefer?
That's a microphone?
You can speak.
Red means it's on.
For each of our 5 minutes.
You're actually introducing yourself to the people that you're working with next year. You just didn't realize it right now.
Don't say anything.
Well, I did notice the, why I was like,
Good morning. And welcome, and I'm going to do something. I'm going to ask everybody just to come on up. We want to make this kind of a discussion as much as we can. If there are people watching us on live stream, come a little closer to your monitor and feel a part of this. Welcome to this session of our celebration of the 20th anniversary of the Center for International Legal Education. We had what I thought was a nice time last night celebrating it, and today we're going to do a little more with some substance. And we're going to begin with some people who are going to talk about their career paths, and we have a wonderful panel. I'm going to very briefly introduce the whole group and then get out of the way, and then they're going to, in alphabetical order, each spend about 5 minutes and then we'll open it up to questions so that students can find out where and how they're going to get their job. And if I go alphabetically, Charles Katubi is a 2001 JD graduate of the University of Pittsburgh. He's a partner in the offices of Jones Day in Washington, where he counsels both private and sovereign clients, does international dispute resolution, investor-state disputes, and arbitration. He has authored briefs in more than a dozen cases before the U.S. Supreme Court. He's argued cases on appeal in the 3rd, 6th, and 9th Circuit. And most importantly, from my perspective, he's currently completing a book with his colleague Luke Sabota for our CILE study series that is on general principles of law and international due process. Next to Charles is Max Lawn, who is a 1988 graduate of a law school. He is Vice President and General Counsel for Alcoa, Inc., where he oversees day-to-day operations of Alcoa's legal activities worldwide and serves as head of the legal department's mergers and acquisitions practice. Max has spent his entire career with Alcoa, right out of law school, right after being my research assistant. So being my research assistant propelled him to being general counsel for Alcoa.
Straight line.
Next to Max is Vyosa Osmani, who is one of our LLM graduates from 2005. She's also an SJD graduate from 2015. Vyosa is a member of the Kosovo Parliament and a professor at the University of Pristina in Kosovo. In the most recent elections, she received more votes than any other woman in the Assembly and more than any other individual except the Prime Minister. Prior to being in Parliament in Kosovo, she served as legal advisor and chief of staff to the president of Kosovo. So she's had a little bit different experience after her law studies than the first two. Next to Vyosa is Katerina Asanova, who's a 2008 JD graduate of law school. She's a trial attorney with the Office of International Judicial Assistance with the Office of Foreign Litigation at the U.S. Department of Justice, a position she has now held for 3 weeks. But prior to that, she was at the Commercial Law Development Program in the U.S. Department of Commerce, where she managed CLDP's technical assistance programs in Eastern Europe and Eurasia. On this side, Wes Rist is a 2005 JD graduate. He's Director of Education and Research at the American Society of International Law, where he supervises a variety of programmatic activities for ASIL's membership and the international legal community. ASIL is the premier international organization for programs in international law and also working to develop international law. Prior to joining ASIL, Wes was Assistant Director of the Center for International Legal Education here at Pitt. He also holds an LLM degree from the University of the West of England. On this side of West is Elizabeth Shackelford, who graduated as a JD in 2006. She is a Foreign Service officer currently studying Somali language in preparation for her next overseas posting as a political officer in the Somalia unit, which will be headquartered in Nairobi, Kenya. She previously served in the Department of State's Operations Center, the Secretary's 24-hour Communications and Crisis Management Center, and she has also served in South Sudan, where she was the last one out. She directed the evacuation of embassy personnel and U.S. citizens following the outbreak of war there in 2012 and received the Consular Award for Service for 2013 for her service in that process. She began her career in the Washington, D.C. offices of Covington and Burling, and then moved to international development work at the firm of Booz Allen before going to the Foreign Service. And immediately on my right is Mark Walter, who is a 1998 JD graduate. He is Managing Director for Trade Policy at Nathan Associates in Washington, D.C. He has led USAID projects in Ethiopia and elsewhere, now focusing primarily on work in Burma. He is in the development area, but not too long out of law school, was also an assistant director of CILE. He was the first assistant director we had, did a lot of on-the-ground work for projects we had with the U.S. State Department in Ukraine, Serbia, and Kosovo. So we really have a great group of Pitt Law graduates here to talk about career issues and their career paths, how to get that job, like their job that they really love having, that can be a neat place to be in life. So I'm going to turn it over now, and I think we've decided that we'll just go alphabetically in the same order that I introduced them. So Chuck, it's all yours.
Okay, thanks, Professor Brand, for that. So career paths. I've been at the same place, same firm for 15 years, and this is stealing Mac's jokes from last night. He's been at the same place for 27, so he beats me. We either like what we do or we're incredibly unimaginative. I think it was your word. So I hope I'm not the latter. But it's a bit of an oddity to stay at the same firm for so long. But I guess I'll talk for 5 minutes about how I got to where I am, and I do think it's a bit of a metaphor for how the practice of law is changing globally. I started off coming out of law school after a clerkship, and I wanted to be an appellate lawyer, a domestic appellate lawyer. I really liked the practice of appellate law. I really liked arguing for federal courts of appeals, and that's where I really focused my career. But what I soon realized is that my clients were not just finding themselves before U.S. federal courts and state courts and courts of appeals. They were finding themselves before Ecuadorian courts and Nigerian courts and Uzbek courts. And in order to best serve my clients, I had to expand my skill set. And that's the first thing I learned when I was in the practice of law for a few years. And I think it's a good thing to always keep learning, is you have to expand your skill set to best serve your clients. So thankfully, at that point, I had my CILE teaching to rely upon. Because of being Professor Brand's research assistant, I had spent a summer at the Hague Conference. After my first year in law school, I spent my second year studying abroad in the UK and got my LLM. I worked at the Max Planck Institute, also because of Professor Brand after law school. And I had this deep reserve of international law background to take me in the direction that I thought I needed to go to best serve my clients. And that direction quickly turned from litigation to arbitration. Now, I will admit, when I was in law school, I wasn't a firm believer in arbitration. it seemed odd to me. It seemed awkward to allow to private parties to contract to take their disputes completely out of local courts, completely out of whatever law applied, and to apply whatever law they wanted. It seemed a bit of a misnomer. Why would you need to do that? And, if we had a symposium, there have been many of them, that tried to debate what's better, arbitration or litigation. We could fill this hall, and every professor here would have different views on what's better, litigation or arbitration, on cost, on speed, on efficiency, on confidentiality, and we'd generally get nowhere. But one thing I soon realized was acutely true, is that the debate completely changes when that dispute is international. The fact of the matter is, and I've learned in my 15 years of practice, is international arbitration is something completely different. It's a virtual monopoly. Nothing can take its place. Because when you're looking at the alternatives, what is the alternative? My court or my opponent's court? The fact of the matter is, international arbitration may be the second best option for each party, but it's the only real option that they have. It is a virtual monopoly, and the enforceability of arbitration awards versus judgments makes it a practical necessity in the global practice of law these days. So my practice, what was once an appellate practice, soon started trending for me and my clients towards international arbitration. And my practice is even a bit more specialized. Yeah, sorry. My practice is even a bit more specialized. I practice primarily investment treaty arbitration. Investment treaty arbitration, if you've been following the news, tends to be the public whipping boy for international practice these days. A lot of politicians on weekend talk shows like to debate whether we should allow private parties to sue foreign sovereigns for damages that they suffer when they make investments around the world. And that's another debate that we can save for another day. But the point of the matter is I tend to be a true believer in the necessity for investment treaty arbitration, just as the same as I am for international arbitration. This area of practice, whether you're representing a individual investor, representing a corporate investor, a Western investor, or an investor from a developing country, and I do all of those things, it's a practical necessity with all of the capital flows we have across border these days. It is really the only forum we have, and it's really only been around for 20 years. It's the only forum where public international law rights, you and I's public international law rights, become meaningful and real in a practical setting. So as you can see, I am a true believer in the system, and that is another thing that I want to impart to you. To be a global lawyer, it's good to be a believer in the regime that is being created for your clients, and a believer that this is something that is assisting the rule of law around the world. I tend to believe that is true for international arbitration and investment arbitration, and I think that is what has really led me to continue to do the work that I do and to try to do great work, because I really believe in where it has led me. Happy to take any and all questions. I'll keep it short, and so you can hear from everyone else. Thanks.
Hi, I'm Max Lawn. I'm officially looking around the old guy on the panel. I was in law school here. I'm ashamed to admit, almost 30 years ago. So I've been practicing law for quite some time, and I think they call it the practice of law because you practice it until you perfect it. A little bit about my background before law school. Undergraduate, I got interested in things international when I was in high school. My father was a college English professor, and he spent a year. The family spent a year in the bad old communist days behind the Iron Curtain in Romania. I was there initially from 1977-78. Spent a year in a Romanian high school. Came back from that. Going into that, I was sort of vaguely interested in studying maybe medicine, something like that. Coming back from that, I was very interested in history and political science, those sorts of things. Went to Rice, undergrad, studied history and Russian language there. Why Russian? Well, I had a little bit of German. I'd had some French and Spanish in high school, and I thought, why not? Well, why not is because it's a very difficult language, which I learned, and one of the things I learned was that sometime after the age of 18, your language acquisition facilities decline substantially. I don't know. Elizabeth will have a counterpoint to that since she's deeply learning since she's learning Somali. But one of the things I learned in the course of studying Russian in college was, my Russian after 4 years isn't nearly as good as my immersion Romanian that I picked up when I was 16 or 17. Anyhow, my pathway to law school was sort of trying to make a decision when I was graduating from Rice. I got a Fulbright scholarship of my own, went back to Romania, spent 2 more years there as a graduate student in history. The history job market was then as now atrocious and so practical person that I was, I chose Dorby. Dorby was law school, and Pitt had been kind enough to first admit me and then defer me for a couple of years, and so I came back to Pitt. Fortunately, I met Professor Brand very early, the first week or second week of law school, and got to talking about my international interests and sort of followed that pathway here, even before there was a CILE and before there was a curriculum. As I mentioned last night, it was largely Professor Brand's guidance that got me to interview with Alcoa. I interviewed with all of the big firm, typical big firm stuff. But Ron had observed that because he'd had a couple of students who had done independent studies with the Alcoa legal department, and said they're doing some very interesting international work, commercial work, investment work, development work of their own. You should talk to them, and I did. It was a summer associate there after my second year of law school. They liked me, I liked them. Still there, haven't looked back. Other people have come and gone, right, Diane? But I've been very happy there. Spent most of my career doing mergers and acquisitions, mainly international mergers and acquisitions. Alcoa as a company sort of marched across Europe in the early part of the 1990s. We bought. It was an era of privatization in Europe. We bought state-owned aluminum industries in Hungary, in Italy, and in Spain. We looked at a number of other things that were being privatized. I had a lot of Russian adventures during the same time. We started going to Russia in about 1992. Finally succeeded in buying something there in 2005. So it was a project with a very long gestation period. I think the thing that one of the things, and building on what Chuck said, it wasn't inevitable when I came out and went to Alcoa that I was going to do international. I had a strong interest in the area, but one of the things when I came out and said I really want to do international, they sort of patted me on the head and said, "That's very nice, but first you're going to have to be a domestic lawyer." And that turned out to be really the best advice that I've gotten, because what we do as lawyers, and particularly as commercial transactional lawyers, is we evaluate risk. And one of the things we have to do is to be able to explain the risk to our clients. And in order to explain the risks of a transaction in Russia or Saudi Arabia to the management of a multinational corporation, my management, our CEO is German, our CFO is American, one of our group presidents is German, and another is French. So we've really got a multinational senior management group, but they're all part of a U.S. multinational company, and so they have come to understand the U.S. system. So what we have to do as international commercial lawyers is to translate the risks and the workarounds and the countermeasures that we put in place in a transaction into terms that they can understand into U.S. terms. And in order to put them into U.S. terms, you have to know those backward and forward and be able to do that. So part of my message is absolutely pursue your interest and your dream, but don't lose sight of the fact that you're getting a good U.S. legal education here, and you're going to have and make sure you keep that grounding. Thanks.
Good morning. Once again, I had the opportunity to talk to some of you last evening during dinner and discuss a little bit of my experience and how I thought that was impacted by CILE and especially Professor Brand and other colleagues. So I would like to focus a little bit more today on my career path rather than speak in general. So my career path has been quite unique. I wish I could tell you why it happened as it happened. Sometimes I feel like it was because it was meant to be, because I never really thought of being engaged in politics while I was in law school. In fact, there was a reason why I decided to study international commercial law when I came to Pittsburgh, and that was precisely because I didn't want to get involved in politics when going back home. But things turned out as they did, and I did end up in politics. I guess my advice would be for all of you who are still students, that everything starts while you are a student. It really starts here at the law school because it depends on the relations that you build among each other, especially if you're interested in international careers, but also with your professors. Because if it would happen as it happened in my case, your professor might end up becoming the president of your country. Because this is precisely what happened in Kosovo. It was because of the hard work that you show as a student and the interest that you show as a student that your professor will not forget, even after having thousands and thousands of students, as it happened in the case of Kosovo. The professor who became the president will remember you and will ask for you to become his legal advisor when he becomes president. In fact, in my case, it has not only been the people in Kosovo that have impacted me most. It was from the very beginning the people from Pittsburgh. I was only 19 years old when I met Mark and Professor Brand, who had come to Kosovo through a U.S. State Department grant to help some of us, in fact, the students who would be interested to develop their international experience. I was recommended by some of my professors, and again, it is important that you impress your professors while you are a student from your first year, to meet Professor Brand and to meet Mark, and then, of course, it was important to impress them. So that I was selected to represent the University of Pristina, my university, in an international competition. Doing well there was a step towards me becoming a potential candidate for the LLM degree here at the University of Pittsburgh, which I completed in 2005. But right after I completed that degree, as I said, in the area of international commercial law, I was very interested in arbitration, on the UN Convention on Sale of Goods. My interest was to go back and teach to Kosovo, and I did. There was some sort of an informal agreement between the University of Pittsburgh and the University of Pristina that the people studying here would serve as a capacity building effort of the US government for Kosovo, which was a war-torn country and really needed lots of young people who had studied abroad to go back to the institutions and help build those institutions, because we had to build them from scratch. So when I went back, I thought that the capacity building has to start from the university, where the next generations are educated. So I went back to teach, but as I said, what happened was our president, who was then in power, had died, and we had a new one, who was one of my professors in Kosovo, who had offered me a job to become his legal advisor initially. How did I come from his legal advisor to his senior legal advisor to his first advisor, advisor on foreign affairs, and then finally chief of staff? Hard work. I know you hear that quite a lot. In politics, because although my job was professional, giving professional advice, you're in politics. The more hard work you do, the more people around you will hate you. They will try to fight you. I guess it happens in every other country. At least this is what colleagues from other countries tell me. They will try to stop you because there will be lots of people around you who will not do hard work but will try to get to the top through other methods. My advice is keep the hard work. Someone will notice you, and if you are lucky enough, the person who needs to notice it will notice it and will eventually promote you to where you really deserve to be through the hard work. While working in the president's office, I got to be part of the most historic processes that my country has gone through. It was the negotiations for Kosovo's final status for 2 years that I was involved in. The Declaration of Independence, actually working on the Declaration of Independence, being part of it. Writing the first ever constitution of Kosovo, of an independent Kosovo. And then defending my country's independence in front of the International Court of Justice. Working on the recognition process, which is quite an international work because you have to travel all along the world, work one-on-one with the highest officials of countries in all continents that have not yet recognized your country's independence and convince them to do so. Talk on behalf of your people about your people's struggle for independence, and try to know the history of each and every country in the world, because you cannot have the same talk with every president or with every foreign minister. It has to be shaped or tailored based on their interest as well and based on their history as well. And then work on membership for my country to international organizations, which again, every single one is different, but you will need your lawyering skills in order to convince countries to recognize you because you convince them that there's a legal basis for it. Finally, after all of this experience, after working with the president for 5 years, I decided to run for office, so become an actual politician myself. It was a very hard decision because, again, I was still thinking, do I really need to be deep into politics? But then going around your country and seeing all of the challenges that your people are facing, you truly understand that you can make a difference no matter how small it is. At least you can try. And this is what I thought I could do by running to become a member of the parliament, the only place at that time which was the place where politicians are directly elected by the people. Currently, I'm serving my second mandate and mostly involved in issues of rule of law and foreign policy, but also doing quite a lot of social inclusion stuff, which means, in my case, helping women and young girls in their access to justice. Because of that work, I was awarded by UNDP as a social inclusion champion, because I think no matter what your interest is, if you're living in a country where lots of people are still facing daily needs and lots of challenges, you should not leave the social inclusion part aside. The third part of my career deals with teaching. Despite of being involved in politics, I continued teaching all along. I think it is one profession where you can really see that you're making a difference in people's lives. Especially if you're working with students that have never had an experience, you help them get funds, you help them go beyond Kosovo, you help them participate in international competitions, and you help them understand the one thing that is the same, that is the truth for every part of the world. And again, if you work hard, you'll be the same as those people from the US, and China and Russia and everywhere. It doesn't matter where you come from. If you work hard, you're going to be equal. So that's all for me for the moment, and I'll welcome your questions.
Good morning. My name is Katerina Asanova. I am a 2008 graduate from the law school. And I think why Professor Brand asked me to come up here, because I've certainly not have achieved nearly as much as everybody else on these panels, is I have managed to do some very interesting work within the U.S. government after graduation. Just to tell you a little bit about what I've done, I struggled to find a job. 2008 was a very difficult year. A lot of people were either lost. I had an offer that was rescinded, which kind of gave me an opportunity to kind of revisit what it is that I wanted to be doing. And I decided that I wasn't going to take a job. I was going to wait and find the right job. So I just wanted to let you know, I graduated in May of 2008, and I did not start working until March of 2009. But I was okay with that. There were definitely some moments of frustration. I think I called Professor Brand and sent a few panicked emails, but it was worth the wait. I ended up working for 6.5 years with the U.S. Department of Commerce, Office of General Counsel Commercial Law Development Program. What CODP does is provide technical assistance in the commercial law realm to developing and transitional countries all over the world. Although most of our work right now is centered in the Middle East, Sub-Saharan Africa, North Africa, Europe, Eurasia, and Central Asia. I was brought on to actually manage the Eastern European and Eurasian portfolio. Basically what I would do is meet with my international stakeholders, policymakers, listen to them, have them tell me what it is that they're struggling with, again, in the realm of commercial law. I would also be very much in tune with what U.S. strategic foreign policy initiatives were for those particular countries, and then it was completely within my discretion to come up with the type of assistance the Commerce Department could provide these countries. And those took any number of formats, whether there were trainings and workshops, consultations, providing advisors, commenting on legislation. Again, I mean, it was a wide variety of areas of law that I dealt with. I had to become a generalist in many different areas, and I had to train myself on how to actually implement successful and effective development programs. It was an amazing job. I think I parlayed that in 6.5 years into developing a lot of expertise in the commercial legal reform areas of those particular countries, so much so that definitely towards the latter part of my time at Commerce, I was often asked to, on behalf of state embassies, speak on behalf of the U.S. government about rule of law issues and commercial legal issues for those countries. Often when there were high-level trade dialogues between, can give an example, U.S. and Georgia, I offered the U.S. government response whenever there were commercial legal issues that were discussed. So I definitely parlayed that development job into much more of a legal job and built on my expertise, so much so that, there weren't that many people in the U.S. government that could provide that information and provide that level of expertise over a long period of time. So I left Commerce, and actually it's been a month officially that I transferred to the Department of Justice Commercial Litigation Branch, and I am now in the Office of Foreign Litigation. OFL represents the U.S. government anytime the U.S. government is a party or has an interest in a proceeding abroad in a civil or commercial matter, which you can imagine is quite a bit, so we're quite busy. And I specifically manage our Office of International Judicial Assistance. My office is the central authority for the Hague Evidence Convention and the Hague Service Convention, so I administer those conventions in the United States. So all requests that come in for service or evidence from any judiciary and anywhere in the world for anything in the U.S. go through my office. And I'm going to be doing quite a bit of new things with that office and developing it and growing it, because I've never had anyone managing that office before. So I'm the first attorney that they've brought on exclusively to manage the work of OIJA. So again, that being said, it's quite interesting, some of the work that I've done in my short time out of law school. I just wanted to actually take now a few minutes and give you a little bit of advice from where I've learned, both in terms of what I felt like I did to get myself to where I am now. And also because I've done quite a bit of hiring, both in terms of law clerks, interns, and full-time employees while in the government. And these are the kinds of things that I've picked up over the last couple of years. One of the things I can tell you is from the moment that I came to law school and I expressed an interest in international law, I allowed that interest to take me to various places. I remain steadfast in my passion for it, and I think because of that, my resume at the end of law school demonstrated that. Anyone could have looked at my resume and said, she is interested in doing international legal work of some kind, whether it was jurist, whether it was working in Kosovo for one of my summers, applying and receiving a FLAS and studying Serbian, doing the Vismut, which all of you should be doing, graduating with an international comparative law certificate. I mean, I can go on and on. So I didn't have to tell people they could look at my resume before I even came in the door and know that my self-described interest was proven by what I was doing in law school. The other thing that I would say are languages. That's something we didn't talk about. We had like a little group this morning. Things like English for Lawyers is a fantastic program here, but not just the FLAS. I mean, not everybody's fortunate. The FLAS is a scholarship you get that allows you to study a foreign language while in law school. You can do it on your own. I can tell you at CODP at Commerce, we actually require every single one of our attorneys to speak a foreign language. Having 2-3 languages is gonna open up so many doors for you. So even if you don't have, you're kind of starting from scratch, just keep that in mind. If you have the opportunity to study a foreign language, if you find yourself thinking, what can I be doing that's a little bit extra, that's gonna push me a little bit further, down from the pack, thousands of resumes that people always see, languages are key. Languages have really helped me kind of propel forward. And the other thing I want to talk about is public service. I, again, came out of law school and started in public service, and I probably will continue to do that. I see myself as developing a long career within the U.S. government. Something that you may not realize is the amazing and unique opportunities there are within the U.S. government. I hope just the ones I've mentioned to you very briefly, which I'm happy to talk about individually in more detail, can show you kind of the neat areas and the neat kind of work that the U.S. government is doing. There's a lot of pure content substance-based international work. We talked about commercialization, tech transfer work, for example, that USPTO does, but they have an entire section that does that and trains people abroad. Some of the other ones I thought about, energy, treasury, they all have a really good international departments, both doing content-based work, but also providing technical assistance. I worked with treasury quite a bit. CBP, Customs Border Protection, they also have it. But things like Department of Commerce, Department of State, Justice, USTR, the U.S. Office of the Trade Representative, everything they do is based in some fashion in international work. Whether you're representing the U.S. government abroad, or you're dealing with how the U.S. is being impacted by certain policies and legislation and laws and developments that are going abroad. So what I wanted to tell you is to keep an open mind about the U.S. government. There are a lot of great opportunities. If you're interested in public service, there's a lot of benefits to joining the U.S. government early in your career. That being said, one of the things that I've seen too is a lot of people start out in the private sector and move into the government, and they assume very high-level positions. So you don't have to start out there. Just keep that in mind. That is something you can transfer into later on. The other thing about the U.S. government being now on the hiring side is that it's very difficult. USA Jobs is awful. I have amazing people I know that apply and I never see. I repost and repost and repost, and I'm not getting those resumes of the people that I know are applying. So unfortunately, I'm going to tell you that it is a lot about getting to know people, networking, meeting people, doing informational interviews. I know there's so many alumni. Professor Brand is the go-to source of people you can meet with that can tell you about those neat opportunities. as one of many alumni, we try and do our part to bringing people on for internships. Also, another way to kind of get your foot in the door, not always ideal, there's pros and cons to it, is being a contractor as well. There's a lot of contractor positions in the U.S. government, and it's an easier way to start. It's not an easier way to develop your civil service career. But again, it's a possibility if some of you know, to at least start somewhere, and hopefully it'll lead somewhere else. So again, I encourage you to keep public service in mind and to really explore what opportunities there are. I guarantee you there's very interesting work that you can be doing based on your substantive interests, and again, based on your interest in doing something international, whether you're working in a foreign country or you want to represent the U.S. government. And again, I'm happy to provide more information on where you can start, how you can start, maybe some tips for usajobs.gov that I've discovered, and certainly happy to talk more about my experience. Thank you.
Good morning. My name is Wes Rist. I am currently the Director of Education and Research at the American Society of International Law. I was, prior to that, the Assistant Director here at CILE, so I'm very familiar with working with the students at Pitt on accomplishing some of their international career goals. I would actually put money down that I'm the only person up here that never actually took a course from Professor Brand. In fact, I graduated, and I'm fairly certain he had no clue who I was, because the person who was Austin at the time when I applied for the job had to explain who I was to Professor Brand when I applied for the job. That's probably not the ideal way to get the most out of your international experience at Pitt. The reason that was the case in my situation was I spent my second year of law school overseas doing an LLM degree. So I just scarpered off and was like, this is, I'm going to go do this international stuff. This is interesting. The reality was I actually didn't come to law school to do international law. I didn't know I was going to go to law school until like a year before I decided to apply. I was going to be a doctor. That's what I was going to do. My mom was a nurse. I loved the hospital, hung out there as much as I possibly could. The alternative was at the garage at my dad's mechanic shop, and I was like, no, that's no good. I'm not good with machines. So the medical side was what I was going to do. In college, I worked at a hospital, and I loved it. It was wonderful, and I saw interns and residents kill people because they had been awake for 48 hours, and that was the environment of testing new surgeons, and how are you going to know that you can... I was like, I don't want that kind of pressure, so I'm going to find a low-pressure job. Lawyer sounds good, right? The reality was I went to visit a friend, and we had to wait for her to get done with her law school class. She was the first person I had ever met that had gone to law school. I'd never known a lawyer before. And we sat in on her class, and it was constitutional law dealing with criminal procedure issues, and I was hooked. I was like, this is fascinating. Why did no one tell me this existed before? This is what I'm doing. So I went to law school knowing I was going to be a criminal lawyer. I hadn't had a chance to do study abroad in undergrad because I worked the whole way through, so I was like, I'm going to do this international stuff. The ABA just said we can get a full year of credit for studying abroad. I'm going to study abroad and do a criminal justice program, LLM. This will be great. Got over there to do my criminal justice LLM program. 30 out of the 35 of us that had signed up for that program were actually Pakistani peacekeepers who got called up to go do peacekeeping in Pakistan, so the university was like, you can't do the criminal justice program. We're not running it for 5 people. We're sorry. And I was like, I have no idea. What am I I've already paid everything. I'm here. I can't, classes were started 2 weeks ago back in the States. What am I supposed to do? And international human rights law actually had international criminal law and European crime courses. And I was like, well, at least I can get a little bit of criminal experience. The year won't be a waste. I'll do this. And a year later, I was done, and I was like, I'm doing international human rights law. What's this criminal stuff? Who cares about that? This is really important. So I came back, took all of the international courses that I possibly could, took seminars that were great, got really good experience, still worked, got good domestic experience. Both, I think, Max and Chuck mentioned, the domestic experience is important. I completely agree. I worked in the criminal appellate practicum that Pitt has that's wonderful with the public defender's office. I did appellate work for a year with them. Terrible stuff. I would never voluntarily do that job, but it's so vital that we have people who can, and you learn so much about what it's actually like to do that kind of work through the appellates and the practicums. Would strongly encourage those kinds of practical skills building elements. Those are really important things as you move on. After I graduated, I had a couple different career paths I was interested in, but I settled on going back to the UK. I had been invited back to work on my doctorate and to teach. So I headed back, and I was teaching classes, and I was writing, and I was presenting papers, and I hated it all. I was like, I'm not actually doing things. I need to be doing things. Writing is not doing things. Ron's like, what are you talking about? But Ron is like the most active law professor you will ever meet. He's the example of what law professors should be in terms of engaging with international law. So I came looking for careers that I could do, things that I could combine the skills that I had, which weren't what I had expected to do. I took the PhD gig because I was going to do international human rights law, and a PhD from Europe was an automatic expert tag. You know, I could be, even though I was young, I could be an expert because I had a PhD, and so I could get into a UN organization or an international organization of some kind, or even a regional one. But that skill set wasn't fully developed. I wasn't going to finish my PhD. I had no interest in getting that doctor tag. Props to Viosa for actually doing that. That's amazing. But it wasn't for me. And again, this goes to the be flexible and be willing to move around, because eventually I found the job offer back at Pitt, applied for that, was able to teach as part of that, did a lot of career advising, supervised the LLM students, developed significant program and project management skills, developed budget management skills, developed supervisory skills, things that you don't get in regular law school classes that are essential, absolutely crucial for applying for professional jobs where they expect you to not just actually be a lawyer, but also do other things. I know Katerina and I have talked about this, you know, the management skills that goes into being a lawyer on some of these things where you're actually running a project, and you have to do more than just advise about the commercial viability of a piece of foreign legislation. You actually have to figure out, how am I going to staff the office while I'm away advising on this? How am I going to figure out my budget? Can I take an intern? Who's going to supervise the intern? Who's got the time to manage that kind of stuff? Those are skills that are incredibly important. You actually have the capacity to build some of those skills right now while you're a student by doing student government or student organization work. So you can actually engage in some of that even now and be building that kind of stuff. Eventually got to the point where I either needed to transfer over to being a full-time faculty member and kind of going the academic route, or find something else because Ron wasn't retiring fast enough and he wouldn't let me take over the center. So I had to do something else. And Ron was very supportive of that process after I decided to go along that route, and got the job at ASIL, where I am in more of a support capacity for international lawyers. So I don't practice international law in the way that Kat or Viosa or any of these others do on a day-to-day basis, although I engage with a lot of these issues. But I create training and educational programs for everyone from high school students to sitting International Court of Justice judges on very, very general topics. You know, what is international law and why should I care about it and should America be involved, to what's the most recent current event topic. You know, South China Sea, China's building artificial islands, how is that going to impact the Convention on the Law of the Sea and sovereignty issues and all of those kinds of things. So there's a wide variety of things that I do there. A lot of what I do also is actually built around professional development for students and new professionals. So that's part of my job at ASIL. I'm more than happy to talk with folks about that. I actually came up in the spring and gave a talk that Pitt recorded that you can find on Pitt's YouTube site. That's a very 90-minute detailed kind of how you can build your resume and professional development opportunities. But I'll leave it there because we're short on time. So ask any questions that you want afterwards, and pleasure to talk with you all.
Suba Wanakson, Maga Egu Lizzie. It's about all I've learned in 3 days of Somali, so forgive me for not sharing any more on that. I'm Lizzie Shackelford. I am currently a Foreign Service Officer, as Professor Brand said. It's hard to believe that 10 years ago, I was returning from my summer in Sierra Leone, working on a defense team at the Special Court for Sierra Leone. Turns out, a lot of demand for people who want to prosecute war criminals, but defense of alleged war criminals, nobody's really signing up for that. So I highly recommend that if you're having trouble finding activities to do with your summers. I returned here, began my third year, and really was not sure at all what I was going to be doing when I got out. I was a real lawyer once upon a time. Turns out that was just the first year that I was out. I was at Covington & Burling doing international trade and litigation as a little first-year grunt. But that was some really phenomenal experience and training that I just really didn't have on the horizon. I wasn't expecting to be doing. Once I took that job on, I kind of expected I'd be doing that for a while, but after approximately a year and a week, which really, given the hours I was billing, was probably more like 3. But after that, I left to go to Booz Allen to do international development work, courtesy of this guy dragging me over there, convincing me that it was going to be a lot more fun, which it was. There I was actually a legal expert and project manager. After only 1 year, 3 years billable, I was an international law expert. That's just kind of to show you, opportunities pop up, as everybody said. Take advantage of what comes your way. Always keep your eyes open and always let people know what you're interested in, because my first job came based on a recommendation from a professor here. I will not share his name lest everybody start knocking on his door as well. My second job came from another Pitt Law faculty member. My third job came based on a lot of experience and exposure that I had to foreign service officers overseas while I was working in my second job. So I didn't have a career path when I started out. I knew, as many people do, I went to law school wanting to do international law, and it followed a lot of different directions. 9 years of being a lawyer or lawyer-type object. Later, I've worked in about 30 countries. I've done a wide variety of things. I am a master of nothing in particular, but basically just sounding as though I know what I'm talking about most of the time. Every opportunity that I had after law school basically came as a result of both hard work, a lot of networking, and the really awesome experiences that I had as a student here. My first summer, like many other folks, I went to Kosovo. I worked for the American Bar Association's Central European and Eurasian Law Initiative. That's what it is now. I think it was just the ROLI program. Is it ROLI now again? Okay, it's gone back and forth. CILE is dead. That's really sad, guys. The rule of law initiative. Okay, whatever it is now. It was fabulous. It was several months of working in Kosovo on developing, basically just looking into the damage to the legal profession and the judicial program there after years of war and limited recovery, and basically putting together some studies and also working with the law school on developing some interesting practical curriculums. That was my first summer. My second summer, I defended an alleged war criminal. He was a lovely guy. But those two opportunities, while at the same time different professors were pushing me to take jobs at law firms, at some really great law firms, I said, I'm going to do what I'm excited about, because you don't get this opportunity necessarily as you move forward. You do actually have to start paying more bills and having real jobs. So I took those opportunities with some support, with a lot of support from Pitt, a lot of support, of course, from Professor Brand, as we all like to say. But those were what really stood out when I went on for my first interview at Covington & Burling, which is a top law firm in Washington, D.C. They had seen dozens and dozens and dozens of people who got through the resume pile and got in front of them and were talking about their experiences clerking or working for law firms. And obviously, the vast majority of people that they hired did do that. But I spent most of my time talking about having malaria and typhoid in Sierra Leone and traveling around Eastern Europe and that type of thing. And they saw that as somebody who was really willing to do something different, to do a kind of more non-traditional path. And that still got me a very traditional law job. So I say that because, my kind of points of advice are, first of all, I just got a few here written down. One is, you guys are at Pitt. This is a wonderful school. It's a great law school, and the international program is amazing, but we all know it's not top tier. So you're competing with everybody who's in these more well-known law schools and international law programs out there, so you need to do things that you're going to stand out with. I think that the things that I did in the summer really made me stand out, and I threw myself into them and worked very hard, so not only did those stand out on my resume, but the people that I worked with in all these different areas really remembered me, exactly as Vyosa was saying. I mean, everybody that I worked with, no matter how small and minor the task was, I photocopied like a monster, like those things like stapled, yeah. And then you get these different opportunities along the way, but you've done everything with a great level of detail and focus and enthusiasm, and that's how you get those other opportunities. I really encourage everybody here to take advantage of what Pitt has to offer that is unique and different from a lot of these other big name schools. First and foremost is access to some incredible professors. If you were at some of these other big name schools, you're not going to get the kind of access that these guys let us have, and you need to take advantage of it. Sorry, Professor Brand, but lots of time with students. I mean, he'll never turn you down. But it's incredible because they're not only great people to help you shape the direction of your careers, but they're incredible mentors. They're extremely smart, and they have some incredible international law experience themselves, which they continue to do as they teach as well. Be creative and open-minded when you're thinking about different jobs to do. As several people have already said this, I'm now in the Foreign Service. Am I a real lawyer? Well, I'm still barred, which is good. But people, the government's full of lawyers, some of whom have a lot of actual practical legal practice experience, some of whom don't. But I never would have expected how many different ways my legal education and legal background would help me as a Foreign Service officer. Anything from trying to decipher criminal law code in South Sudan in order to try and help Americans get out of trouble, which we do a lot of that, by the way. Whether it's trying to help us look into policy concerns over whether or not there are international human rights violations by other countries on the policy level. That's been incredibly important. I've been able to bring something to bear that a lot of the other diplomats have not been able to do because they don't have that type of background and experience. I would also say, very much as Katerina was saying, the US government is absolutely full of all sorts of different international law opportunities that people don't necessarily expect, whether it requires a law degree, a legal background, or if it's just something that's very helpful. Work on ways to find out how you can offer, through your resume, but also through the actual skills that you're bringing, skills that other people coming out of master's programs in different places aren't going to be able to bring to bear, and be really creative when you're looking at that. Not only when you're looking out at different opportunities, but when opportunities kind of fall in your lap, which they do, if you are putting it out there with all of the people who are doing this really interesting work. If you're putting out there and you're showing and demonstrating through everything that you did while you were in law school and everything that you've done since, that you are really interested in these jobs and that you're a go-getter and that you're going to work really hard, people do, opportunities come up. Now that said, my other bit of information down here is go get it. Don't expect that somebody's going to come to knocking on your door and say, hey, I heard through the grapevine that you're really interested in this type of thing. Here's this great, wonderful, well-paying job that's where you can do exactly what you want. That does happen, but it only happens if you've done the groundwork before, right? It only happens if you've really been networking, building your resume, publish. Do things like publishing. A couple of people have referenced that as well. Very easy to do. You guys are all writing papers right now in law school, so I highly encourage you to take advantage of that and actually leverage it into real publications, work on jurist and things like that, because writing is important pretty much across the board on any of these jobs, whether you are writing briefs at a law firm or writing proposals if you're doing international development work, writing guidance for if you're doing international advisory work. That's a lot of what I did in my second job. And make sure that you are demonstrating that enthusiasm, because you want to be the kind of person where if a job pops up somewhere, you actually come to mind. Somebody's like, who would be really good for this job? And that's one of the ways that you can get the opportunities that not everybody else gets. The other thing, the last bit of advice I will say, because I know we want to give people opportunity for questions, is to do what you love. You have to do grunt work. All jobs have it. But if you aren't in a job that overall you really enjoy, it shows. Now you've got to keep in mind, you do have to go out there and do the low-level stuff to work your way up to the higher levels. But if you're not happy in the place where you are, talking about an extended period of time, not just, wow, this project or this particular boss kind of happens to suck. We all have to go through that. But if you don't really enjoy what you're doing, it will show, and nobody will want to work with you. It will show, and nobody will want to hire you for new things. So while you do need to be strategic in terms of building the skill set to get to the job that you really want at the end of the day, don't waste several years doing something that you fundamentally don't like because you feel like you have to do it in order to get to the place you want to be 10 years from now. Find ways to enjoy it, find ways to realize that this is something that you're going to get a lot out of, or find a new job. I'm not sure everybody would always agree with that, but frankly, right now, I'm terrible at studying languages. I'm really bad at languages. Highly, highly recommend getting languages I'm bad at them. I did the FLAS for Serbian. Can I speak a word of Serbian now? Probably not. But that was a great scholarship, by the way. I had to learn Polish for my first job. Thank God the US taxpayers pay for us to do full-time language study at the Department of State, because otherwise I would never have any of it whatsoever. And now I'm doing full-time Somali. I will be going out to the US mission to Somalia, traveling in and out of Mogadishu pretty regularly and other parts of the country. I'm thoroughly excited about that gig. I am not excited about 5 hours of language class and 4 hours of homework every day. But that said, this is something that I'm going to find a way to make it fun and to enjoy it, to appreciate the fact that I have this type of opportunity, because overall, the job that I'm in, I love. It's fascinating. Somalia has elections next year. I want to be there. I want to be advising the US government on how we're going to work with the Somali government moving forward. So anyway, those are my little bits of advice. Take them or leave them as you will. But I will say I have not followed the same career and the same job for many, many years like some people here. I think that's great if you find it. I think I found a job that I'm quite happy with because I get to stay in the same job, yet change it every year or two. So find what's going to work for you and just really be enthusiastic about it. All right, that's it.
Thanks, everybody. I'm really happy I get the opportunity to go last year. And I've been sitting here listening to everybody speak and thinking, wow, that's me. That's me too. That's me too. What I'm really struck by is, I'm feeling kind of, I've known these people, or a lot of these people I've known for a really long time. And I'm feeling a little bit nostalgic about the trajectory that we've followed that puts us right back up on this stage. I remember, although Max won't, I remember being in law school and having a practice round for the Viz competition that he arbitrated for. I remember when Vjosa was 19. I remember that summer in Kosovo with Katarina. I remember Lizzie's typhoid malaria thing pretty well. And what I really note is the serendipity that's involved in all of this, and I've been thinking about that a lot lately, particularly with the career path that I've chosen. And I think I'm also happy that I've bookended with Chuck here, that Chuck went first and I'm going to go last because I think there's some interesting interactions here. But I want to read you a quote first. One of my favorite photographers is Henri Cartier-Bresson, and he was a great, really sort of a spontaneous portrait photographer. He went all over the world and took these wonderful pictures of people. And he had such a wonderful way of capturing not only his subject, but the rapport that he had developed between himself and his subject. And so the surrealist poet André Breton once wrote of Cartier-Bresson's style of making and then capturing a relationship as this, and I'm quoting here, "Actually, it's quite true that he's not waiting for anyone since he's not made an appointment. But the very fact that he's adopting this ultra-receptive posture means that by this he wants to help chance along. How should I say, put himself in a state of grace with chance, so that something might happen, so that someone might drop in." And it's this state of grace with chance that I think has driven my career, and in some ways, everybody else is up here. Nobody really expected to be where they are. I started out. I didn't come from. I envy people like Max, who had the opportunity to come from a family that traveled a lot. I grew up here in Pittsburgh, and I always wanted to travel. I just didn't really know how. And so as Marco Gardini reminded me this morning, after grad school, I wanted to be a journalist. I'd studied journalism, so I just I popped off to India, and because that's, as Marco said, I'd said that's what the news was. And I was not a great journalist. I enjoyed it, but I wanted something more. And so in any case, to make the long story very short, I went into law school knowing that I wanted something broad, something big, and something international. And over time, I got that, and I had the opportunity, thanks to Ron Brand, I had the wonderful opportunity to work with the State Department programming that Pitt Law was awarded working with schools in Ukraine and Serbia and Kosovo. And so I had a great experience working with that. About 10 years ago, I left to go to a company called Booz Allen Hamilton with the great opportunity to go to Ethiopia, first to do something that I'll get a reaction out of Lizzie when I say this, first to do something called BizClear, and then later to be the project director, what we call in the development industry, the chief of party, on a WTO accession project for Ethiopia. Ethiopia has been in the endless pursuit of WTO accession. And I was there to help the Ministry of Trade and Industry prepare for its WTO accession. And so I helped analyze trade laws. I helped draft their papers, their submissions to the WTO Working Party on areas as broad as intellectual property, trade and services of tourism services, all sorts of things across a broad spectrum. I did that for about 3 years. Then went to Kosovo again and worked on a project there for about 3 years working in the business enabling environment component of a big private sector development project there that was also run by Booz Allen Hamilton. I left Booz Allen almost 5 years ago and joined a company called Nathan Associates, which is actually a very old economics firm in Washington, D.C. It's actually now the oldest development firm in the business. And we work mostly on U.S. government contracts, U.S. aid primarily, some others as well, occasionally contracts with other donors, the World Bank. We have a London office, we have an India office, and we work on UK funding, some direct-to-government funding in India. We work on Asian Development Bank sorts of programming. And my job is to run one of the practices. I run the legal and regulatory practice within the firm of Nathan Associates. As I said, Nathan Associates is an economics firm. It does economic analysis. It does fiscal policy. We do a lot of trade analysis. Our core functionality is the actual numbers crunching that economists do. But then economists, as we've talked about outside this venue a couple of times this morning, economists are very deeply involved in the development landscape and economic growth programming around the world. I'm lucky enough to remain working on the legal and regulatory side. So I have been working lately mostly in Southeast Asia. I'm working on right now working on a new mobile payments law for Myanmar, which is really exciting because it gives us the opportunity to work both with the government structures that are putting the law into place, but also the private sector, the ICT, the Information Communications Technology sector, and helping them develop an understanding of the law so that they can start building software programming that can rely on the new mobile payments law. As I said before, I'm kind of happy that I bookended with Chuck because Chuck mentioned his interest in his work in investment treaty arbitration. I like to think that one of the reasons that we have an incredible growth in investment treaty arbitration is because, of course, we have a big growth in investment in the first place. Investor-state relationships have grown dramatically over the past several years. And one of the reasons for that is because I believe the development community has been fairly successful. I don't remember the statistics. I looked them up recently, but a significant percentage of the investor-state arbitrations over the past 5 years have been with developing countries. And it is a pretty astounding figure. And the dollar figures that are involved are like astronomical. I think they still humble Chuck and I. But this is something that we work with pretty closely, and I work with both Laos and Myanmar on new arbitration laws and their understanding of arbitration and their ability to understand their obligations under something called the New York Convention, which is why one of the reasons we have arbitration in the first place, because these awards that are rendered become enforceable, recognizable and enforceable in the countries in which they, in which the losing party resides. And I think that this is all really exciting, and I'm so happy lately to be working with Chuck on some of this stuff, and bringing all of this full circle, and having great opportunities to meet up with my colleagues. And so let me just come back to that one more time, the importance of listening, first of all, to everything that you've learned here, and you've heard from these people, because I think it's all so true. But also, again, just put yourself in that state of grace with chance, and learn from it, and prepare yourself for whatever comes down the road, because none of us up here expected what came to us. Thank you.
I'd like some of those jobs. We do have a little bit of time for some questions. Are there questions anybody would like to ask any of the panelists here? Nobody wants a job. Okay.
You always have to call on people.
Yeah.
I know we were talking about this beforehand, Jennifer having brought it up. How important is continuing your education throughout your career, and where you want to get in your career path?
Yeah, just so we have it on record, how important is continuing education throughout your career?
So yesterday I just launched yesterday I just launched ASIL's new on-demand CLE platform. So you can now actually go onto our catalog and watch international CLEs and not have to take family law when actually what you care about is international law for CLE courses. I will say there is it depends on the field you're in. The private practice fields, they have wonderful course development inside. The big firms now make their own CLEs. They're all CLE accredited providers. They create their own content. I know Jones Day does, Arnold Porter, all the big places do. So they actually don't need it as much, although we do tend to provide unique perspectives, because what happens is it's all the internal folks at that law firm creating their own courses. The outside of that, it's a huge issue because the content is tough to come by on current events. So where I work, we actually will put together a CLE about South China Sea right as that's happening, about current issues as they're coming out, bringing in experts to talk about those fields. So it can be very helpful in just keeping up on the current issues.
I would say that it's indispensable, especially if you're interested in the area of international law, because international law changes every day depending on how international affairs impact it and how countries around the world are changing. So basically you're going to have to read at least on a weekly basis on what's happening and educate yourself, even if it's not related to a degree. In my case, it also related to a degree because I continued with my doctoral studies for another 4 or 5 years and managed to finish, early this year. But it was very important to understand, as I said when I was talking, the history of each and every country. And I'm not talking about the past history, mostly recent history. If you want to understand your interlocutor, and you will need it, if you're doing international work, you need to definitely educate yourself continually. But if you're doing it for a degree, you have to choose an area that you love, especially if you're doing a PhD or SJD, as they call it here in Pittsburgh. You need to choose something that you love, because dealing with the same topic for 5 years, it can get boring sometimes. So choose something that is really interesting to you and really challenging, and something that has not been done before, I would say, so that you can give your contribution for the science as well.
And this is my 2 cents. This is something I think that is unique about choosing to go into an international practice of law, you're constantly going to be dealing with new situations, new countries, new industries. I mean, my clients are mining, they're oil and gas, they're aviation, they're manufacturing or retail. You're constantly needing to learn new countries, new laws, and new industries. And the best piece of advice I can give you as you transition from a domestic lawyer to a global lawyer is this. As a domestic lawyer, you're hired by a client to provide you advice on what the law is. As global lawyers, what we really are is aggregators of the law. And then we have, and I think Max said this, we have to somehow aggregate that for a client, and that calls for constant education on your client's business, industry, and the various laws they're dealing with. You don't want to be hired and to advise on a transaction between a Canadian company in Africa with funding from Hong Kong, and then show up and say, yeah, my Asia guy says this, my Africa guy says this, U.S. law says this. I don't know. It's going to be a tough week for you. You know? You're not going to be their lawyer for too long. So continuing education, and that doesn't necessarily come from formal programs, although it does. It comes from you know, learning every day. And I think that's what I love about the global practice of law as opposed to domestic practice of law, is it enables you to learn something new every day, and you have to.
And I'll add my 2 cents as well, drawing on what Vio said and what Lizzie said earlier. Being a lifelong learner is essential. I mean, whether you're doing it formally or whether you're doing it informally. I mean, one of the worst things when you're interviewing someone or when you're evaluating someone who is in your organization, one of the worst things you can say about them is, you know, I just don't think they have a lot of intellectual curiosity. I just don't think they're all that interested. They're good technicians, but in order to go to the next level, you have to, and I think everybody has talked about the passion you have to have about what it is you do, and I think that's key. And I think a piece of that passion is simply having the drive to teach yourself something new every day. Sure.
I wanted to just say 2 things. In terms of, Lizzie and I have that in common, in terms of our U.S. government work, is we do have to become generalists. We don't get to specialize, really. In terms of your foreign assistance work and my work now, both at Commerce and at DOJ, one of the things I've done, the government's not very good about, you know, the continuing legal education part. They just ask you, you know, have you done your 2 hours every year, or whatever the requirements are. So it's really up to me. While at Commerce, you know, there were certain legal areas that I was particularly drawn to. The 2 that I can think of, I was really interested in countervailing duties. I thought that was really interesting. So I found a program on that. Investor-state arbitration, I had to do an entire program and work with the Ministry of Justice in Georgia on investor-state arbitration. Well, I felt like I needed to actually know what that was. So again, I was the one that found those opportunities, proposed them, and of course my counsels were more than happy to have me attend. That actually brings me to another point. I am subscribed to a whole lot of listservs. My email every morning is explosive with things from the Wilson Center, I have the State Department. Again, in working for Commerce, because I was focused on Eastern Europe, Eurasia, I was signed for anything and everything that had to do with Eastern Europe, Eurasia that was coming out of the State Department was in my inbox every morning. There's so many. I mean, I have like 50 I can think of right now. And I read everything. That took quite a bit of time, but you could come to me on any number of countries, on any day, and I could more or less tell you what was going on. I attended a lot of talks. I went to conferences. I did all this, and I did it while, you know, having a very busy job, and previous job, one that required me to travel a lot. So again, none of those things were ever required. Those were all things that I came to do, but I think they make you much more well-informed. Yes, you're gonna have CLEs you're gonna be doing, but those are things you can be doing every day. Every morning, I would take that time to go through and read those headlines and read some of those stories. And I think all of us can suggest ways that you guys can be signing up for those things to find out about conferences and speakers. And again, networking. Meet people. You go to these things, introduce yourself to the speaker. It takes that one opportunity to meet that one person that's gonna lead you to the next opportunity in your life.
Other questions? Yes.
So everybody, as Brielle and two of us that are now looking at internships and jobs and stuff, what's one thing that whenever you are reading the same cover letter 100 times, it really pops out to you, just one thing that really makes that one person stood out, based even though everybody else has the exact same experience.
The question is, what is the one thing in a cover letter or a resume that really stands out if you're looking at a stack of applications for a position?
I'll start. I'll start, although I'm sure everybody here. I'm going to say a couple of things that I cannot believe I'm actually going to say. Proofread, spelling mistakes, typos. I can't believe I'm actually saying this. I cannot tell you, and unfortunately Pitt students as well are not perfect. It drives me crazy. The fact that I am receiving cover letters and resumes even. Cover letters, yes, you're writing them, you make a grammatical mistake here and there, but your resume you're sending out to numerous parties. Every time you're sending it out with that typo. There's no excuse, and I'm pretty bad. I mean, I literally will tell people, I'm sorry. I can't live with the fact that you've made this many mistakes on your resume and your cover letter. And I still get cover letters that are obviously were not written for me. They were not written for the Commerce Department internship, or the Department of Justice internship. I could tell obviously they were written, and you literally changed my name and my department at the very first sentence. So I still get those. Those resumes are completely put aside immediately. What I read for, and it's what I mentioned, our experiences. I'm actually not a grades person. There are people at Justice, I'm having a hard time now because they look at grades, and that kind of frustrates me. Granted, I mean, if you're failing, I'm not talking about failing, but I really don't care if you got an A or a C. I care about what you did with your education. I care about what other extracurricular activities you've done. I care about that you've proven, what I mentioned basically, back to what I said earlier, is have you proven to me that you are genuinely interested and passionate about pursuing a career in international law? I'll say this. I meet with a lot of people that do just the internships at, or summer associate positions and clerking, and just that. They've done nothing else. Haven't even taken international legal classes that CILE organizes. When I ask them, they say, well, I'm taking classes to prepare me for passing the bar. Or I'm way too busy with the course load, I don't have time to do this. Or I don't have the money to go abroad and work abroad. Those are not excuses for me. We talked a lot about sacrifice. A lot of us up here on this panel have made a tremendous amount of sacrifice to get to where we are. I named a lot of things that I did while maintaining a full course load. I'm not any smarter or any better than anyone else in this room, but I worked hard and I was committed. So again, those are not going to be excuses for me to say, well, I couldn't make it work. I couldn't do it. You can do it. You can do a few things. So those are the kinds of things I look for. And again, unfortunately, the stack is still big. After you've weeded out all those people, it's still a big stack. And then a lot for me comes with the interview. So, bringing those people in, it's really about having good communication skills, being able to interview well. I urge you to take advantage of any kind of interview, kind of mock interviews, talk to Professor Brand, talk to other professors, talk to other people you interview with, talk to friends you have that are interviewing people. I do give a lot of advice on how to interview well because I've seen quite a bit of bad interviews. And someone I thought would be really good, they come in and they just blow the interview. Something with like not maintaining eye contact, not sending a thank you letter, although almost every single intern that interviewed with me from Pitt has sent me a thank you email or a thank you card. That's very important. I remember all of those things. So again, kind of little things. I'm sure it's nothing you haven't heard before, but believe it or not, all of us see it all the time.
So I'll actually mirror a lot of what Katerina said. I actually am harsher on resumes and cover letters. If I find a typo, it goes in the bin. I mean, I don't read any further. The first typo, I'm out. I've got a stack, and I need a way to narrow it down. So the first thing is a typo. For cover letters especially, two really important things. One, your resume is your checklist. That's what I'm looking at to see, do you meet those skills that I need? Do you meet those checkbox things that I need? I don't want sentences in your resume. I don't want, and this is a point of controversy, especially in DC, mission objectives or, statement of whatever. I want 5-word maximum in your resume. I want to be able to very quickly get a sense of what skills you're bringing, what work product you've done, what your experience is. I want to get that very quick. Your cover letter is a narrative. I shouldn't see a single bullet point. I still get cover letters that are like, 2 or 3 sentences and then bullet points. Look what I did. Look at what courses I took. That's even worse. Hooray, you took a course. I don't care. I want the answer to 2 questions in your cover letter. Why do you want this job? What is it about this job that makes you excited, that you are passionate about? it automatically resolves that whole I scratched out Department of Justice and wrote in Department of Commerce problem, which means you're going to have to spend time writing every cover letter. Every single one. It's going to take you a couple of hours to do. Prepare for that. And two, the second question you should be answering is, why do they want you? Why should I, as an employer, want you? You have to work on the skill set of being able to sell yourself as a person, and that comes in two forms. One, you have to be confident and say, I actually can back up what I'm saying I can do here. I actually do have these skills. And two, we talked a lot about all the domestic stuff that you can do that applies to international law. You should not rely on them figuring out that the domestic stuff that you've done applies to what you're talking about, or that your experiences apply to this. This is the point where you tell them, let me tell you why this internship that I did that seems completely unusual is actually entirely relevant to what you guys do. It demonstrates a couple of things. It demonstrates why your experience is important. It demonstrates that you've actually studied what this company, this organization, this government agency does, and you know what your skills are that are relevant. And it demonstrates that you actually understand their job description and you've picked up the jargon. You should be using the terms that they use in their job description in your cover letter and your resume. And I can go into far more detail on this if you want, but I talked.
Just a couple of quick things.
Yes. Let's get, yeah.
Can I add one thing?
Yes, and then we'll-
I owned a company, had 250 employees worldwide, hired a few attorneys, but I want you all to realize that your resume is, you are an attorney. It's your case for you. So not just your cover letter, but your resume, if you want that one job, your resume should be the case for you without even looking at the cover letter. Then the cover letter should only make very succinct discernments if something isn't clear in the resume. So I want to scare you all, because your experiences that you are building should speak for themselves. And they already do. You are here. Be confident in that. You do not have to have a detailed cover letter. Your cover letter should only alleviate any confusion because someone isn't familiar with the program. That way you'll make less mistakes too.
Thank you.
A couple of points here. I work for a company that's about 150, almost 200 employees with a relatively low comparative turnover. It's only about $40 million a year, maybe just a little less than Alcoa. But we get, on average, about 15 resumes a day. We get a lot of CVs. Everybody gets a lot of CVs. Our recruiting director lost his mind a couple of months ago and started redlining resumes and sending them back to the people who had sent them to us. It was a bad day for him. But a couple of things. First of all, if you're going global, you're going to be applying across a lot of different industries, a lot of different formats. Apply for the right job. If you're going to apply, if you're trying to get a development job, if you're trying to get in with one of the Beltway bandits and you want to work for one of the contractors, you need to know the language. You need to know what this is about. You need to know what you're going to be doing as a development professional, because other people, namely the international relations people who come out of Johns Hopkins and Georgetown and GW, they've been instructed in how to apply to these jobs. They already know. So you need to find out how to apply to these jobs. The other bit is just a little practical bit of advice. A lot of the organizations that you will be applying to, again, if you're going global, have these new, unfortunately, these new web-based application processes. Use words that are in the job description. You will not get past door one unless you actually regurgitate what is in the job description. And it's just one of the weird little foibles of the internet-based job application system.
Now have to get past the algorithm before we get to the person.
Exactly, right.
And that's a new part of it all. We have reached the time to close this program. Before we go, though, I want to invite everybody to come back in this room at 1 o'clock. There's been talk about access to professors, getting to know professors, getting to know what they do. Sometimes we as professors don't talk much about the kinds of things that we're doing, not just teaching in a class, but doing other things. This is your chance for the students this afternoon to find out what your professors are doing. And they're doing cutting-edge stuff that's really important internationally, and they're going to talk about it this afternoon. Come and hear that. It gives you something to talk about with the professor to make use of that access to the professor that you've been talking about. Those of you with name tags, if you'll note, if you have a little green dot on there, that means you did RSVP to Austin, and everything is free today if you registered for it. All of the programs you can come and be at, but lunch, if you have the green dot, that means you did go on and follow instructions and register for it, and we did buy a lunch for you, but we had to know how many to buy. So come on up and join us at lunch. Come back down here at 1 o'clock. But first, join me in thanking our panelists for being here this morning and sharing their time with us. We were going through showing other people where their PowerPoints was.
I see.
I didn't realize there was
Yeah, I mean, we can, but I was doing,
okay, then I should,
so I had one for the keynote.
Okay,
And we can
put that
have
up.
that in the background for anything other than,
put that up. Okay. And there's PowerPoint for this. You got a, sorry, hider, I don't know, is hider here? There is hider. Why don't you and I sit right here? To enjoy the lunch right now. I didn't get to sit at my desk and returning. Okay. Okay. And then I will, if there are questions, I will take the microphone to the audience.
Do you have to pick your wife and kids up at the airport?
You had to come.
Okay, were they yeah. Where'd they go? Cape Cod. Oh, they enjoy it? Yeah. Good. Right before school started? Or?
Good afternoon, everyone. Good afternoon. Sorry to break up the conversation, but I did want to go ahead and get started so we can get to our program. For those of you who I haven't met, my name is William Carter, and I'm the Dean of the University of Pittsburgh School of Law. And my role here is quite simple, just to introduce the program and welcome you all to this scholarly presentation as part of a series of events relating to the 20th anniversary of our Center for International Legal Education. Throughout the afternoon, we thought it would be most appropriate to commemorate the 20th anniversary of our center by doing what we do best, which is to share knowledge and information around critical global legal issues and matters of policy. You know, our Center for International Legal Education has and will continue to serve as a real focal point and a hub for these kinds of conversations, both locally, nationally, and globally. You'll have the opportunity this afternoon to hear from Mr. Jeffrey Kovar, a distinguished speaker who has played a key role in representing the United States government in a variety of sensitive and significant negotiations, most recently playing a crucial role in connection with the reopening of diplomatic relations between the United States and Cuba. Following Mr. Kovar's address, you'll have the opportunity to hear from our own distinguished Pitt Law faculty, as well as their friends and colleagues from around the globe on important issues in international law, among them cybersecurity and privacy, international criminal law, and international commercial law. I want to thank you all for coming to attend today's events, for being part of this celebration. I want to express my particular thanks to Mr. Kovar for taking the time to be with us, and to our other distinguished guest speakers for coming to share their knowledge, and thereby honoring both the law school and the center with their knowledge and their commitment to these issues that we all share. Again, I want to thank you all for attending. I look forward to today's discussions and conversation. In a moment, I will turn the program over to Professor Brand, but as those of you who were at dinner last night heard me say, I just want to repeat my thanks to Professor Brand and all of the faculty here associated with our Center for International Legal Education for making it one of our most distinguished programs, for making it a hub for our students and faculty to engage with global legal issues, and of course, for the hard work, diligence, and commitment that they have brought to our center for the last 20 years. With that, I will turn it over to Professor Brand to introduce our keynote speaker.
Thank you, Dean Carter, for that welcome. Last evening, we celebrated the first 20 years of CILE at a special dinner. This afternoon, we celebrate again, but in a set of presentations designed to address a number of issues of international and comparative law, and to emphasize the importance of legal education in making the world a better place. It's also an opportunity to do something that we don't often do in the law school, and that is to hear our colleagues talk about the things that they really are interested in and are doing. We hear about what each of us is teaching in a certain class, but this gives us a chance to come together and share that, and I really welcome that opportunity. But we begin with our keynote speaker, Jeffrey Kovar. It's both a personal pleasure for me and a professional honor to introduce Jeff Kovar. We began working together more than a decade ago when Jeff became Assistant Legal Advisor for Private International Law at the U.S. Department of State. That made him, among other things, the head of the U.S. delegation for the negotiation of what became the 2005 Convention on Choice of Court Agreements. And I do think it's fair to say that without Jeff and his leadership both on the U.S. delegation and in the entire negotiations at the Hague Conference, that convention probably would not have been successfully completed as it was. Jeff has led other negotiations as well, including those resulting in the 2006 amendments to the UNCITRAL Model Law on International Commercial Arbitration, and I will note that for the students in my arbitration class because we've been looking at that one, and the 2002 UNCITRAL Model Law on International Commercial Conciliation. He also was leader in the 1992 Real Declaration on Environment and Development. But he is currently the Assistant Legal Advisor for Western Hemisphere Affairs, a position that has placed him at the center of recent developments in relationships between the United States and Cuba, a matter about which he will share some of his thoughts today. But most importantly, Jeff has Pittsburgh roots. His father and his uncle, right, are both alumni, alums of the University of Pittsburgh. So please join me in welcoming Jeff back to his roots here in Pittsburgh.
Thanks very much, Ron. Dean Carter, thank you, and all your colleagues for inviting me to participate in this conference celebrating the 20th anniversary of the Center for International Legal Education. As Ron said, he and I worked very closely for probably about 7 years on what ultimately became the Hague Choice of Court Convention, and I have to say that it was Ron's skill and patience as a lawyer and a negotiator which were really the steadying foundation of our delegation through all those negotiations. It's truly an honor to be here. As Ron said, I am part of the great Pittsburgh diaspora, although I'm not a graduate of Pitt myself, and so it fills me with a lot of family and professional pride to be able to help you reflect on the tremendous accomplishments worldwide of the faculty and students and alumni of Pitt through the center. You know, one of the things I like so much about the Center for International Legal Education is the way it has integrated the practice of international law with the study of international law. Practice can sometimes be a dirty word in certain academic circles, but it's not for us. As common law lawyers, we should all realize that we are the living embodiment of law that has developed organically, shaped by practice, informed by reason and debate, and by the study of precedent. And as such, you know, we as common law lawyers can truly appreciate that we are practicing international law at a time when it's still evolving through a fairly early stage of its development. We are lucky enough to be able to see how the consequences of our actions on the world stage are contributing to that evolution of international law. I mean, just look at some of the important areas in which international law is developing that are topics for this afternoon's conference. They would scarcely have been on anybody's radar in the United States when I was in law school in the early 1980s. Cybersecurity and privacy, understanding Islamic law in the current international legal environment, litigating international human rights cases and corporate responsibility, jurisdiction and the recognition of foreign judgments. As someone myself who has devoted now almost 30 years to the practice of international law in public service, it's really exciting for me to see the dynamic work that all of you are doing here at Pitt. And I'm grateful for the contributions that many of your faculty and alumni have made to our work at the State Department and in the U.S. government. So let me tell you a little bit about what we're doing on Cuba. It's an almost bottomless inbox of legal issues that we have related to Cuba. I'll try to go through some of the issues that we've recently worked through, highlight some areas that we'll be working on in the near term, and then try to leave you with a sense of where future legal developments might evolve and how you could be part of them. First, let's recall that President Obama announced last December 17th that it was time to begin a new relationship with Cuba, since the one that had been in place for almost 60 years had, in his words, failed to empower Cubans to build an open and democratic society. Instead, that policy had only served to isolate the United States and, as President Obama said, impair the use of the full range of tools available to promote positive change in Cuba. The president went on to note that we can't keep doing the same thing and expect a different result, and that it doesn't serve anyone's interest to try to push Cuba toward collapse. So he said, through experience, we've learned that it is better to encourage and support reform than to impose policies that will render a country a failed state. We should not allow U.S. sanctions to add to the burden of Cuban citizens whom we seek to help. In his announcement, the president called on the Secretary of State to begin discussions with Cuba to reestablish diplomatic relations and to reopen embassies and conduct a review of Cuba's designation as a state sponsor of terrorism. He also announced that the administration would be making relevant regulatory changes to increase people-to-people contact between Americans and Cubans, to support civil society in Cuba, and to enhance the free flow of information to, from, and among the Cuban people. The goal was to facilitate more authorized travel to Cuba, including by providing general licenses in the 12 existing categories of travel permitted by law. In the past, you had to apply each time for a specific license. Now, in one of these 12 categories, there is now in the regulations a general license, so you don't have to get a license in advance. Expanding the products and services authorized for sale and export to Cuba, such as tools and equipment for use by private sector Cuban entrepreneurs. Allowing Americans to bring back up to $400 in Cuban goods when we travel to Cuba, including $100 in cigars and rum. Permitting telecommunications providers to establish the necessary mechanisms and infrastructure in Cuba to provide commercial telecommunications and internet services. Just a few weeks after that, the Departments of Treasury and Commerce issued regulations that reflected these and other changes. Then, in his State of the Union address, the president explicitly called on Congress to begin the work of ending the embargo. Over approximately the next 6 months, teams from the State Department and the Ministry of Foreign Affairs in Cuba met 4 times in Washington and in Havana to address the details of reestablishing diplomatic relations and converting our respective interest sections into embassies. Because we did have a presence in Havana and they had a presence in Washington through the Swiss embassy. We had interest sections under the auspices of the Swiss embassy. Our bilateral discussions ranged over issues from Cuba's need for banking services for its mission and its mission employees. Cuba had been without banking services for over 1 year, so they were doing all of their diplomatic activity and visa work on a cash basis. To excessive Cuban screening of people who would come to the U.S. mission in Havana for visas or other cultural and educational opportunities and meetings. To the need for U.S. diplomats to be able to travel anywhere in Cuba and not be restricted. At the same time, in Washington, we were carefully examining Cuba's designation as a state sponsor of terrorism under U.S. law, and we reviewed information about Cuba's related activities and policies. By April, Secretary of State Kerry was in a position to recommend to the President that Cuba should no longer be designated as a state sponsor of terrorism, and the President then reported to Congress that, consistent with U.S. law, the administration intended to rescind that designation. Secretary Kerry reported and the President certified that Cuba had not provided any support for international terrorism during the previous 6 months and had given us assurances that it would not do so in the future, which is the statutory standard. Congress reviewed the report and certification for 45 days and did not seek to block the rescission. So after the 45 days were up, the Secretary formally rescinded Cuba's designation. Rescinding Cuba's designation as a state sponsor of terrorism resulted in a number of legal consequences, one of the most important of which is that After a 6-month period, the special provision of the Foreign Sovereign Immunities Act that makes it possible to bring suit against a state sponsor of terrorism for certain claims will no longer apply. Then on June 30th, President Obama and President Castro exchanged letters that confirmed the reestablishment of relations and the reopening of embassies would be effective on July 20th. The two governments also exchanged letters with details about how the embassies would be operated. And on July 20th, we terminated the agreement that created the interest sections. And we notified to each government our respective staffs, now as members of our diplomatic missions. Cuba raised its flag and celebrated the reopening of its embassy in Washington on July 20th, which was the day that the embassies opened. But Secretary Kerry, you may recall, had broken his leg during the Iran negotiations. He was riding his bicycle in Geneva. And so he waited a little bit longer, and so he traveled to Havana for the ceremonial reopening of the U.S. Embassy and the raising of the American flag about a month later on August 14th. Now, all of these negotiations and regulatory changes and statutory reviews relied heavily on the legal analysis of the Office of Legal Advisor in the State Department. The bilateral discussions with Cuba were grounded in our two countries' reciprocal rights and obligations under the Vienna Convention on Diplomatic Relations and the Vienna Convention on Consular Relations. Both of our countries are parties to those conventions. The review of Cuba's designation on the state sponsor of terrorism list required not only a close reading of the statutory standard, which we've already mentioned, but also a careful examination of the open source and classified information about Cuba's actions and policies, as well as discussions with Cuba about their giving assurances of future conduct. Of course, the regulatory review and drafting and adoption of amendments to the Cuban sanctions regulations were also heavily legal exercises, and including questions of separation of powers and the limits of executive branch authority. Now that these steps are behind us, because we've reestablished relations, we've opened embassies, we must increase people-to-people contact and trade between our two countries. And the most effective way to do that is to lift the embargo entirely. The embargo has been in place since it was declared by President Kennedy and implemented in the form of regulations issued pursuant to the Trading with the Enemy Act. Subject to Treasury licenses and as specified in the regulations, the embargo prohibits almost all travel, trade, and financial transactions by U.S. persons with Cubans anywhere in the world. It's up to Congress to entirely lift the embargo, and President Obama reiterated on July 1st his call for Congress to take steps to lift the embargo that prevents Americans from traveling or doing business in Cuba. Now, short of lifting the embargo by statute, the administration can continue to use its licensing authority under the embargo regulations to facilitate greater contacts. So you may see more changes to the regulations in the future. Next, there are areas in which we must meet with Cuba to make progress on normalizing relations. In particular, there are several major issues that we need to work on with them. First, establishing a meaningful bilateral human rights dialogue, which is a cornerstone of U.S. policy toward Cuba. We've already had a preliminary meeting on this in Washington. Second, settling the claims of Americans whose property was confiscated by the Cuban government following the revolution, as well as the claims of Americans for wrongful death and other personal losses for which they've obtained judgments in U.S. court. The property claims were adjudicated by the Foreign Claims Settlement Commission of the United States many years ago in anticipation of a future claims settlement, and they were valued by the Foreign Claims Settlement Commission at approximately $1.8 billion before interest. Third, addressing law enforcement issues. As you know, these many years of isolation have resulted in a number of fugitives in each country that are wanted by the other country. And finally, engaging with Cuba on substantive discussions about installing modern telecom infrastructure and equipment to bring the Cuban people the benefits of the global internet and other telecom services. There are, of course, many other issues we're also interested in advancing with Cuba, including in areas in which we've been conducting regular discussion over the years, such as opening direct mail service between our two countries. You actually cannot send a letter directly from the United States to Cuba. It has to go through a third country right now. Restoring regularly scheduled commercial air service. Right now, only charters fly between our two countries. Migration issues, marine environment issues, emergency response, and maritime boundary. But all of this is still just the beginning. Looking down the road, it is clear that in order for Cuba to be able to develop and fully participate in the global economy, it will not only need to modernize its telecom infrastructure, but also its other physical infrastructure, including roads and railroads and ports. In addition, and this is where you come in, Cuba will need to modernize its commercial laws. It'll need to enact meaningful protections for foreign investments, establish transparent and reliable public procurement laws and procedures, enhance public participation and private investment in all these areas, and respect individual rights and freedoms. I hope that you can start to see where your role will emerge as U.S. and Cuban relations mature and deepen, and Cuba begins to open up to the possibility of transforming its government and society in ways that increase prosperity and personal freedoms. Your ability to help Cuba with this transformation will still be constrained for a while by the U.S. embargo and other legal restrictions applicable to Cuba. So look closely at the regulations to see what is possible for you to do. Ultimately, we're betting that Cuba's willingness to change will be heavily influenced by the quickly expanding people-to-people contacts between our two countries. So when you travel to Cuba and meet your counterparts at international meetings, which will become increasingly easier to do, you will need to teach them about our legal traditions and about international standards, bring them model legislation and expert commentary, and help them tailor those model laws to their evolving needs. These are all things that you know how to do well. So we can all play a role in this process of normalization, and I urge you all to do so. So thank you again for allowing me to speak today, and I'll be happy to take any questions.
We do have a few minutes. Is this working? It's green. Okay. We do have a few minutes for questions. Do we have questions?
Good afternoon. I'm Kristen Schneck. I'm Vice Chair of the Pittsburgh chapter of the American Immigration Lawyers Association. I have a question regarding enforcement/migration. Do you know what the plans are to do with the thousands and thousands of Cubans who are under orders of supervision and have final orders of removal? Will they be sent back?
We have talked with the Cubans for many years about what we view as their international obligation to take back their citizens. And that's always been part of our migration discussions, and it will be in the future. But I don't have anything specific to tell you about that, beyond that we will continue to talk with them about it.
So you laid out some very interesting opportunities for engagement, and some of those in an academic context make a lot of sense in cooperating with other law schools and things like that. But for those of us that are in the practice or development areas, what form is this engagement with Cuba going to take? Are we going to be seeing USAID contracts put out into the development community? Is this going to be a Beltway Bandit kind of approach? how are we going to focus on growing those things? Obviously, things like international communications and telecom, that's a huge industry where the industry is chomping at the bit to move forward on that as well. Is the plan to try and parlay that into industry motivation and development, or is the government going to try and kind of direct and lead that in some significant way? Do you have any sense of how that's going to be accomplished in probably decades to come now?
It's a good question. Right now, there are still quite a number of restrictions on U.S. assistance to Cuba. So probably many of the forms of assistance from the U.S. government for some of these development efforts that you've been used to using around the world will not be available for a while. So you'll have to look for other ways until we can get to a point where those restrictions will no longer apply to U.S. assistance to Cuba.
Further questions? Okay, if not, please join me in thanking Jeffrey Kovar.
Thank you.
Okay, you will see that we have a rather full agenda for the rest of the afternoon. And we want to make sure that every pair of speakers gets sufficient time, but we remind every pair of speakers that your time is limited to 30 minutes. And what we're going to do here, although we have one block of speakers from 1:30 to 3:30 and another block from 3:45 to 5:15, what we've done is ask each University of Pittsburgh faculty member whom they would like to invite to speak with them, and they have done that. And so we're going to bring the pairs up one at a time. Each of them will get 30 minutes to give their paired presentation in the order that is in the program. Now, in order to allow as much time as possible for those presentations, and if there's time for questions, what I'm going to do is forego the usual flowery introductions of all of our speakers. These are all great speakers, I guarantee that, and they're wonderful people, and they're excellent, excellent scholars. There are bios in the program. Take a look at those, but I want to give the speakers time to make their presentations. And we're going to begin with the presentation on cybersecurity and privacy in the U.S. and the EU with Professor David Thoth from the University of Pittsburgh and Professor Pierluigi Peri from University of Milan.
Perfect. Great.
All right. Thank you very much for having us, Ron. Thank you for the opportunity to speak together with Pierluigi. We're going to talk a little bit about privacy and cybersecurity, and the first thing that might jump off of your mind is, what are these two things? And as we go through this presentation, what you're going to observe is that the terms will appear to have been used interchangeably. This is not by accident. In fact, it goes to a bit of a comparative problem across the US and the EU. And our hope is that we have successfully condensed enough of a summary of at least a semester's worth of work into 20 minutes, 10 each, so that at the end of this conversation, we can show some of these comparative points, why they are particularly important to what is necessarily an international problem, and allow for you to ask us questions. I think in both of our experience giving these presentations, the questions are where the most interesting part of the presentation is. The slides and the data you can read. So with that, we will start with an overview of the structure of each and then proceed into the depth of each of the EU and the US. A brief word from the US perspective to begin with. Much of the focus is on the private sector. Why is this? Why don't we have that public law, for those of you who are familiar with the Privacy Act in the United States, governing the government type of focus in most of these discussions? Well, the answer is quite simple. It's because of this. On this device, when I purchase it and use it, other than the ordinary sales tax, virtually no money goes to the federal government because the federal government, and for that matter the state governments, have played virtually no role in the ongoing development and maintenance of what goes into this device and computers and all other types of things. The critical infrastructure we use predominantly is maintained by the private sector. Some of you might be thinking about the exception for GPS. Can talk about that at the end, but it actually plays a much smaller role than we think it does. And so the focus of much of the regulatory activity, because the private sector operates this critical infrastructure, is on the private sector. And that's what we're going to talk about from the US perspective today. One other note how sort of the public folks view this. I had an interesting conversation, the quote of which I have permission to use, with some folks at the National Security Agency when asked about this and their role, and they respond in sort of a gesticular, throwing their hands up way, we can't help. We're not allowed to. We can only defend .mil. That's the portion of the World Wide Web which refers to those military websites, because they are limited under US law from doing so. So much of the press discussion that you'll hear, what the media reports, misses the critical point that there are limitations on what the Department of Defense, the Department of State, and even the Departments of Homeland Security and Justice can do in this equation.
Thank you very much. Sorry, I know that we are in the middle of a presentation, but please let me also thank the University of Pittsburgh, the Center for International Legal Education, Professor Brand, and all the staff for organizing this wonderful conference, and happy birthday for your anniversary. Well, we can bring back all the European cybersecurity law mainly to two regulations, the Data Protection Directives and the European Convention on Cybercrime. Just for those who are not familiar with European Union law, the directive is one of the three basic types of EU legislation. We have directives, regulation, and decision. The regulation is similar to directive, but with the difference that is applicable in all European countries without the need to be transferred into national law. A directive needs to be transferred into national law. The decision only deals with a particular issue and specifically mentioned persons or organization. The European Convention on Cybercrime is not only European, but is open to other countries, for example, the United States. The United States signed this European Convention on Cybercrime in 2006, and this is probably the start of a common framework. Me and David are searching for this common framework to regulate data protection issue between Europe and the United States, at least about criminal activities in digital environments. Since we derive all the privacy regulation from directives, we have a national privacy law in every European member state, but with common principles. The aim of every directive, in fact, is to provide a common legal framework across the member states to harmonize regulation and trade between the member states. The bottom line is that the flow of personal data across the European member states is free, and the single national laws cannot stop this flow in any way. Just 2 words about a distinction that is important for European privacy scholar. The cybersecurity regulation is not only about privacy and computer crimes, but focuses on data protection that is broader than just a privacy regulation, which involves the processing of personal data, or cybercrime regulation, which involves just the regulation of computer crimes. We have other resources containing specific provisions about cybersecurity, for example, the directive about electronic signatures, or the digital single market strategy, which is a new strategy that the European Union just issued in May 2005, where the European Commission sets out 16 initiatives under 3 pillars to make the European single market fit for the digital age, mainly tearing down regulatory walls between the member states. For example, one of the first initiatives is to end the roaming charges for mobile phone communication and guarantee access to an open internet with strong net neutrality rules. In general, however, the definition what is security of data and what are the risks of security breach could be found in privacy law, and this is why we are focusing on privacy law.
As we proceed through discussing now sort of the overview of the U.S. perspective, you'll again see that there are what looks like a patchwork of regulations in different areas for which terms like privacy and cybersecurity could apply. And I encourage you as we run through this to think again about the interrelationships. We're going to come back to talking about that at the end. So there are a few major pieces of the U.S. picture. The most dominant in terms of actually impacting the industry is industry-specific regulation, and it's really healthcare and finance where most of the action is in this regard. We also have something called security breach notification laws, and when I have more time, I ask the audience to raise their hands if they've got a letter in the mail saying that someone lost their data. I imagine by now most of you have. These laws are what generate those letters. Then we have general consumer protection statutes, which federal agencies and some state agencies, but mostly the Federal Trade Commission, have interpreted to include being fair about your security practices and not being deceptive about your privacy practices. And they've used that authority to affect privacy and data security regulation in the United States at the federal level. There's also some other smaller pieces like the state data security laws requiring reasonable security and some other things, SEC disclosure regulations and a few others. I note these up there. There's a couple slides for those of you who have packets that describe what these are. We're not going to talk very much about them, both in the interest of time and because they don't actually have a lot of statistical impact on practices today. Industry-specific regulation, and we're talking now about finance and healthcare, in the United States is unique in its form. Rather than giving a laundry list of do X, Y, and Z, it identifies a series of salient areas and says the regulatory requirement is that you develop a plan, you, the company, the regulated entity, develop a plan to address these areas and follow your own plan, and your plan is reasonable. Now, this is very interesting because it's much less directive. Some scholars call it process-based standards. In a series of research that I can show you the results of at the end during the questions if you're interested, quantitatively it can be shown that this style of regulation is 4 times more effective at stopping cybersecurity breaches than the more directive do X, Y, and Z regulation. So I note that as we start to talk about these two types. First is the financial sector, and it comes out of the Gramm-Leach-Bliley Act. Some of you may have heard of this. It also has privacy and security provisions in it, which generally require organizations to engage in this process of developing plans to address their security and following their plans. And there are usually 3 areas into which the general objectives are divided: administrative risks, physical risks, and technical risks. And the important part of this is that it's not just about the technology. It's about the processes. It's about, did you lock the door to where the computers are kept? Because if you didn't, the hackers don't need any kind of fancy technology. The interesting point about the financial sector is that these regulations exist. If you talk to the chief information security officers, they will tell you that we pay attention to these regulations and we follow them. But there's virtually no enforcement activity, and not for a lack of, as I'm sure many of you have heard, incidents in the financial sector. I don't actually have an answer to why this is, because when I ask my colleagues in the Department of the Treasury, they say, we really don't know. Interesting open question. There was one enforcement action, the results of which have not yet been finalized. It didn't gain very much traction. Healthcare is quite different. Very similar structure of regulation coming out of what's called the security rule under HIPAA. Many enforcement actions have come from the Department of Health and Human Services, Office of Civil Rights. Now, of note, many of these came after enforcement authority was transferred from the Centers for Medicare and Medicaid Services to the Office of Civil Rights. Perhaps, obviously, CMS is designed to work collaboratively with people and essentially give them money for their hospital operations. OCR is an enforcement mechanism. So maybe that tells us a little bit, although interestingly, no one has studied that yet to see if it's the case. But there has been a substantial amount of enforcement activity, some of which you would have seen on the front page of the New York Times or on CNN's website. In thinking about these styles of regulation, there are two key points that I ask in these presentations people to take away. The first is that everything boils down to a business risk decision, and risk assessments are key. And why is that important? That's important because when we are thinking about cybersecurity, we can't stop everything. So this style of regulation, and what I suggest to you as to why it's more effective, aims at encouraging risk assessment, at encouraging a process by which entities think about their risk and try to do the best they can with the resources they have, efficient allocation of resources. There is still a lot of low-hanging fruit. It exists in these industries, and it exists in some of the other industries I'm going to talk about. As I mentioned, there's some other industry-specific regulation. Happy to take questions on that. The security breach notification laws. They effectively cover every U.S. territorial jurisdiction. Why is this the case? Their jurisdiction does not depend on physical location of servers, physical location of companies. It depends on the residence of the people described in data which was compromised, which means if you are a New Mexico company, which does not have one of these laws, and you have data describing Californians, you are covered by California's law. Although there has not been a long-arm test of this, every single attorney I know who practices in this area advises their client to assume that there is full and healthy long-arm jurisdiction in this regard. There is an exception for encryption. We'll talk about that. So how do these work? It's not anytime you lose any data, you have to report it. It's if you lose data, which meets the simple test you see on the board. Is there an identifier unique to the person, which is usually from a list, usually that person's name, combined with sensitive information about that person, which is usually one of three primary categories. Some states have more. They're the primary categories you see up there. If both of those exist, you have a reportable breach. But there is an exception for encrypted data. Interestingly, encryption is not defined meaningfully from a technological standpoint in any of the jurisdiction's statutes. So what happens? Well, if you talk to Chief Information Security Officers, they're going to tell you, our senior management came in and told us to go encrypt everything. They didn't give us more money. They didn't readjust our budgets. They just told us to encrypt everything. Well, what happened as a result of that? The ability to engage in risk management was taken out of the hands of the technical experts, and they were forced to allocate their budgets to engage in something which may or may not have been effective. And at least in three notable cases, interviewees whom I met with, they identified that this took money away from an active threat, meaning they knew that it was making their security worse. There are some very good quotes about this that I can show. There's some statistical data. People are interested in coming back to that. Lastly, I want to note the Federal Trade Commission. This could be an entire semester's course. We don't have time for that. So what I want to highlight for you, again, I mentioned that it's based on unfair and deceptive practices. What the FTC essentially does is when it identifies something which is so egregious from a technological standpoint, it notifies the company, conducts an investigation, and we almost always have a settlement. There is one exception. There are now over 100, getting into the hundreds of these enforcement actions, all of which settle. Some scholars have argued creating a jurisprudential precedent, except one, the Wyndham case, which to no one's surprise, Wyndham lost their series of legal attacks against the FTC for its authority to do this because Wyndham was the lowest of the low-hanging fruit in sort of the modern era, the past 3 to 5 years of enforcement. You've heard me talk about reasonableness. The reason that the FTC, I would suggest to you, has had very little trouble getting in settlements out of these actions is because the organizations which they target are engaging in some type of activity which is so egregious that no one in the security community would ever, the technical security community, would ever stand up. No one in the privacy community would ever stand up and be willing to say in a private meeting, let alone under oath, well, that was a reasonable practice and there was nothing they could have done. They've been very strategic in that regard. But they have sort of created a little bit of jurisprudence. These are an example of some things which attorneys actually advise clients not to do, specifically as a result of the FTC's enforcement. And you'll notice we have a patchwork of a variety of different regulators and styles of regulation which come into play to cover privacy and security in the United States. So when you have that patchwork, where does that leave you? And Pierluigi is going to talk a little bit about some more recent developments. I'll come back to the US and we're going to tie this together into a comparative question to pose for you.
Thank you, David. Okay. Switching back to the European cybersecurity regulation, we can summarize the fundamentals in 8 principles that I reported in this slide. For our purposes, however, it's important to focus on principle number 7, which impose the adoption of technical and organizational measures against unauthorized access and loss of damage. This is important because it's the view of the European lawmaker about cybersecurity. First, security is not an option, because the data need to be safeguarded against the risks of unauthorized access and loss or damage, what we call the data breach notification regulation. Second, security, as David said, is not a product but a process. And this is why the measures are not only technical but also organizational. In European Union, we have an agency specifically about cybersecurity, which is the European Union Agency for Network and Information Security. The main scope of this agency is to promote a culture of network and information security through some tasks, which are the following 4. Advising and assisting the Commission and the Member States on information security, collecting and analyzing data on security incidents in Europe, promoting risk assessment and risk management methods to enhance our capability to deal with information security threats, and awareness raising and cooperation between different actors, mainly developing public-private partnership with industry in these fields. So it's a sort of collector of typical cybersecurity problems. We have also different data protection bodies. We have the National Data Protection Authorities, the DPAs, the European Data Protection Supervisor, the EDPAs, and the European Commission's Data Protection Officer, the EU DPO. I have summarized the definition of these bodies in this slide, but for concrete application of data protection law, it's very important to focus on the activity of data protection authorities, because is where the action is. In fact, if we look at the role of the DPA, we find that they have an administrative role and a judiciary role.
this role will probably change in the forthcoming General Data Protection Regulation, where the DPAs will have more tasks and the possibility to control the controllers or processors' activities with the assistance and oversight of other DPAs in other member states. This is the so-called one-stop shop system. So, looking forward at the forthcoming regulation that probably will be issued in a few months, the European Union has a lot of programs concerning cybersecurity. The first is the Digital Agenda, which sets out 14 actions to improve cybersecurity readiness, such, for example, enact a policy about critical information infrastructure protection, or establish a well-functioning network of computer emergency response team at national level in every member state. Looking forward at the strategy, we have a strategy that is called Europe 2020, and we have many action about cybersecurity. I have just reported the action which are focused on cybersecurity regulation. And in a few months, as I said, we will probably see the new General Data Protection Regulation, which is part of the process of the data protection, which includes the General Data Protection Regulation and the Directive for Police and Judicial Activities. Please consider that the European Commission decided to use the regulation, which is immediately applicable in all European member states, without need to be transferred into national law by each country. So the question is, will this reform completely overwrite all the pre-existing regulation? Formally, yes. But in my opinion, the fundamentals of data protection, the 8 pillars of data protection, are the same even in the new General Data Protection Regulation. I hereby report the next step of the approval of this regulation. We are now in the so-called process of trialogue, is because it's a dialogue between 3 parties, specifically the European Parliament, the European Council, and the European Commission, that are negotiating the last questions before the definitive approval. After the approval, there will be a 2-year transitional period to enact the regulation in every member state. So, the pillars of this new regulation are the famous right to be forgotten. It is the right for data subjects that their personal data are erased and no longer processed. The duty to hire a privacy officer for data controller with a certain amount of persons in charge of processing. The data breach notification provision, which actually is provided just for ISP and telecommunication companies, but will be extended to all the data controllers. And finally, the privacy by design and privacy by default principles, which will supervise all the creation of new objects, technologies, and software dealing with personal data.
Why don't I have much to tell you about recent developments in the United States? Most recent developments in the United States have stalled. They've stalled because US law is fragmented, as you saw. If you are a little bit confused, you all got that, right? The entire semester's worth of work in just 10 minutes. You know everything you need to know now, right? It's incredibly fragmented. It's incredibly confusing. And this creates a problem. As you saw from the European perspective, when thinking about privacy, data security, cyber warfare, cybercrime enforcement, there is coordination at the Commission level. We don't have that in the United States. Why does that matter? What ends up happening is we have, by my last count, I think 12 some odd different congressional committees working on different bills, none of which go anywhere, in part because they are constrained by political considerations and because they can't reach convergence because any one of those levers which they try to pull in their narrow expertise pushes all of the other levers about which they're not thinking. So where does that leave us? This is sort of a general map, attempting to pair the US and EU regulations with one another. which is something of a futile exercise that many scholars in Professor Perry's and my area try to engage in, and often end up feeling very frustrated at the end of their projects that there's no answer. What we suggest is that in thinking about the comparative relationship, substantive convergence, agreeing on what are the principles, seems very unlikely. But there may be some benefit from finding common procedures. And we will leave you there to think about that question and the relationships and comparisons between the two. And I think we have maybe time for one or two questions, Ron? All right.
I just wanted to ask you, has there been any coordination between, not between the EU and the US, but even within them regarding virtual currencies, or are they just trying to ignore everything because they don't understand them?
Virtual currencies.
Do you want to talk about
There is no coordination.
The short answer is there's not much in. Thank you. The short answer is there's not much in either case. The U.S. Congress held some hearings. That's about all they did. It caused I think, 1,000% spike in the value of Bitcoin when the hearings, just because the hearings happened. This is 2013-ish. Other than that, no, there hasn't been any internal coordination in the U.S., and I'm not aware of any across the Atlantic.
As far as I know, the European Central Bank is trying to understand what is a virtual currency. So we are.
Thank you very much. I'm Lizzie Shackelford with the Department of State. I just wanted to know, in terms of the divergence between EU law and cybersecurity and US, do you think the divergence is really mostly because of our kind of political situation and governance differences and the ability to get that aligned, or is it, how much of it is influenced by the difference in culture over privacy?
So I think the answer is that both play a very important role in the substantive differences between the U.S. and the EU. And let Pierluigi say a little bit more about that. But I don't think either is a barrier at all to finding some degree of procedural convergence, which can have a much larger benefit than I think the sort of rhetorical discussion in the media gives it credit.
Sure. This is right. We start from different conception of privacy. You know, in the United States, typically you are not feared by privacy from companies. In Europe, we don't care about privacy from government. This is one of the main difference of privacy perception in United States and in Europe. But I think that besides this common distinction between European and European Union and United States, the coordination is very important. In fact, they are just going to a coordination at least for preventing crime and terrorism. European Union and United States has just reached an agreement, which is called the Umbrella Agreement, just a few days ago, which is the exchange of records to prevent and to persecute crime, but with strong data protection of European and American citizens. So I think that this is the way we are following.
Thank you, both of you, for an excellent presentation.
Thank you very much.
Next up is a pair that's going to look like a single person. Unfortunately, due to some last-minute matters that were uncontrollable, Mark Kamek is unable to join us. So Professor Haider Hammoudi is going to present on the understanding of Islamic law in the current international legal environment. Just get the sure. You don't have
Yeah, thanks everybody for having me. Thanks, Ron. As Ron mentioned, my co-author of a book we were going to talk about, our Islamic law case book. Well, he said he was sick and wasn't able to make it. I have a feeling he didn't want to stand next to me while I was talking. But and I also don't have a PowerPoint like the cybersecurity whiz kids or anything, so I'm just gonna have to wing it here. But we're going to talk about Islamic law, our Islamic law casebook, and why we're taking an approach that's actually kind of different from the way that Islamic law has been traditionally studied and understood in Western academies for the most part. So what's the traditional way of understanding Islamic law? How is it usually looked at within let's just say universities in the West, but even often in the Islamic world itself? Well, the core material is usually this juristic material. That is to say, you get these jurists who are authoritative, often medieval, and you look at, but in some cases modern, and you look at the way in which they interpret the sacred text, usually within Islamic law, depending on sect and everything. It's going to be the holy book, the Quran, the word of God descended through the angel Gabriel, or it's going to be the actions, utterances, statements, permissions given by the Prophet Muhammad himself. Again, if you talk about the Shia sect, you'll involve some descendants of the Prophet Muhammad from his immediate family. But you get the general idea. You get a bunch of source texts, and then you go to the jurists, and you say, well, what do they say? The thing about the jurists is they're not actually deciding actual cases. Their method is casuistic, which means that they present a bunch of hypotheticals and say, well, this is how I would decide this, and this is how I would decide that. And that's easy to do because you can divorce yourself from any sort of social, political, economic factors, not to an entire extent, but to a large extent, by pretending it doesn't really exist. And I think it creates distortions and misunderstandings and misconceptions in a way that we wanted our casebook to avoid. So I'll give you a simple example of that. A simple example of that would be Islamic finance. If you go and pick up an Islamic finance textbook, which is based on these juristic readings, it will tell you the first thing is Islamic law believes in profit sharing. So we believe that we have partnerships together, and we make money and lose money together as a group, and that's why we work together to make money so that everybody's happy, and if we lose money, well, we share the pie together, and that's how Islamic finance works. Well, that sounds nice. And then you remember or keep in mind that people, groups like, a large portion of Islamic finance these days is done by Islamic finance desks in groups like Citibank or HSBC or anybody else. So I, having been a commercial lawyer for a good portion of my pre-academic life, have been involved in distressed debt situations representing debtors, and Citibank was on the other side. And those guys don't share profits. That's not what they do, right? And if you were to tell me, oh, well, maybe they have a section that does, it just doesn't make any sense, right? The entire culture is not about, well, let's all share together. Oh, we all lost, we'll have a hug, and it's just not how it works, right? So that can't be right? It might be right as an ideal. It might be right as a, let's play out some hypotheticals and sort of explain how we hope the world could work, right? But it's not really right? And in order to figure out how it's really right, you would need a different method. And it would be a method that would focus on cases and things that actually happen. And we have cases, right? There are cases that occur in the US and the UK and Indonesia and Malaysia in which disputes occur over an Islamic finance issue, right? And if you read those cases, you start to see, well, credit sales are okay in Islamic law, right? So, which they're not okay in other religious systems. But once you say credit sales are okay, your problem is solved. Because what that means is, if I were to sell this pitcher of water here to Professor Brand, I could sell it to him for $10 now. I'm allowed to do that. Or I could sell it to him and say, pay me back later $15. Right? From that, and I don't need to bore you with details, it's a lot more elaborate than that, but from that, it's not terribly hard to build a banking system. Professor Brand needs a house. Okay, Professor Brand, you go find the house, and I will buy the house for you and sell it to you. Pay me in installments over 30 years, right? This amount of money. Right? So I remove any risk on my side, because I'm buying and immediately selling. And I've transferred all the risk onto his side, and I'm going to get my 6%, or 4%, or 3%, or whatever the prevailing interest rate is. Right? And so it's easy to replicate Islamic finance, and I think if you look at cases, what you see is a practice that's really derived based on mimicry. Right? The idea is find a conventional transaction and find a way to justify it. Islamically. It's a little cynical, I suppose, but I think that's what case methods lead you to do. Another popular way to look at Islamic law would be to say, well, we'll use this case method, we'll use actual cases, but we'll look at history, because that's when Islamic law really flowered, by which I mean it was really dominant, right? In the modern world, well, it applies in some cases, but a lot of times there's transplanted codes and the like, right? And the thing about that method is that it's very useful, and it's very intellectual, and it's very stimulating for someone like me, but it's not necessarily quite as useful, perhaps, for a modern audience in terms of things that they'd like to know about Islamic law that are relevant in today's world. So I'll give you the best example. It's in the afternoon and things are getting, maybe it's post-coffee. So instead of finance, I'll talk about sex, because sex should. I thought the cybersecurity guys were going to talk about Ashley Madison. You had a chance. Blew it. Okay, so sex. So one thing that's very interesting, and something I've actually done a little bit of research on, when one looks at the methods of slavery in Islamic law historically, say the 15th century, the 14th century, versus American antebellum slavery, one of the key differences is one is very heavily racialized and the other is not. And there's some significant consequences when it comes to sex, right? Because when you're not racialized, the sex of a master and a slave, of course, a male master and a female slave, I say of course because the patriarchy is just presumed, is not as big a deal. And what you start to develop is a series of rules that legitimize that practice, and indeed legitimize the child as the legitimate and free issue of the master. And so in a world in which you want to keep these things as far away from possible, you sort of shield your eyes to the fact that that sex is happening. And in another one, you say it's okay. And you develop rules, and all of a sudden, in a patriarchal society, as any 14th century society was, Islamic American, well, not American, obviously, European or otherwise, 14th century, and certainly, I'm sorry, if you want to compare to 18th century or 19th century American slavery, certainly a patriarchal society there as well. All of a sudden, you have a very interesting contrast, and what starts to look like everything is subsumed within the Islamic context within what's called the nikah, permissible slavery. Right? And once the child is born, well, now it gets very, very confusing, because you can't sell the slave, and the child is yours, legitimate and free. Right? Well, that's starting to look a lot like a marriage. Someone's told me, no, but you can't force sex on a wife, but you can on a slave. I'm not sure how much you know about history, but trust me, that's not, marital rape is a 1950s concept and post. Right? It's interesting. It is. I mean, as an intellectual matter, it's interesting. You can learn a lot about how values shape law, underlying values of a racialized system versus a deracialized system. You can learn a lot about how law then creates values. You start to say, that's your child, and it changes your attitude, right? I have to feed, I have to clothe, I have to educate, I have to shelter, I have to care for this child. This is my child, in a way that did not exist. Couldn't exist in a one-drop rule society, right? Can't treat that like your child. You can't treat that child like your child. So there's interesting things to learn about law and policy and jurisprudence and all of it, in my opinion. What you're not going to learn about is anything relevant about how Islamic law works in the modern world. You're comparing two systems which have norms and values and systems and understandings that are completely different from the way modern Muslims or modern Americans think, as different in both cases, right? So you're not going to be able to say anything intelligent about that. The only people who would be able to find anything useful, well, we can't open a mosque in Monroeville because look at what Professor Hammoudi just said about slavery, right? But, obviously completely, we're talking about the 14th century, to the extent that, in fact, if you ask most modern Muslims, what does nikah mean? They say, well, it means marriage. And if I were to say, well, actually it means permissible sex because it includes sex with slaves. What? No, you can't be right. That's wrong. Right? Because nobody thinks that way anymore. For good, and that's a good thing. I mean, I'm not, obviously that's we have a positive development. So if we want to learn about Islamic law, and we want to learn about it in the modern world, and we want to learn about it in a way that's relevant and sort of reactive to what's happening in the world, the way that my co-author and I thought we would do it is to focus on actual cases and how they're decided in the modern world. Now, there are some challenges to this, right, that don't exist elsewhere when one thinks about Islamic law. It's easier with Islamic finance because it's something of a globalized practice. But it becomes a challenge when you want to talk about marriage, or you want to talk about divorce, or you want to talk about inheritance or anything else. And that is that the Islamic world does not live in any sort of mythical house of Islam. You have a whole bunch of nation states divided. Each one of them has their own legal system. Each one of them has populations with their own biases, beliefs, pre-existing customary practices. My co-clerk would have told you the Javanese, my co-author would have told you the Javanese have a traditional matrilineal inheritance system. It's fascinating. Completely at odds with the Islamic system. And so you have these sorts of differences. And so we were sort of forced into, okay, well, we'll go ahead and accept that, and we'll pick two countries, Iraq, four countries really, Iraq and Egypt on one hand, and Indonesia and Malaysia on the other. Why? Well, I mean, it's the areas we know. I mean, so there's one practical aspect to it. But I would never say, I'm on tape, oh well. But there are some other intellectually justifiable reasons in that. But one of them is you're taking two very different portions. You're going by the traditional Arab world, right? Which is the focus of where a lot of Islamic law takes place. But at the same time, you're looking to the perimeter and to areas of the world in which there's more Muslims in Indonesia and Malaysia than there are in the entire Arab world. So you're getting a much better and broader view in that way. You're looking at what non-Arab speakers taking a fundamentally Arabic source text are going to try to do. Fascinating to see that process too, because it gets translated into English, it gets translated into Indonesian, and from Indonesian it comes out. It's really fascinating with women's rights, because Arabic is a gendered language such that every single word is male or female like French. Every adjective then becomes male or female. Every verb takes a male or female form, right? Into a language like Indonesian where there's no gender at all. I can't even think in a language. I can't get it into my head. But that's how it works. And so they translate it, and all of a sudden, that which said boy becomes child, which is convenient. So one can see these sort of processes take place in these different societies. One other big difference that I should say, Iraq we thought was important because it includes a very strong Shia tradition. The Shia juristic academies are located in Iraq. You have a large number of cases that you can look at from Iraqi law from there. And I think using that, one can learn a great deal of how Islamic law actually operates on the ground in different Islamic countries. You're not necessarily going to know how it applies in every single country, but you'll at least have representative examples. And I think, hopefully, from these sorts of pedagogical exercises, someone learning in this method would then be able to take those kinds of lessons and apply them throughout the Islamic world more broadly. So that's all I had to say. I was a little bit short, I know, because I tried to fill out my co-author's time, but obviously it was unsuccessful.
The extent that Islamic law affects, was it working? Well, the extent that Islamic law affects daily life of individuals depends on the country. So in one place you might have criminal law being affected by Islamic law. In other places you might have very little effect. Like you would not have it in the financial sector. You would probably have it in the personal status, family issues. What kind of areas did you study Islamic law in? Because, like I would, in Saudi Arabia, they would have Islamic law in everything. In Iraq, we do not have Islamic law in criminal law. So what kind of areas did you focus on? Because it is different. There's Islamic law in field X, in place X, given background X.
The thing that frustrates a lot of people when they read our casebook is, well, how come you have 2 chapters in the beginning on inheritance and then 2 chapters on marriage and divorce, and then criminal law doesn't come until the end, right? We really want to hear about hands getting chopped off and people getting stoned. But the thing is, as you say, the reason for that is precisely for the reason that you say, which is in the vast majority of Islamic countries, this isn't even the law anymore. I mean, there's only some very small number of countries where that's the case. What we try to do is focus on the areas of Islamic law that are particular salience, both broadly within the Islamic world as well as the areas in which we're looking at. And those are primarily going to be personal status as well as financial rules. But one thing that does happen is that criminal rules will pop up even in societies in which technically there's no criminal law. So for example, Iraq is a good example of this. Malaysia is actually a similar one as well. In these countries, there is no criminal law that's Islamic that, say, punishes an apostate, someone who was Muslim and then is not Muslim anymore. However, in both of these countries, if you were a Muslim and you looked to convert to Christianity and you looked to get your ID card changed, because you're going to need your ID card changed if you were, say, a Muslim woman who wants to marry a Christian man, you can't do it, right? You're not allowed. And they will tell you you can't do it because it's an Islamic prohibition. In fact, within Iraq, if you were Christian and 14 and your father converted to Islam, you have been automatically converted, notwithstanding the fact that in the Islamic rules you're not a child anymore, but under Iraqi rules you're a child, so now you're a Muslim, and now you can't convert back into Christianity. There's any number of cases like this. So there are fascinating different, I mean, these are terrible human rights. I mean, I'm not defending them. I just mean fascinating from an intellectual perspective, obviously deeply problematic from a human rights perspective, results that, that come from the intersection of modern law, modern state law, and Islamic law. And clearly here they've been melded together. The age of majority is taken from Iraqi law, the rule of apostasy is taken from Islamic law, and taken together, and to get a weird result that nobody would recognize, right? No modern judge in the US would understand what was happening in this case. Why couldn't they just convert back? And you wouldn't get a classical jurist to understand it. He wants to punish the apostate. And what the court is doing is pretending it didn't happen, which in any other criminal context would be bizarre, right? You killed somebody. I killed somebody. No, you didn't. No, I refuse to recognize that. Weird. But that's how it works, and so that's part of what we talk about as well.
Thanks, Heider. Question for you. So I'm thinking about the casebook project from its teaching perspective, not its scholarly perspective, and it prompts this question. If I'm thinking about a comparative casebook of any kind, and particularly with regard to Islamic law, I could picture that the perspective between kind of Western common law traditions and Islamic law would be radically different in things involving personal status. And I can probably assume that it's not going to be radically different in litigation. The incentives are probably quite similar. But then I think about deals in commercial transactions and thinking about the purpose of a casebook to kind of orient students not just in doctrine, but also to kind of open their eyes in differences in global perspective. And so here's my question. What is the single thing, if you're doing a deal and you have a Western traditional common law lawyer on one side and a traditional Arab Islamic law educated lawyer on the other side, what is the single assumption that they're both making about the deal that's wrong from the other's perspective? Like, where's the biggest gap?
Mm-hmm. That's a very good question. Let me say where they're both similar, because I think that helps to highlight the area of difference as well. I mean, it's a very good question. So where they're most similar, they both recognize this notion of private property. They both recognize that each one is attempting to profit at the expense of the other. They both recognize, however, that they can't do the deal without the consent of the other, and then so in some way they have to convince the other guy that they're profiting, right? All of those sort of traditional things in negotiation. This is good for you because of X, Y, Z is all the same. I think the single most biggest difference is, and this value is created largely from these juristic works, is the idea of at least the fiction, well, or maybe fiction's too strong a word, at least the underlying belief that in an ideal world everybody gains or loses together, right? Which isn't going to reflect itself necessarily in the actual commercial transaction, or isn't going to reflect itself perfectly in the commercial transaction. It's much easier to have that conversation if one knows that that's sort of the ideal. Even if you're going to get to result X, which isn't exactly that, you're going to have an easier time communicating with someone who's familiar with Islamic law and comfortable with Islamic law. You're going to get easier approval from what's called the Sharia Review Board, which is going to pass on the Islamicity of it, if you can convince them in one way or another that the deal is mutually beneficial. And I don't think that necessarily, or to the extent that it doesn't work for everybody. I don't think that it necessarily works to the same extent with the Western person. The Western person is sort of thinking, I need to protect myself, and I'll worry about them protecting themselves, right? And I think the Islamic side would think much more of, no, we need to do this together and work in this together. Now, again, I want to emphasize, it's not that the structure of the deal is necessarily radically different, but it is different in terms of an outlook and in terms of how you approach it and how you negotiate it. That certainly happens a lot. And so that kind of miscommunication and negotiation to a result which often frustratingly is almost exactly the same, but very often that kind of negotiation does get fouled up. One thing actually I'll say in addition, and this is less Islamic and more sort of Middle Eastern culture, but the way Arabs like to negotiate, and having done deals throughout, is you have 10 points and they'll go 1, 2, 3, 4, and then revisit 1, and then go back to 5, and then 7, and then 2, and then at the last minute everything comes together, right? And Americans hate this because they feel like you're reopening things that have already been closed. And they just think, what's the last minute? Midnight on September 11th, okay. 11:58, everything starts to come together. Whereas with Americans, well, we just did 1 through 6. No, you can't. We have to go to number 7. And we haven't signed anything. Why can't we talk about number 3 again? I want to talk about number 3 again. But that's less Islamic. I mean, that's more of a cultural practice, I think, among large numbers of Muslim-majority countries, but isn't really related, I think, to Islamic law per se.
Thank you, Haider.
I do want to mention that there may be times when we don't have time for every question that comes up, but at the end of the day, we're going to have a reception for informal discussion up on the second floor in the Alcoa room, and so we'll invite everybody for that. But also something kind of special, we invite you also, if the weather is okay, and I haven't been outside enough today to know, to take the first tour of our new rooftop garden that's right above this building as part of that reception. But now we turn to international human rights and criminal law, and we have one of the newest members of the University of Pittsburgh Law School faculty, Professor Matiyanga Sirleaf, and her colleague from Temple Law School, Professor Jaya Ramzi Nogales.
Thanks, Ron, and thanks to CILE for inviting both Jay and I here today. We're going to take a slightly different tack than our predecessors. We're going to be talking about current scholarly projects that we're working on, and we're hoping to foster an interesting dialogue both between ourselves and the rest of you. So first, I would just like to say that we're both working on sort of recent crises in international human rights law and how international law more generally has tried to deal with this. I'm looking at Ebola, Jay is looking at the migration crisis that has been happening. So one of these crises is sort of fading from the headlines while the other is dominating the headlines, which I'm sure you're aware of. And we're both in our projects looking at issues of structural failures, and we're seeking to reimagine the space or reconceptualize our respective fields and how they can address these various problems. Jay is looking in the field of international migration law, while I'm looking in the field of post-conflict and transitional justice. And we're hoping that you guys will share any questions or comments that you have to hopefully enrich both of our projects. So I'll go first. So over the past 30 years, there have been numerous infectious diseases due to the increasingly interconnected world that we live in, globalization and the like. We need, more desperately than ever before, effective means of regulating these types of diseases. And this is particularly so in post-conflict countries who already have weak infrastructures, and this is where most of the work I've been doing has been in the field of post-conflict justice. Now, Ebola is an infectious disease that manifests itself as a severe or hemorrhagic fever that is often fatal. As many of you, I'm sure, are aware, between March and May of 2014, Guinea, Liberia, and Sierra Leone had a number of Ebola cases. The first organization that was on the ground is Doctors Without Borders, which is an international NGO. The international system was much slower. The UN Security Council, the World Health Organization, and the like came on the scene much later. As of September 9th, the World Health Organization estimates that there have been almost 28,000 cases of Ebola and more than 11,000 deaths. Tragically, Ebola impacted post-conflict countries that were already struggling to rebuild following very devastating conflicts. And so my project is arguing for reconceptualizing or reimagining of the field of post-conflict and transitional justice in light of this epidemic and the need to increase emphasis on positive peace building. And so I want us to understand how Ebola has impacted these particular countries. So if we think about post-conflict societies and we look at places like Guinea or Liberia or Sierra Leone, these societies are generally marked by injustice, which people experience both as discrete acts of violence that they either witness or endure, but they also experience structural inequalities. And in massively destructive conflicts, following these conflicts, the state is generally devastated and non-functional. The rule of law is something that is completely disintegrated, and you can think of the formal apparatus of the state having disintegrated as well. Major reforms are needed in all sectors: political reform, economic reform, social reform, and the like, and security reform. But generally, peace-building efforts and post-conflict justice efforts have neglected the importance of the social structure and remedying structural violence. And this has rendered countries in the global south very ill-equipped to deal with humanitarian and public health crises. So historically, post-conflict and transitional justice has focused on ceasing the violence, stopping the guns, making sure that security sector reform happens, right? Securing negative peace and making sure that there is an absence of violence. But this has been at the expense of looking at positive peace building. And it's important to keep in mind that long after the guns have stopped, insecurity and instability remains, and peace is something that is much more wide and broad than ceasing violence. And if we think about how Dr. Paul Farmer has defined structural violence, he talks about it's a way of describing social arrangements in which individuals and populations are in harm's way. These arrangements are structural because they are embedded in the political and economic organization of the society, and they are violent because they cause injury to people. And so what I'm trying to do in my current work is look at health inequities both globally and domestically as a form of structural violence, and I want to argue for the use of a more transformative the use of a more transformative form of post-conflict justice, which is seeking to address structural violence and attempting to respond to the priorities of those that are recovering from mass atrocity. Ultimately, I hope to examine whether the use of traditional peace-building tools like peacekeeping missions can prove effective in managing public health crises, or whether there's a need to reconsider and expand the current toolbox. And the aim is to propose a framework for understanding how to more effectively address such crises in the future. And so I'll turn over to my colleague Jaya, and then we'll ask each other some questions and then open it up to you.
Thank you so much, and thanks very much to Pitt Law School and the Center for International Legal Education for bringing me here. So I'm going to talk, as Matiange said, about migration emergencies. I don't think my topic needs any introduction, not at least if you've been near a computer this summer or last summer. It's just dominating the headlines now all the time. But I want to take a step back and think more critically about what's happening, and also, as Matiange says, think critically about the role international law is playing here. I first want to think carefully about the depiction of these situations as a crisis or an emergency. I would in fact say that these massive flows of human beings, thinking about the women, largely women and children who came from Central America to the southern US border last summer, and then the flows and flows of migrants we're seeing in Europe as I speak, these are foreseeable responses to cycles and structures of violence. And these are cyclical migration flows, right? These are not surprises, nor they should not be, particularly because international law provides no safe and lawful means for people to move, say, from Central America to the US, from Syria to Europe. So I want to think critically about the factors that construct these crises, and in particular, the way international migration law is a factor that contributes. It's certainly, I'm by no means saying it's the only cause, but I want to think about it as a contributing factor. I think people often think of it as a solution, maybe an inadequate solution, but we rarely think about how it's contributing to this problem. And my argument is that law really inscribes and reifies certain approaches that eliminate flexibility, and this is particularly acute with international migration law because there's no way to change it or update it. Let me take a step back and talk about what a crisis is. So crisis is pretty hard to define. It means a lot of different things to a lot of different people. So on the one hand, we can see the Hungarian president, right, worried about the crisis of national resources and border control such that he's had to put up a barbed wire fence, right, to keep out these migrants, and he's doing, I think today, military exercises along the borders, right, to scare away these Syrians. Then we see for others, like, for example, the UN High Commissioner for Refugees, this is a humanitarian crisis, and this should prompt generosity and allocation of resources. The first thing you see when you go to their homepage is Syrian refugee crisis, donate now, right? So everyone can put this rhetoric of crisis to work in different ways. I think the common thread in defining a crisis, and I think this would apply to Mateange's paper too, is that it's a grave situation, right? And this gravity is unforeseen and perhaps unforeseeable. This arises suddenly, it grabs everyone's attention, right? The situation in Europe right now, a great example. It's powerful and it's flexible, right? It draws public attention, it draws resources, it draws other benefits. But there's a real cost here, right? Which is that this emergency rhetoric implies an unanticipated problem with a discrete cause, right? The crisis distracts attention from processes and structures that create these problems and focuses us very narrowly on specific events. This leads us to temporary solutions that avoid examining core causes, and it depicts migration as a choice, right? Unmoored from long-term structural causes of migration. So let me just talk for a minute about the architecture of international migration law. So I wouldn't say international migration law is exactly a field of law, right? Especially if we view the role of international law as coordination. We see massive global flows of human beings, the majority of whom are barely covered by international law. We can contrast that with the international law governing global trade, communications, and even finance, right? Where it plays a significant coordination and regulatory function. So there are two problems with this vacuum of law when it comes to migration. The first I've mentioned before, right? There's no safe transit route to get from one country to the next. International law says nothing at all about that, even human rights law. And then there are very few paths, even if you can get yourself into Europe, there are very few paths to remain and be protected, right? So the central path that we have is this principle of non-refoulement. You can't send someone back to a country where they're fleeing a particular type of danger. This is actually an incredibly successful human rights norm, if not the most successful norm, one of the most successful norms, but it's also incredibly narrow, right? It comes from the 1951 UN Refugee Convention. It's been expanded through the Convention Against Torture. There's been a lot of development of this law. At this point, I would say it's a jus cogens norm of international law, but it protects only those fleeing persecution on the basis of their membership in one of 5 grounds, or someone suffering torture at the hands of or with the acquiescence of a government official. This is not a response designed for the complexities and subtleties of the modern world, right? So a lot of the kids coming over from Central America last summer, 6-year-old kids fleeing violence, like maybe they fit into the definition, maybe not, right? Not clear that everyone from Syria fits into this definition. They are fleeing terrible violence. They need to be protected. But are they being individually targeted for their political statements? I don't know that you can legitimately make that argument. And also, of course, we're lacking this route to entry or safe passage. The common response, I think, is to expand international refugee law. I'm not sure that's the right way to go, and I'll talk about that in a minute. But I do want to note that in particular, one problem that we're seeing is that mass influx was anticipated and actually feared by the drafters of the Refugee Convention, right? Thinking about the displaced populations throughout Europe after the World Wars, they didn't want to have anything to do with mass influx. They ignored the problem, they excluded it from the convention, so that's part of the reason it's really not addressed in international law. We've seen a recent case from the European Court of Human Rights that tells us that states have to individually assess claims of migrants interdicted at sea in certain situations, so they got to see if these folks have refugee claims. But we have a U.S. Supreme Court case from many years ago that says exactly the opposite, right? So that's basically all the case law that's out there. So let me just finish up by talking a little bit about the role of international migration law. So there's this real path dependence problem that we have in international migration law because there are no mechanisms for progressive development. International migration law has inscribed and reified this real focus on refugee law. My paper talks a lot more about different areas of law. I'm happy to talk about it a little more in Q&A. But this is a factor in migration emergencies, that we have this entrenched set of norms that is now very sticky and very difficult to get away from. And this approach actually consumes both rationality and morality, right? So this is an irrational system. We're not thinking about either what migrants need or what states need, right? We don't ask questions about equitable distribution, about labor needs, right? Vulnerability, as a friend of mine argues very convincingly, is actually trumped by geographic proximity and physical ability to overcome barriers to entry. What we saw last summer in the US is very unusual, that this was predominantly women and children in the flow. I just looked at the UNHCR website because all the pictures I'd been seeing of Syrian refugees, I thought, wow, that looks like mostly men. And it turns out 75% of that flow is men, 12% is women, and 13% is children. Because the men can make it physically, right? And that's why they get there, and that's why they get protected. But are they the most vulnerable? Are they the most in need of protection, right? This is the situation that our system sets up. There's also this moral deference to the refugee law framework that I find troubling, right? There's insufficient critical analysis of whether the substantive lines drawn are morally appropriate. So with the border crisis last summer, right, we said, well, if they're refugees, they can stay. If they're not, they can get sent home, right? But no one took a look at how those determinations are being made, right, in the general public. That enables us to avoid conversations about that. The horrors of procedural due process. I'm a civil procedure professor, and it is horrifying what happened at the border in terms of the processing, right? Women with their child on their lap being asked to describe the sexual assaults that they suffered at the hands of their husband in their home country, with maybe or maybe not an interpreter over the phone, or maybe their interviews happening over the phone, right? So, and then we just say, well, we made that decision, that person's not a refugee, they can be sent back. So it's troubling on a couple of different dimensions. So the part of my paper that needs work is thinking about the road ahead. So what do we do next, right? I think the first step is we need to anticipate and expect migration flows. These flows are here to stay. They're not going to go away, right? So we need to proactively think about setting up structures that are going to deal with them going forward. We want to think about the source of these flows, which is really global inequality, right? And so what can we do if we think about that, right, how does that affect the way we structure the system? We really need to think about safe transit routes. That's incredibly important. And I think the argument I'm going to make is that we should establish a temporary regime that states might be willing to be involved in for a certain period of time that may eventually lead to a permanent regime, because I think part of the problem we've seen is a lack of political will to sign a new convention that's going to be a permanent commitment by states. So I'll stop there because we're really interested. We're going to have, I think, a brief conversation, but we're really interested in hearing from you guys and having time to take questions from the audience.
All right, great. So we had a couple of questions for each other, and then, like Jay said, we're going to open it out to everyone else. But so I'm sure you've heard that there are a number of commonalities within our respective pieces. And one of the questions that I have for you, Jaya, is, so what are the dangers of moving away from the existing system of refugee and international migration law? I heard your presentation regarding the challenges of using this law, but what are the dangers of moving away from this law and to some alternative approach?
I mean, I think that's why, you know, most people who aren't in academia and are actually in practice make the argument that we should extend refugee law, because I think it's incredibly difficult politically to imagine an alternative, and this is protecting some number of people. It's, as I said before, this very, very successful, powerful international legal norm that is working, is doing a lot of work, though imperfect, and right, should we let the perfect be the enemy of the good? Now, I think on the flip side, the reason that I'm making this argument is I think it's just hard to say, it's hard to make a counter argument after looking at what happened last summer and this summer. The system is broken, right? It's not working anymore, and there has to be some kind of solution going forward. So I think really, you know, the Refugee Convention, and, you know, it's just no longer serving, it's incapable of serving this holistic function. And maybe some part of it would be incorporated into a new regime, but we need a regime that touches on all kinds of different aspects, right? Some people are coming for labor migration, but there's no means in international law to allow for labor migrants to come, even though they're filling jobs that are needed, right? So then those folks try to come in through the refugee process. So I think it needs to be part of a bigger picture framework that thinks about all the different reasons people move and enabling these different forms of movement. So I had a question for you, again, drawing on the commonality between our papers. I think one frustration we share is the slow response time of the international community, right? So we see these crises and everyone's like, what do we do now, right? and it happens very slowly, and in the meantime, people are suffering and people are dying, right? So how can international law become more responsive? And I think, you know, there are a couple of different ways. Well, let me hear your response, and then maybe we can talk a little more back and forth about the different approaches.
Sure. So in an effort to be brief, I didn't cover how international law responded during the Ebola epidemic. And so for those of you who aren't aware, I'll just briefly summarize. The World Health Organization has international health regulations where underneath that there's a provision where something can be declared international public health emergency. And when that is done, then certain mechanisms are supposed to come into place that are then supposed to assist with that given health emergency. And for the first time with Ebola, we had the UN Security Council proclaiming a public health issue to be a matter of international peace and security, which is something that has never happened before. And I think there's an increasing recognition that international peace and security and human security is a much broader concept than guns. And so what I think needs to happen in terms of international law is a conceptualization of security that is much broader than just guns. And so I think that there is a trend in that direction. The dangers, obviously, is conflating global public health issues with security issues, right? Because there are places where they overlap and there are places where they diverge. But I think that the UN's Security Council's recognition of Ebola as constituting a public health emergency is something that is increasingly significant. I think that there is not enough movement, both internationally and regionally, to deal with public health emergencies like Ebola, and it only happens when it touches upon, you know, European countries or the US countries, then it's an emergency. But when countries in the global south are dealing with issues of health inequities and diseases spreading and the like, it's not necessarily a matter of international public concern. So I think part of what needs to happen conceptually is reframing how we understand peace and reframing how we understand security. And I think that the Ebola epidemic is something that that has helped to start that progress. Well, we have more questions for each other, but instead of us just talking back and forth, we're happy to hear any questions that you guys have.
Jaya, you posit the need for some sort of global instrument on migration law, but what would be the elements of that, apart from the refugee definition? For example, if there was a population where there were no jobs, would there then be a requirement of regional countries, neighboring countries, global countries to take percentages? Same thing with natural disasters, same thing with violence. Or is it more like the refugee convention where if you get somewhere, they can't send you back? You posited the need for a safe transit, but so if we say in Honduras, the violence is so horrible that some international, you're positing an international legal norm, would that then mean Uruguay would have to fly a certain percentage, Canada would have to fly a certain percentage, Mexico? What would the elements be of your system?
Great, thank you. It's a great question. I think there would be different approaches for different needs. So vulnerability as a need is going to end up being quite different than labor needs, right? So I think labor needs can be processed in that country, whereas vulnerable folks might need to flee and they might need assistance fleeing. And the International Organization for Migration does a lot of this already. Folks who want to leave for labor migration might pay their own way or might get a loan and then pay that back, right? A loan that is regular. So another huge issue that I didn't touch on in my talk is the exploitation that results from the current situation. Now, we've seen some of this. For me, part of the silver lining of what's been happening is we've seen some great New Yorker articles and articles in the New York Times about the incredible amounts of exploitation that's happening to these folks, to labor migrants and to vulnerable migrants. So I think, there are ways in which the route can be regulated. Labor migrants might end up paying their own way. Refugees we already bring over, right, in some numbers, not in quite as large numbers as we're thinking. And this was one of my questions for Matayanga as well, is thinking about the role that regional systems can play. I don't think they can do everything. We're looking at the crisis in Syria, and we have 2 million Syrians in Turkey, 1 million in Jordan, right? That's why they're coming to Europe, because the neighboring countries just can't support that many refugees. But I do think regional approaches have a lot of merit, and they can take us a certain part of the way. So it's pretty multifaceted, and obviously it's going to have to, there are going to be a lot of different interests and stakes at the table, but I think it's in the interest of all countries, right, to have a solution, because these massive flows at the borders of Europe and the US aren't in the interests of those countries either. So having something that's more regulated, more safe, more secure, and more thoughtful, I think, is going to be beneficial for not just the migrants, but also the countries.
Thank you, and thanks for really excellent presentations. Both of you, in one way or another, touched on what I would call the oh my God factor. And I'm wondering, so much of what's going on in the world, in your area, but in so many others, seems to relate to a perpetual state of exception, where norms that we have that could really be useful get chucked out because the idea is nothing like this has ever happened before. Oh my God. Emergencies, crises. And I'm wondering, in your work, are you trying in any way to define better what constitutes an emergency or a crisis? And maybe more importantly, and I'm sure this is true of your work, prepare decision makers and others to be ready so that it isn't an oh my God on the basis of information that is already available?
So I'll take a first stab at that, and then Jaya will speak. But I think certainly you've touched on sort of a nerve that runs through both of our projects, right? What do we mean by crises? How do we define emergencies? Certainly the idea of numerous migrants on the border conjures up some need for action, and generally the response has been as you rightfully put it, well, we've never seen an influx this big, right? Or Ebola is something that is actually so distinct. And it's like, well, no, actually there was avian flu before, and before that there was SARS, and before that there was HIV and AIDS, and before that there were other infectious diseases. So there is a tendency to see new problems when we've been facing similar problems before. And I think we're both playing with understanding the rhetoric around crises, because the rhetoric around crises does spur actors, policymakers, and the like to action, and does draw attention to issues that we think need to be prioritized. But there's a tendency also to sort of foreground certain rights and certain issues with drama. And so once those issues no longer have that drama, for example, Ebola is now no longer in the headlines, so the problem of Ebola is solved. And it's like, well, no, actually, that isn't the case. And so how do we go about formulating responses to problems in international law that are more sort of everyday, right? So that there isn't this hierarchy of rights, so that there isn't a need to prioritize this fire over that fire, when in fact there are fires that are happening every day that are causing the huge, massive influx of migrants, or the spread of infectious diseases around the globe. And so this is something that we're both struggling with, and I don't know that we've come to any real solution, but it's something that we definitely identify with, so thank you.
Yeah, I think the definition of crisis is incredibly hard, and I, in my paper, just said, I think it's very hard to define. Here are some parameters, and it made me feel better because I read a piece by Hillary Charlesworth later, who's, one of the leading thinkers in international law. She said, yeah, crisis is impossible to define, right? So I think it's very hard to come to a definition, but I think this idea that it's something sudden and arises unexpectedly that I'm trying to push back on, really, because part of this paper arose from watching what was happening at the border and thinking, right, the numbers have been increasing from Central America since 2011, right? 3 of the countries from which these kids are coming have, they're 3 of the 5 highest murder rates in the world, right? So this was predicted. If someone was paying attention, this was, and UNHCR, right, other people are paying attention, right? If there had been a coordinated response much earlier, we may not have seen this. And it's the same thing with Syria, right? It's the same situation. Like, these flows have been leaving Syria for years now, for years. And had there been some kind of had Europe agreed to take 160,000, had Germany agreed to take 500, 800,000 migrants earlier, right, we might have had a more orderly situation with much less human suffering.
Okay, this is obviously one on which we could go probably the whole afternoon, but we're going to stop now and say thank you very much for very provocative. And next up, we have from the University of Pittsburgh, Harry Fleckner, and from Toro Law Center, his colleague, Professor Jack Graves.
Yeah, I'm going to use that. Okay, well, good afternoon. I am Harry Fleckner from the faculty here at the University of Pittsburgh, and I'm here with my very good friend and most distinguished colleague, except for he disagrees with me, that is Professor Graves, and we are the people standing between you and the break. We are up to that task, as a matter of fact. We'll plan to get through what we want to talk about. We're both going to talk about, I think, maybe both of our favorite subjects, certainly my favorite subject, and on the short list for Jack, and that is the UN Sales Convention, the United Nations Convention on Contracts for the International Sale of Goods, which is a treaty that governs the contract rights, formation of contract, and the rights of the parties, private parties, in international sales of goods transactions. It covers the same kind of topics that you would find covered in Article 2 of the UCC, for example. And it has been ratified. There are now, I believe it's 84 contracting states, something on that order, 83, 84, a lot of them. Presumptively is I say presumptively because you can opt out of it, but presumptively governs about 80% of world trade in goods at at this point. And it attempts to do something which is quite difficult. It attempts to create these rights about a specific commercial law topic in an area where, by definition, no matter what you do, whatever you do is going to become part of a much larger system. Unless global trade stops, there will be, when you try to create international norms in one part, it will have to form itself into a system that works for global trade. And that means there's going to be, in a case like this, where there's an attempt to create uniform international commercial norms, there's going to have to be this interesting and difficult interaction between those norms and domestic law. And that's what we want to talk about. We want to talk about what has been one of the most challenging areas in the application and interpretation of the CISG, its relationship with domestic law. And we want to give you a bunch of examples of the way that there has been interesting issues that have arisen, and then talk about maybe some of the longer-term implications that arise from this discussion. So let us get to it. We're going to talk about it, it's the idea that it's an enclave of uniform international transnational law, in a continent of non-uniform national law. Yeah, that's pretty much a pretty good description of what happens with the thing. And there are at least 3 different kinds of borders that are disputed about just where the CISG ends and domestic law begins. And we're going to take them up one at a time. The first border that we want to talk about is the borders that are articulated expressly in the CISG itself. So, for example, in Article 4 of the CISG, matters of the validity of a sales contract and questions of the sales contract effect on the property and the goods are excluded from the reach of the convention. There are other express exclusions from the reach of the convention, including, for example, in Article 5, which excludes questions of the seller's liability for death or personal injury that are caused by the goods. But we're going to talk about these 2 particular exclusions, the validity exclusion and an exclusion of property issues, as an example of the border disputes that occur in this particular area. So I'm going to have Jack talk about the first one.
Thanks. It's important to remember that the reason for most of these exclusions, that the drafters of the CISG couldn't agree on them. To get a deal done, essentially they had to say, we're not going to address these issues. One of them was validity. And this is a perfect example. Penal fixed sums. Most of you remember from contracts that under the common law, we're perfectly willing to enforce a good faith attempt to liquidate damages of an uncertain amount. But we don't enforce penalties that are intended to deter breach. Now, we could debate all day long what the right rule is, but that's the common law rule. I think we would all agree. In contrast, in a civil law regime, we enforce fixed sums, be they liquidated damages or penal clauses. Now, if something is obscenely high, even as a penalty, we may not enforce it under a civil law regime, but we enforce penalties, no problem. So what do we do in a transaction governed by the CISG? CISG essentially says, you know what, Article 4, this is a validity issue. Different legal systems handle it differently. We're going to leave it to those legal systems. So what do? We look to the rules of private international law. If the transaction would point to German domestic law, absent the CISG, we probably enforce the penal fixed sum. If it would point to the law of some U.S. state, absent the CISG, we don't enforce a penal sum. Pretty clear, pretty simple. Now, that said, everybody wants uniform law. So in the interest of uniformity, some commentators on the CISG, generally continental European commentators, said, you know, in fact, we think under the CISG, penal fixed sums are enforceable. Now, there's a whole host of reasons why I think that's wrong. And fortunately, you don't need for me to talk about all of them today, because it's actually published in the Journal of Law and Commerce. So right here at Pittsburgh, so you can read my article on penal sums if you want to see the whole thing. But for today, the one point I want to focus on is one of the arguments is, well, even though we agree that validity is not governed by the CISG, validity issues are outside the scope, when we go to domestic law, such as the law of Pennsylvania, which has adopted UCC 2718, which says penalties are void, we should actually interpret it through the lens of international norms, which, by the way, we think would enforce penal sums. in effect, we're saying, you know, we're going to go to the CISG to reinterpret your domestic law. To me, uniformity is a noble cause, but not when we torture our domestic law in order to claim we're following the CISG. To me, that's just as bad as using our domestic law to interpret the CISG, which is a problem we'll deal with in a couple of slides.
And I realized when I did that we had discussed this ahead of time, and Jack told me, boy, I hate handheld mics. Let me use the mic on the lectern. And I made him use this, so sorry about that. Well, another of the issues that are expressly excluded from the reach of the CISG are issues concerning the effect of a contract for sale on the property in the goods. Property issues, as Jack mentioned, are one of those things that really there are enough differences. They could not reach consensus in 1980 when the UN Sales Convention was being put together on this kind of question. You know, the kind of issues like, you know, can a thief transfer good title to goods to a good faith buyer? Situations like that. Those were going to be things that different countries had the traditions were too different. It was just going to be too hard to handle these things, and there might be distinctions in types of property rendered by different domestic systems. So the heck with it. We're not going to try and bring uniformity, despite the advantages of having a uniform international regime. We're not going to try to bring uniformity to this particular area connected to sales law, property. But once again, whenever you carve out something like that, it creates these kinds of issues. Just how far have we gone? So there's a provision towards the end of the convention that says that if a party is in possession of property that it must preserve for the other side, for example, if the buyer takes delivery of goods that it then discovers are horrible, that breach the seller's obligations in a big way, the buyer can do what's called avoid the contract. And that's supposed to result in basically the undoing of the contract. The buyer's supposed to give back the goods, the seller's supposed to give back the money the buyer paid, and you'll have some further remedies after that. But in the meantime, the buyer has a hold of goods which are essentially the seller's goods at this point, so the buyer's under an obligation to preserve them. After a while, with the passage of time, however, the idea of preserving goods, like sticking them in a warehouse and keeping them good, can become very expensive. And some goods you can't preserve for very long. You know, you're selling fresh cut flowers, you don't preserve them for very long as fresh cut flowers. So Article 88 in some cases authorizes, and in other cases mandates, that the buyer, and I'm just giving the example of a buyer, in that kind of situation, must sell the goods on behalf of the other side. Mandates that in many cases, but requires it in others. The problem, of course, is that this is a mandate of the CISG, but the CISG does not empower the buyer, expressly at any rate, to transfer title to the party who is buying at this sale that the CISG mandates. So, in fact, the CISG could, those questions of the effect of that sale on property, in most people's view at any rate, would be governed by applicable domestic law at that point. But applicable domestic law may say that the buyer in reselling the goods doesn't have the right to transfer good title to these goods to the buyer. So the CISG could be, by this amalgam of international rules and local rules, end up mandating a party to do what it can't do, in fact, mandating a party to end up breaching a contract that the convention requires it to enter into. So I am I'm working on a revision of a commentary and dealing with this, and I kind of say, well, this is an area where we really we have to have uniform laws, kind of by implication of what the CISG does. And can we work it out, at any rate, that the CISG itself authorizes that a buyer in that circumstance can at least transfer whatever title that its seller had. It can act as, in effect, the agent in the sale for transferring the seller's title. Maybe that's not enough of a property issue, that it's outside the scope of the CISG, because if you don't do that, you could have some big troubles coming down the line. Another one of these uneasy relationships between CISG and domestic law, and figuring out exactly where the CISG should end and the domestic law should pick up. So those are a couple of examples of these express exclusions from the reach of the CISG. There are unexpressed borders between the CISG and law, and they are basically unexpressed because they were kind of too basic almost to express. The CISG is about substantive sales law. It doesn't create a court system. It doesn't create a procedural system. It doesn't create a banking system. It doesn't create a system for moving goods by itself. It's focusing on something which kind of everybody understood. They kind of knew what it was focusing on. But it turns out there are all kinds of difficult border disputes in that particular area. I will take the first one of these because it's one of my favorites. The distinction between the substantive sales law that is governed by the CISG and procedural rules. And there are all kinds of arguments about this. For example, does the CISG govern the question of who has the burden of proving, for example, a breach of the seller's obligations concerning the quality of the goods? Does it deal with that burden of proof issue, which lies right on the borderline between substantive sales law and procedural law? And there are a series of things mentioned up there that in which people have disagreed about whether the CISG governs these things, these kinds of matters or not. Almost everybody else in the world at this point, except me, thinks that the CISG does in fact govern questions of burden of proof. The way it works is there's nothing express except in one particular provision about burden of proof in the CISG. But where you have something governed by the CISG that's not supposed to be, that isn't expressly handled in it, you're supposed to, first of all, try to fill that gap by looking for general principles in the CISG, and only if you can't find those general principles, then you resort to applicable domestic law. And there are a group of people who are quite adept at finding general principles, and on the basis of one provision, which isn't very clear about this, have derived a whole system of burden of proof rules that are said to be governed by the CISG. The German Bundesgerichtshof, the highest court with jurisdiction on these kinds of matters, in fact, had a situation where the party who would normally not have the burden of proof was particularly, had much better access to the proof on the issue than did the party who didn't have the burden of proof. And there's a German domestic burden of proof principle called Beweisnähe, which switches the burden of proof in that particular situation. And the German Bundesgerichtshof declared, well, the CISG contains the Beweisnähe principle too, which of course is, well, couldn't actually cite anything in the CISG for that, except the fact that it was reasonable, and that seems to be a general principle of the CISG. Forgot to mention that it's kind of in systems like that in the United States where we rely on a discovery system, this Beweisnähe principle doesn't really work. Our system is, you know, if the other side has the proof, we'll let you discover it. And if you can't discover anything, you still have the burden of proof and you're going to fail. So the Beweisnähe principle, which is found to be part of the CISG and thus binding on the United States as a matter of treaty law by the German court, just doesn't work in the US system. So another example, I think, of this very difficult relationship between international uniform rules in the commercial area and applicable domestic law. You got another one, Jack.
No problem. And also looking at procedural issues, I'll talk about my other passion besides international commercial law, and that's international commercial arbitration. The interpreting an arbitration clause within a sales contract. And there's actually a classic CISG case that most of us who teach the CISG deal with. It's Filanto versus Chiliwich. It's an early case. And one of the reasons we talk about it is because Judge Briant in the federal court in New York is really unhappy about the CISG, and in fact blames the State Department for fixing a problem that didn't exist. But he also spends pages and pages, and if you've read it, it's pages and pages, goes through this tortured analysis of trying to figure out what to do about this battle of forms under the CISG in Article 19. And in fact, the CISG doesn't govern the issue at all because he makes the point. The sole question before him was whether the parties had agreed to arbitrate. And an arbitration agreement is fully separable from the sales contract in which it's contained. In fact, arguably, it's not even unexpressed. It's expressed in Article 81 because avoidance doesn't touch the arbitration provision. So you could even say it's almost expressed. But he nonetheless goes through all of this tortured analysis trying to figure out what U.S. law to apply to this question when, in fact, the question was whether the parties had agreed to arbitrate in Russia. And he should have been applying Russian contract law. So again, the this issue is even in a transaction governed by the CISG, there are going to be some questions it not only can't but shouldn't answer, and a classic procedural issue is where the parties have agreed, for example, to arbitration. And that's not governed by the CISG.
Another issue in this area is the fact that CISG is contract law, sales law in particular. It's not tort law. And the borderline between tort law and contract law can be, as everyone can attest, pretty blurry. So, for example, there is the issue where there are domestic legal systems around the world that identifying the rules as tort rules allow recovery of property damage without proof of any fault on the part of the party calling it, kind of a strict liability for property damage regime. And the question there is, well, can you base that in, does the CISG preempt those domestic rules? Because it's got its own set of liability rules for damage to property not caused through the fault of the party. Does it preempt those domestic rules, or do they continue to survive? And no one is quite sure about that particular issue too. And so no one is even quite sure about what domestic law is left once the CISG comes in. There is another area which is perhaps the most controversial, which I have called about internal borders. I have already mentioned the way that the CISG handles questions that are within its scope, but for which it doesn't provide an express rule. And the rule is that, is found in Article 7.2 of the CISG, that if you have an issue that is a matter governed by the CISG, but you don't have a rule to figure it out, first you're supposed to try to derive a rule based upon the general principles upon which the CISG is based, and failing that, you turn to applicable domestic law to solve the issue. These matters governed by the CISG, but not actually, for which there isn't actually a rule, are usually designated as so-called internal gaps that are subject to this two-step gap-filling procedure. Well, the issue has arisen concerning civil law hardship doctrine. Civil law hardship doctrine is an interesting thing. It's not quite like what we in the common law are used to in terms of impossibility and practicability, excuses like that. It deals with the same kind of situation where something unexpected happens after a contract is entered into that the parties really hadn't contemplated, and it renders one party's performance very hard. It renders one party's performance very difficult, maybe very, very expensive. The situation may result in hardship. And in that case, under traditional civil law hardship doctrine, the parties are first of all under a mandate to negotiate to see whether they can solve it on their own. And if those negotiations fail, then you can go to court, and the court can either declare the contract basically rescinded, declare the contract voided, and the parties will just go their merry way, which would be the same result you would get under impossibility or impracticability doctrine in the U.S. Or, and this is the one that is very uncomfortable for contract common law people, the court can adapt the contract. That is, it can come up with new provisions of the contract to which the parties have not agreed and just say, okay, here's your new contract provisions. And that makes common lawyers pretty darn uncomfortable. The old saying that the judge's job is not to make a contract for the parties, but to enforce the contract the parties are, seems to be violated by this. And there was discussion during the negotiation of the CISG about whether hardship, and particularly the contract adjustment features of the hardship doctrine, would be included, and they weren't. There were proposals that were rejected. Nevertheless, when the issue came up, and this was a fairly recent Belgian case, where there was one of the sellers' inventory needs, steel for this particular product, massively increased in price, and the seller claimed hardship and actually got a Belgian court to adapt the terms of the contract by raising the price of the goods by, it was almost €500,000 that was imposed, to which the buyer had never actually agreed to pay, but now is under a mandate to do it. It got appealed up to the highest court in Belgium. The highest court in Belgium says, oh, yeah, hardship doctrines and the adjustment of contract terms are, in fact, a general principle of the convention, even though that was explicitly rejected during the course of the negotiations, and there is nothing anywhere in the convention that allows courts to impose contract terms. And it did so on the basis that another set of principles, non-binding principles, kind of an international restatement of contract, the UNIDROIT principles of international commercial contracts, include a hardship doctrine. And the idea was, well, these all must be principles that also underlie the convention. The fact is, this is one of those examples where there was no gap to fill. The CISG had decided that they weren't going to have special rules allowing contract adaptation, so the court was filling a gap through this process that didn't even exist, but ended up filling it with, lo and behold, the domestic law with which it was familiar, and that's always a danger in this area. So this is a particular problem. You got another example?
I want to pick up on yours, and I'm going to try something that's probably a bad idea, but I'm going to do it anyway. I'm going to try to think out loud in front of a group with something I've just been mulling over the last few hours. I agree with Harry on being appalled at the Belgian case and the use of hardship doctrine. It's not in the general principle. So how does this happen? I think part of this has to do with, we talk about approaches to statutory interpretation and the search for general principles. The problem is, as long as we think of the CISG as a statute, and I agree that it is, but as long as we conceptualize it that way when we're applying Article 7.2, if you're a common lawyer and you think about general principles to interpret a statute, what's that? It's the common, you think about general principles to interpret a statute, you look to the common law, because we think of statutes as islands on a sea of common law. In fact, that's expressly addressed in UCC Article 2. If you find the answer in Article 2, apply it. If you don't, go to Article 1. If you find the answer in Article 1, apply it. If you don't, go to the common law. So this idea of, if we don't find the answer in the statute, go to the common law is really embedded in our jurisprudential thinking. In contrast, the civilian knows these statutory islands are not islands at all. They're all there is. There is no sea surrounding it. If you don't find the answer in the statute, look harder and look at the foundation underneath the statute. Look for general principles. So if you are an American lawyer or judge looking for general principles, we've all seen what they do. They go to UCC Article 2 or the common law. They go right to domestic law to try to figure out what we think we call general principles. That's wrong under Article 7.2, but it's also natural. What do the Europeans do? What the Europeans do isn't as obviously wrong, but I think it's just as wrong. They look for general principles. Well, where do they find general principles? They find them where they're used to finding them. They find them in the general principles of the civil code. Just as problematic, they're going to their own domestic law. Harry and I know, both agree that the general principles discussed in Article 2 are the general principles found in the convention itself, period. Either in the language of the convention or at most in the travaux préparatoire, the legislative history, but not anywhere else, not in the UNIDROIT principles. So what is it? How do we get there? It seems to me that if you look at the convention as a contract between contracting states and take a purposive approach to interpreting a contract, what can we derive about the purpose of the contract from the contract itself? Maybe from the parties' negotiations, but nowhere else. That's where we find our general principles. And if we take that approach, almost a contract approach, even though this is a statute, then I think we will properly limit ourselves to the convention itself. If we want to determine whether estoppel is a general principle, find it in the convention. I think you can. Others may disagree, but the point is the search should be in the convention and not other areas. And then both common lawyers and civil lawyers will stick to the convention.
Well, we have just a little bit of time left for, of course, the biggest question, which is what does all this mean? What is all this going to do? The question really here is, this is one of the most salient examples of the challenges that have faced the convention when it came out. And the ultimate question is the convention a success at this point in time? It was, the text was finalized in 1980, it went into force in 1988. Is it a success? And I know, Jack, you have an opinion on that, so why don't you give us your opinion?
In the first of the 30th anniversary CISG conferences in DC, they asked me, so in front of the Secretary of UNCITRAL, I said, I think the convention today in the United States is a failure. By any reasonable measure. I said, I remain hopeful that it will ultimately be successful, but I think that outcome is very much in doubt. And I think the problem is that, one, it's a matter of education. Far too many lawyers have no idea about the CISG, and the only thing they know is that they want to opt out without having any idea whether it benefits their client. Harry and I know both teach that, obsessively to our students. But I think it's also just really, the CISG isn't just different from UCC Article 2, but I think it's more like a civil law statute than it is like a common law statute. It's got elements of both, but I think it's more like a civil law statute. So it's almost like we've got to relearn how to interpret and apply a code in order to apply it properly. I hope we're up to it, but I'm still skeptical.
So he was distinguished up to that point, at any rate. I want to disagree, but only at a certain level. I think it's quite clear that the CISG, parties can opt out of the CISG, and that is when they are advised by lawyers what they do in the United States. That's what they do in Germany. The studies have shown that tends to be what happens. The CISG ends up being applicable by inadvertence because nobody consulted the lawyer who told them to opt out. Right? I don't think that makes it a failure. And the reason I don't think it makes it a failure is because this was an incredible challenge to try to create uniform global rules on this really important area of law, and not just that bridge the gap between common law and civil law countries, but bridge the gap between domestic systems that can't be categorized in that fashion whatsoever. And it's amazing what has happened as a result of this. The use of the web as a way to create uniform understandings of a text between parties with entirely different backgrounds. It's astonishing the resources that are developed from that, and that's all a success. It may be in the end that in another 100 years we'll need to come up with another CISG, and maybe that one will actually be used by people, but it will be built on what we did already today, and I see we're basically out of time, but I hope maybe there's a question.
If I could get one last one. And I do hope it becomes a success. In fact, I've written a basic contracts case book that teaches more about the CISG than I think any other one out there. So I haven't given up. I don't want to give you that impression. But I just think we got a long way to go.
Do we have time for anything?
I'm going to keep us on time here, and we're going to break. We've covered cyberspace, privacy, Islamic law, Ebola, refugee rights, and the CISG. You might think, what else could be left? Well, let me tell you, there's more. So we're going to take 15 minutes. We will start at 3:45, but right now we're going to thank Professor Flechter and Professor Graves. Property and the Future of Knowledge Commons with Professor Mike Madison from the University of Pittsburgh and his colleague, Professor Laura Pedraza Farina from Northwestern University.
Okay. Thank you, Ron, and thanks to CILE for the invitation to be part of this great program. I do not have slides, but I have show and tell. So I am here to talk a bit about this book and the research project that it represents. I will give a brief overview of what the book project represents, and then introduce my colleague who will talk about her work that is related to this. So this is a research project that we refer to as the Knowledge Commons Project. It is sort of international in the sense that anytime you talk about knowledge and information and their regulation and legal structures relating to those, it is sort of inherently an international topic, and we have an international connection that we'll talk about. I should say at the outset, I have two co-authors, two co-conspirators in producing this, Kathy Strandberg, who is a law professor at NYU in New York, and Brett Frischman, who is at Cardozo Law School. And we have been producing work in this area for about 10 years. And so everything that I say is shared, for better or for worse, with them. The point of the research project is about the role of law in social context, and I really want to emphasize the intersection between law and social context in this case. Intellectual property lawyers and intellectual property researchers rely on a standard story to explain the existence of IP law and the scope of IP laws. That standard story is captured in the phrase that you've no doubt heard, the tragedy of the commons. The idea is that society wants the production of innovative things, the society wants the production of creative things, but for reasons relating to the character of intangible information and intangible knowledge, we're not likely to get enough of that material unless one of two things happens. Either we have formal property rights through IP law that give people legal protection and security for what they create, or, on the other hand, governments or the state intervene and either supply the material directly or finance the supply of these things directly. So there is a middle ground between these two extremes of private property rights and government supply, things that are blends of public rules, public order, private markets, private rights, social norms, technology regulation, other things that are formal and informal in common. They are widely known to exist. We call them governance of shared resources, but they are not well understood as a matter of research. And just to give you a quick example of what I'm talking about, in a setting like this, I always point to something like a university. A university is a brilliant example of an environment, an institutional environment, where sharing knowledge, sharing creativity, sharing innovation is the norm. Very few people inside a university expect to retain and own things that they create. In fact, sharing both at the macro level throughout the university and sharing at a micro level, like in a conference such as this, is in fact the way we generate new knowledge and the way we generate new information, and it's a good thing, not an exceptional thing. So what we propose to do in our research project is to document instances like these throughout the world, throughout history, throughout market sectors and other areas of activity in a sustained, systematic research framework. So we're inspired by the work of Nobel Prize winner Elinor Ostrom, who was an economist and political scientist at Indiana University. She won the Nobel Prize in Economics in 2009. She developed a comprehensive research program for which she won the Nobel Prize, studying collective governance of shared natural resources, fisheries, water systems, forests, pasturage, and so forth around the world. We've developed a research program that is aligned with hers in style and spirit, that is systematically studying what we call knowledge commons, collective governance of shared knowledge resources, as opposed to governance of natural resources. And in our framework, knowledge commons are not tragic, knowledge commons are potentially productive. So the result of putting together this research project and the research framework that we documented is this book, which is the result of sort of 8 years of work and preliminary papers and book chapters and so forth. This was published, Governing Knowledge Commons, In 2014, published by Oxford University Press, we have 3 chapters of theory about the research framework, what motivates us and what we expect to learn, and then there are 11 case studies sort of proving the concept that this research framework actually works, and it documents sustained knowledge commons across a very broad range of scientific, technical, and cultural activity, everything from medical research to astrophysics to open source computer software to windsurfers and rollerblades, all the way out to legislative activity as such, and even including a chapter on something called roller derby. There is a second book called Governing Medical Research Commons, where we are now in production at Cambridge University Press. Laura has contributed a chapter of original research to that book, and we have a contract to produce 4 more collections of case studies after the Medical Research Commons book is published. Those will be thematic, like the Medical Research Commons book is. So we're expecting to produce works collecting case studies in the area of information technology, in the area of environmental policy, in all likelihood a book of case studies around education and higher education in particular. And there is sort of an essentially open-ended and completely sort of a lifetime's worth of work for the 3 of us and everybody else that we're trying to recruit around the world to make this an important and high-impact research project. The significance of the work is twofold. In part, the significance is that this is really the creation of a brand new and potentially quite large and potentially quite high-impact field of research, not only in the US and not only with respect to domestic intellectual property law, but around the world. So there is a lot of interest in this area of collaborative governance and shared resources in Europe in particular, and somewhat in Asia. There have been 2 global conferences so far on knowledge commons. The first was in Belgium. The last one we hosted at NYU. The next one is in the fall of 2016 at Sciences Po in Paris through a research grant that is, has gone to my colleague Séverine de Solier at Sciences Po. We have been presenting the work in Asia as well as around the EU and around the US, so we are just really thrilled by the reception of this thing altogether within the scope of IP. Second, there is a pronounced trend within IP scholarship in the US and beyond towards more empirical investigation of the mechanics of IP systems, whether we really need them, in what respect do we need them, how successful are they, what are the trade-offs associated with IP. And there is a related trend in the IP scholarship away from a research focus on the role of the individual and the role of the individual firm as an agent or as an actor within markets, and instead a new interest and focus on institutions, both formal institutions and informal groups, which are not generally terribly well understood, particularly within IP law, but I think more broadly within legal analysis as a whole. So that's the moment where I'm going to stop my setup and I'm going to hand the podium over to Laura, because that intersection between not only knowledge commons but formal institutions and informal groups in general, how those work within IP systems, that's her area of research, so she is going to talk about that. Thank you.
Well, thank you so much for inviting me. It's an honor to be here, to be part of this 20th anniversary. So I think that's better. So today I want to talk about two broad things, make 2 points. The first, I want to tell you how my own trajectory as a scholar, how I came in contact with the Commons work and how I have used their framework productively in my research going forward. And the second one is I want to explore a little bit how this Commons research really has been very transformative to the world of IP scholarship, and it has given us a different way to begin to understand how institutions and informal groups use both informal norms and also more formal levers such as patent law and grants in order to disseminate and produce knowledge. So let me start by telling you my path to being part of this Commons group. So in 2013, I wrote an article that I titled Patent Law and the Sociology of Innovation. And I was inspired to write this article by work in the sociology of science. And in particular, there's one focus that sociology of science has that I thought was lacking in patent law scholarship. And sociology of science is complex, but the main take-home message of most of the work there is that in order to understand the timing of scientific discovery, so why does one discovery happen one day and not before, and in order to understand the context of scientific discoveries, we really need to understand the scientific communities in which scientists are embedded and the social norms that are part of those scientific communities and how those scientific communities interact with each other. And this insight is important for patent law because you have to understanding in the context and in contrast to how courts have traditionally understood the inventive process in the context of patent law. So in patent law, there's a figure of the inventor or the person having ordinary skill in the art. And that figure has a cognitive model of innovation as opposed to a sociological model. And the idea is that you focus on what's going on in the head of the inventor and the cognitive abilities of somebody to make or not make an invention. And this construct, the person of ordinary skill in the art, drives a lot of tests in patent law. So what I was trying to do is to say, well, this construct is not completely right as a way of describing how scientific advances happen. We need to understand communities of scientists. And let me tell you a little bit more about what I mean by that. So when I say that scientific discoveries are relational, what sociologists of science have found is that a lot of discoveries, and in particular really breakthrough discoveries, happen at the interaction of two communities. But at the same time, so interactions between communities can be a catalyst for innovation, and at the same time, lack of interaction or barriers to interaction, very real social barriers to interaction, can be things that retard innovation. So let me give you some particular examples. So interactions between communities and among communities of practice can be a catalyst for innovation. Example, a discovery of DNA is a very sort of well-known example in sort of sociology of science circles. It would not have happened had physicists not migrated and taken with them ways of viewing the world, for example, quantum mechanic models of the world, and taken with them tools such as X-ray diffraction, which was before used only for inorganic materials, and used that to study DNA. So it's a classic example in which a huge discovery happened because migration from one community was applied to another community. Now, there are many, many classic examples in which discovery was delayed. So if you look at two fields, you say, well, why didn't this happen earlier? The knowledge was there in the two fields. And those are the potentially more interesting examples to try to figure out, well, how can you sort of lower those barriers? And well, those barriers are sociological barriers many times. And what I mean by sociological barriers is scientists in communities get socialized into having particular types of tools that they consider are the best tools for the job, particular types of questions and research agendas that are more important, and also a particular resistance to approaches from other disciplines. And I'm not going to give you many examples of that, just but one bioengineering, which we know now is a huge field, there's studies in sociology showing that it could have happened much earlier had it not been for this type of barriers. And then in my paper, I just talked about, well, patent law can be tweaked in order to accommodate for this different view of innovation that's not focused on the individual inventor, but in these communities. And hopefully you can see from this description of my initial research that there's a lot in common with the commons projects, right? So I am trying to say that we need to understand the social context of innovation, and that's exactly what the people in the knowledge commons are trying to do. So I got invited to be part of the second book, the book on medical innovation, and there I became much more familiar with the commons approach to studying these groups of innovators, and I started incorporating into my own work. So what I want to do with the time that I have left is turn to the importance of the commons work for just our understanding of IP, and then some current research that I've been doing applying this work. As Mike talked about in his presentation, we tended to think in intellectual property about the world organized either around having intellectual property protection as fixing the problem of free riding, or having government subsidy as the two ways in which you actually get innovation. But what ended up happening in the 2000s is that a lot of scholars were beginning to describe collectives. For example, Wikipedia would be a very good example of those, in which there's no IP rights. There's no government subsidy, yet you have this very free and robust sharing and creation of information. So the first important insight of the Knowledge Commons framework is, well, what does the world really look like? If this is true, if there are a lot of communities that are creating information without what we traditionally think have to be this incentive, let's describe those communities in a systematic way to understand when they're successful and when they're not, and how they are successful. The second important contribution, I think, is that they introduced also the concept of the semi-commons. And the idea is that many times in reality, you have a combination of all sorts of different methods to innovate. You have informal norms, but then you also have IP protection. For example, the university, we have a lot of knowledge sharing, but we are using also patent protection as a way to incentivize innovation. And of course, government grants. So how do all of these incentive systems work together? And then the third one, which is very important, is providing us with a framework for analysis. And I just want to give you a flavor, because framework tends to, what do I mean by a framework? Well, it's a very important guide to conducting qualitative research interviews for groups of innovators that allows different people working on different communities to then compare their findings in a way that's potentially generalizable. So for example, these are the types of questions that you would be asking if you're using a commons framework. You would want to know, for example, what are the relevant communities that are involved in making knowledge? What type of resources are those communities exchanging? Are they creating products? Are they exchanging know-how? Are they exchanging information? What type of infrastructure do they have? Are they open? Are they closed? Are they somewhere in between? So Wikipedia is completely open. The public, I can just access it. I don't need to pay. I don't need to do anything. Other commons might be more closed. How do you become a member? What's the motivation for members to be members? And are there any barriers to memberships? And then governance. Is there a free riding problem? And if there is, how do you enforce compliance? How do you make sure that people don't take advantage of other people's work? And then finally, what's the role of patents, grants, and other more formal ways of organizing knowledge? So now let me just close by basically describing how I have taken this framework to continue my interest in understanding interdisciplinary collaborations and done it to produce data that now can be compared with other studies on medical commons. So going back to what I talked about in the beginning about the importance of understanding that science happens in communities and that the interaction between communities is incredibly important for the advancement of science, but that often interaction is tricky, and potentially you could see that it's tricky in multiple domains, not just in science, right? Coordination of different disciplines is tricky in general. So I was interested in understanding, okay, well, if we're going to study knowledge commons, it will be very interesting to study commons in which that was the problem that had to be solved, the coordination problem of interdisciplinary collaboration. Let's try to study commons that are set up to do that and understand how they have been successful and how have they not been successful. So I'm doing a research project looking at a very interesting program that the NIH had. So the NIH came up with a program in which they asked the scientific community, tell us what are your most intractable problems and how are you going to resolve them using interdisciplinary teams. So the most intractable problems that require teams to be resolved and that require multiple NIH institutes to coordinate with each other. Give us proposals and we'll fund a subset of those research consortia with money to create interdisciplinary teams. There were 8 of these teams that were funded. And I'm looking at one of these teams to begin with. My idea is to sort of look at all of the 8 consortia. And all of these consortia have in common that they bring people from different disciplines that at some point or another were not interacting with each other. That was the hurdle. I'm studying a consortium that's called the Oncofertility Consortium. Oncofertility actually was a new word that was created to describe this consortium. And the key problem that they were trying to solve was communication between oncologists, endocrinologists, and basic scientists. Women who were having, and this is mainly for women, for male there were fertility preservation techniques, but women who were having a cancer diagnosis back in 2003 and before were almost never given fertility counsels. And there was a big gap in understanding how chemotherapy affected fertility. And there was, in part because there was no collaboration. Endocrinologists were just not talking to oncologists, and endocrinologists were completely not set up for doing emergency procedures in cancer patients. And so I went out, and so they have this grant, and in this grant they set up a collaboration and a system so that dialogue can happen. I won't go into the details of the consortium because it would take too long, but I want to leave you with sort of 4 things that I found as to why that consortium was incredibly successful. And it has been incredibly successful. They have fertility preservation centers everywhere, and right now, you'll be hard-pressed to find an oncologist who doesn't discuss fertility with their patients, where when they started, they were close to 0, right? So it was a successful consortium according to their own goals. So what did I find? So let me just quickly go through 4 things so that we have time for questions. Number 1 is the importance of a pre-existing social network with high levels of trust coordinated around a high-status intellectual actor. So that's a bit of a mouthful. What do I mean by that? Most of the people that I interviewed, or all of the people that I interviewed, credited Dr. Teresa Woodruff, who was the main principal investigator in this grant, who invested a lot of her own social capital and brought together people from different disciplines that she basically already knew, were part of her pre-existing social network, and had a high level of trust in her. And what was interesting about this is that led to a lot of data sharing, very open data sharing among a core group of people. And then that trickled down to the rest of the consortium, creating a norm of openness, creating what I like to call a virtuous cycle of collaboration. And what was very interesting was that very seasoned scientists, sort of, you would think skeptical scientists because they're seasoned, skeptical about the process. Every scientist that I spoke with talked about this experience as one of the most exciting experiences in their own career. So once they could get rid of the hurdles of sharing, actually sharing and collaborating across disciplines is itself an intrinsic motivator. And let me just read you a quote from one of the scientists that I interviewed. And this is somebody who's been in science for 40 years, right? And she said, that's the perfect word, excitement, encouragement. Amazing is a very overused word, but that says it as well. So you do your research in your lab, and it's pretty specialized and pretty basic, and you get together with your big professional society every year to talk about your results, and you're kind of, this little fish swimming around this big pond. But you're part of the same ecosystem and making these little advances that are still important. And then you get to this consortium, where you have access to all of these people in different areas and even outside of the science. This was not something just to get a paper. That was part of it, but it taught me to look at doing science in a different way and having a vision in my mind all the time that, yes, I'm tired, but I know that this is going to help somebody someday. I have a really personal connection and feeling about that. This is representative of the fact that collaboration, when it's managed well, can lead to a lot of intrinsic motivation to produce and share. Number 2, the importance of monthly face-to-face research meetings. Those who are having face-to-face and frequent communication was important. And finally, I'll talk about 3, because I want to make sure I have 5 minutes for questions. It was very interesting to see there was a clash between the NIH coordination and the coordination of the scientists. The bottom line was that that's something that should be explored in the future. NIH coordination was very, very hard. There were lots of formal mechanisms of coordination that failed. Scientific coordination worked quite well, in part because it was informal and centralized. And let me close by saying that the first 2 findings, a pre-existing social network, a high-status intellectual actor, and face-to-face meetings have been replicated in many different other studies. So it looks like the ingredients for successful collaboration could potentially be generalized, in part thanks to the framework of the knowledge commons. And I will end right there.
Let me emphasize 2 quick points, then we'll open up maybe a question or 2. One is we try to model ourselves as a research group as a commons ourselves. We are very explicitly open in at least 2 important dimensions. One, we're open in terms of disciplines. So our research group, we have lawyers, Laura was too modest to say, and the biography does not include the fact that she has a PhD in genetics, so she comes to the scientific research authentically. We have lawyers, we have economists, we have historians, we have sociologists, we have political scientists. So the research framework is flexible enough that we've basically established a common language that all of these different fields can speak to each other in an intelligible way. It's also open in a geographic sense. So we have active researchers who are part of the book projects from the US, of course, the UK, Belgium, Netherlands, Germany, Italy, Spain, and we're always, almost every week, I'm getting contacted by more people who are wanting to learn more about this, graduate students as well as faculty members at law schools and elsewhere around the world. So this is one of the reasons that we're as excited for our own research as Laura was explaining, the physician researchers are excited within the context of the Oncofertility Project itself. It's really, really inspiring to see your own work inspire other faculty, colleagues, and researchers around the world and sort of build a research enterprise from the ground up this way, and to have it modeled more like a social science research project in the sense that we have a method for collecting data both historically and in terms of contemporary application, gathering the data, documenting what you're doing, and then having a protocol for doing eventually comparative analysis on a systematic basis, which is not the way that legal research and legal scholarship traditionally has been performed. So this is, again, another way in which we think that we're modeling sort of a new frontier in what's going on. So I'll stop talking, and maybe we have a moment for a question or two.
Y'all mentioned how today you look at the internet and how there's all this knowledge out there that nobody's paying for, nobody's sponsoring, nobody's necessarily making money off of by being able to patent it and whatnot. My question is, and it might apply to some of the characteristics that you're discussing that are factors of what can be successful collaboration. But is there kind of do you see a link between the value that somebody else has independently placed on it? You've applied for a grant and said we're going to do this type, seek this type of knowledge, where you don't have that if you're in kind of like an open, crowdsourcing, internet-based exchange of ideas. Do you see that there is a collaboration between somebody being able to invest in patent, get a patent on something, or be able to get a grant for something, versus, or are there other ways that you could apply, certain types of standards so that you can develop high-level knowledge creation online that does not require that type of independent kind of acceptance that there is an innate value in it? If that makes sense.
So it's hard to answer a question like that in the abstract, and sort of right, because it's very broad and it covers a lot of potential applications. So I think that's one of the points of our project, is that these are very case-specific, context-specific analysis, and what we're really trying to do is uncover some of the latent social structures as well as some of the legal structures that are applicable to crowdsourcing of this, or music production, or Wikipedia, which actually has a latent social structure and a formal governance structure. It's not, the internet is not always just a free-for-all. There's actually informal rules and norms as well as formal stuff. And what we're trying to do in many cases is document what's going on. And it's not always the case that it's a happy everybody wins at the end of the day kind of story. Sometimes it is a tragic story, and then there's regulatory intervention is appropriate. And so we're trying to document what are the variables that push in one direction, what are the variables that push in another direction, and it's only by collecting enough data across a number of cases where you can really say, here are the common threads. So Laura talked a little bit about, in the case study that she did, some of the key things that seem to be salient. I wrote a case study about an astrophysics collaborative online. So I got one of the luxuries of this area of research is that you really get to dive in like a lawyer does into things that you know nothing about. I know nothing about astrophysics except now what I know, which is that there's an online, crowdsourced, citizen science astrophysics collaborative out there. It's called Galaxy Zoo. For those of you who want to teach your adolescents and your teenagers or your grandparents, Galaxy Zoo. It's awesome. Tens of thousands of people freely contributing their labor online to the production of new astrophysics knowledge with some expert supervision. Yeah. So it's very in parallel to what Laura was talking about. So it's a free exchange of knowledge, exactly in the way that you're talking about, but there's a structure to it. Not a purely hierarchical structure, and there's no money being exchanged, but there's a way to document why it's working and what the trade-offs are.
And let me add, so it's very clear that there are many communities that don't use the traditional, don't use patents, don't use grants, don't use, right? And like one of the things that we're trying to document is like, well, how do those communities function? And a big thing is intrinsic motivation, right? Like people are motivated to do things, especially if you don't ask them to do a lot, right? So crowdsourcing, if you're just doing, or using gaming, like so a lot of ideas of using gaming principles. There's a group that's doing protein structure that they actually have gotten better protein structures than the experts as a game. So right, like what fits in here, and it turns out that some people are very good at that. It's just, so it's clear that there can be intrinsic motivations that can be very good at getting results. But then you do need some structure on top of that, and we're finding you always have some structure. You always have some people that make decisions, some form of hierarchy. That even even in Wikipedia you have that. Yeah.
I'm going to
yeah.
very quickly.
1 minute out of my own time. I yield 1 minute of my own time in the next talk at some risk, but this is a follow-up actually to the question. You mentioned 4 different elements that you had sort of itemized as possibly a pathway to success. Mm-hmm. And the first seemed to be that it is often important, this gets back to hierarchy and structure, it's often important that someone quite already distinguished in the field opts into this kind of, it's really risky, particularly from the point of view of someone who's already enormously successful, decides to opt into what I will call this multidisciplinary, having done some of that work myself in other areas. People at the top are often committed to kind of unidisciplinary and definitions of what they think they're doing. But you've had some success, and I was just wondering if you consider it to be almost essential before you can get a kind of a top-down, before you can get people to start to work together this way.
Yes, no, that's a great question. I think that we're finding in our studies and also from other literature about social movements, so what makes scientific social movements, and by social movements, so the analogy with regular social movements, there are things from the bottom down, from bottom up, right? What makes scientific social movements succeed that are counter the traditional paradigm? One of the things that they find is that you need, or it's very useful, to have the backing of a high status intellectual actor. At the same time, there's a bit of a paradox. That's true. When would you be most risk averse? But it's unclear, though, so then the assumption that if you're very established, you'd be more risk averse because you've established this, right, this body of knowledge that's within your discipline. Sometimes it doesn't, in my experience at least, there's some, it may take a particular personality, but that is not completely true because you're also more free to take more risks later in your career. And so the younger researchers were actually, in some ways, quite risk averse in that sense, right? Because they need the goodwill of the people in their discipline. Yeah.
Okay, thank you very much.
Thank you, Michael.
We move to our last 2 pairs of presentations, and they are in the area of litigation. And so now we're going to deal with human rights and corporate international human rights and corporate responsibility from the University of Pittsburgh, Professor Vivian Curran, and from Benjamin Cardozo School of Law, Professor Richard Weisberg.
Like everybody else, but lest we forget, I want to thank very much Professor Brand. I'm very honored to be invited to this wonderful, just a sensational, the more you learn about it, the more you admire it, this 20th birthday of CILE. I want to thank Dean Carter. Especially I want to thank my friend, officially labeled for the purposes of how these collaborations have gotten together, Vivian Curran, who has been my friend and colleague for many decades. Some of the work that I'm going to very briefly describe today, which has to do with litigation, she has been a part of both as a theorist, as a fellow litigator, as someone who files amicus briefs in important cases. I want to talk specifically today about a case that has very recently been decided, which is called Fisher. But I was inspired a little bit by looking at the newsletters, in this case a rather old newsletter of CILE from 1997, which noted, and I had sort of forgotten about this, that I also have spoken before at CILE, and I was speaking about the way lawyers and judges behaved during the period of Vichy France, during the Holocaust, a book that I had just then published, Vichy Law and the Holocaust in France. And shortly after that, I was asked by a group of litigators or practitioners to help with a lawsuit that they brought in the Eastern District of New York. And this was a lawsuit against 23 French banks who we alleged had ripped off Jewish and other victims, but primarily Jewish victims, during World War II, during the Vichy period. That case was called Bodner versus Banque Paribas, and a companion case, Benisti versus Banque Paribas. This became, at least in my life, the first of 6 different Holocaust-related cases that I became a part of, either as a kind of academic supplier of empirical information or of counsel, or sometimes as an active litigator. And I want to touch very briefly on all of those earlier cases, some of which may be familiar to you. The idea of these cases, which started to arise in around 1996 or 1997 and are still going on in American federal court, the idea of these cases was to try to bring a measure of justice to corporate, institutional, and also governmental wrongdoers during World War II. And the Bodner case proved to be a successful one, in that the litigation had some preliminary successes in the Eastern District of New York. And this led to a diplomatic settlement spearheaded in the end of the Clinton administration by a man named Stuart Eisenstadt, who continues to be a very important player in the area precisely of what might be called Holocaust restitution or Holocaust remuneration, because Stuart Eisenstadt, known to many of you, I think, in this room, was then Deputy Treasury Secretary, brought the parties together, including the government of France, 23 French banks, and 1 American bank, the Chase Bank, and the plaintiffs and the United States government, and crafted a quadrilateral treaty in January of 2001. We all right? So, are you hearing me pretty well out there? What was interesting there is that individual litigation, very adversarial, the French and the French banks and Chase Bank resisted very much the whole idea, after so many years, of charging what had usually been held a German responsibility, which was expropriation during the war, to the French. It was a difficult moment for the French to accept, at that particular period, their own culpability. Resulted in a diplomatic outcome, which over the next 10 years I also had a role in, because I was the plaintiff's representative to a French oversight commission, and the day-to-day restitution of individual victims took place there. And people who were originally adversaries, including corporate adversaries, including bankers, became friends or allies over the period of working through individual restitution. And we've returned about 150 million euros of banking and material losses to individual claimants through that process. Shortly after that, I became part of a team that attempted, and it's always a group of lawyers, as you well know, those on the plaintiff's side. It's almost always a group of what I call ragtag plaintiff's lawyers who have a variety of different strengths or talents that they bring to the process against very well represented defense counsel, typically from big firms who are representing governments or banks. we attempted to sue the French National Railroad, the SNCF, and there are two different parts of that case, which I'll go through very briefly. SNCF is back in the news in this respect again through Stu Eisenstadt, and I'll get to that in a second. When you sue a national railroad, you have an additional obstacle under American law that has to do with federal court jurisdiction, which is called the Foreign Sovereign Immunities Act, or the FSIA. You don't have that obstacle when you're suing purely private entities. The FSIA requires a lot of work under the statute to find an exception to what otherwise provides immunity to foreign governments or to government entities. And the first SNCF case was designed to argue, or we argued, was designed to try to prove that the statute was not retroactive. It was passed in 1976 in Congress, the FSIA, to events that took place during World War II. And we had some success throughout the Second Circuit, but then in a case that most of you, even non-experts, might be familiar with because of movies recently, in a case called Altman, the Supreme Court, and that has to do with the Klimt paintings, the theft of Klimt paintings, and it's recently a movie, a very good movie about the history of Mrs. Altman recovering paintings by Gustav Klimt. The Supreme Court held that the statute was retroactive. Now that, I won't go into this right now, but that helped Mrs. Altman to be able to pursue remedies against the government of Austria, but collaterally it did away with our lawsuit, and that's because we had not alleged an exception under the Foreign Sovereign Immunities Act in the SNCF case. In the Hungary case, which has just, we hope, provisionally terminated in the Seventh Circuit, the FSIA was also a player. We were suing the Hungarian National Railroad and the Hungarian National Bank. The Hungarian National Bank for theft of assets, the Hungarian National Railroad for literal genocide. Some of our clients who were 7, 8, 9, 10, or 12 years old were shoved into those horrible cars, those wagon cars that you have probably seen. Fortunately, a few of them survived, and we had to, again, run up against the possible obstacle of the Foreign Sovereign Immunities Act, and we were the first group of litigants to succeed in finding an exception called the expropriation exception under the FSIA. That was difficult to do. But here, and now I'm about to segue to my colleague Vivian Curran on some questions of international law, after we had successfully pleaded and proved not only that the railroad performed violations of international law, big time, genocidal violations of international law, but also other requirements under the FSIA, that the government or a government entity in Hungary still preserved some of these assets. Very difficult to show, but our clients' cases allowed us to prove that. The Seventh Circuit, having affirmed the validity of our case to move forward, in a case called Abeles, more recently in a case, same case, but it was renamed Fisher, held that there was a responsibility for us to exhaust our remedies under international law, which essentially meant we had been moving along pretty smoothly, that we have to go to Hungary now on behalf of our clients in order to try various remedies, judicial or otherwise, before, if those fail or prove to be futile, we can come back into American federal court. It was quite a blow and somewhat unexpected. How did international law become a factor within a statutory scheme which was specifically meant to give U.S. federal court judges jurisdiction when you have done the difficult work of proving the exception? One answer is that you have to show a takings or expropriation in violation of international law. That is language from the Foreign Sovereign Immunities Act. But we did not expect that the use of the phrase within the statute, which says nothing about the requirement of exhaustion of remedies, we did not expect that proving a violation or a takings, which we had under international law would entail a whole host of questions under international law more abstractly, and we especially did not expect to be saddled with the problem of exhausting our remedies in the very home country where all of these events took place, particularly in an environment, as you may be aware of, in contemporary Hungary, where it's quite unlikely that either the court system or any administrative agency or anything is going to be terribly receptive to the idea of these Holocaust victims or their heirs going back to the original country and now needing to seek out a remedy. So I'm going to turn things over to Vivian, who's very aware of these cases, to talk about anything she wants, but I think it will be this aspect of, somewhat curious aspect of international law as to exhaustion of remedies and its application to this litigation.
Thank you, Richard. So I'm planning to pick up where Professor Weisberg left off with respect to the Fisher case, and then I'm going to try to put the Fisher case and Fisher decision into a larger context of a trend that we've been seeing in recent years in the U.S. Supreme Court. But before I do that, I'd like to thank Professor Brand, not just for inviting me here today, but for the past 20 years of a wonderful run for CILE. I can't believe it's been 20 years. I've seen so much growth in Professor Brand, in the heights to which he's taken CILE, but I will tell all of you that one thing has been stable, and that is the strong sense of ethics with which Professor Brand has always been guided. And I think that was reflected in every comment that we heard yesterday. And it's made being a CILE faculty member so rewarding for me. And I can tell you all, I am looking forward to the next 20 years. So Professor Weisberg mentioned to you that the first issue that came up as a big surprise for the plaintiffs is that the Fisher Court, the Seventh Circuit, said both in Abeles and Fisher, these two names for the same case essentially, that the plaintiffs had to exhaust their remedies domestically. They had to go to domestic courts first. So Fisher is a case of actually quite significant legal value with respect to the FSIA, and also because of its potential for leading to misinterpretations of international law. So I would like to note that every court of appeals that has adjudicated the issue has found that the FSIA does not require an exhaustion of local remedies. So the Abeles case said, we agree with the Ninth and DC circuits that the FSIA does not contain a statutory exhaustion requirement. And I would also note that this is the position of the U.S. executive branch, as it expressed it in an amicus brief in a Ninth Circuit case. So we should be clear that it would be perfectly appropriate for Congress to require a plaintiff to exhaust its local remedies as a condition to bringing a particular suit in a U.S. court, as it has done in the Torture Victims Protection Act, the TVPA. It may also be appropriate for the United States Supreme Court to require an exhaustion condition in a judicially created cause of action. In the case of Sosa versus Alvarez-Machen, the court, in a footnote, said that it might, in an appropriate case, do so. But what is not appropriate is for courts to add an exhaustion requirement to a statutory provision that does not contain one. And if there were any doubt about it, last year, 2014, the United States Supreme Court ruled that the FSIA, that their text, this particular statutory text, is quote-unquote comprehensive. That's the case of Republic of Argentina versus NML Capital. And it emphasized any sort of immunity defense made by a foreign sovereign in an American court must stand on the act's text or it must fall. And we know that Congress knows how to draft these exhaustion requirements. It did so in the TVPA. It also did so in the FSIA in the terrorism exception. So we have such an exhaustion requirement. The fact that we don't have one anywhere else in the FSIA, I think, is quite a strong indication that there isn't one, that none was intended. The Fisher Court said that international law required plaintiffs to exhaust domestic remedies. And the Abeles case said the requirement that domestic remedies for expropriation be exhausted before international proceedings may be instituted is a well-established rule of customary international law. So what the really key phrase here is before international proceedings. And this is where you get the mistake that I believe the Seventh Circuit is currently engaged in. The exhaustion requirement in international law is restricted to proceedings that are in front of international tribunals, not domestic tribunals. And that really bears emphasis. Every case that the Seventh Circuit has cited in reliance on requiring the plaintiffs to exhaust their remedies in Hungary is based on cases that were before international tribunals. And there are many reasons having to do with the international nature of a state going against a state that have to do with exhaustion requirements before international tribunals, keeping the credibility of the international tribunal. There's a whole body of law on that issue, none of which exists where you are dealing with a proceeding in a domestic court. So the restatement has also been relied on quite heavily, the restatement third of U.S. foreign relations by the Seventh Circuit. Now, the restatement is not explicit. On the other hand, all of the examples given in the restatement third involve cases that were before international tribunals. And I think that it is logical to believe that the restatement drafters would not have approved of the Seventh Circuit's interpretation of this case. And I am on the members consultative group of the restatement fourth of U.S. foreign relations, and I believe there's an excellent chance that we will be taking a position in the restatement fourth against what the Seventh Circuit has done. I hope so. It's not a sure thing, but I believe so. Now, the second error that the Fisher Court made was its view that that this was a domestic taking, and then they sort of created an exception for genocide. But in fact, the law on this has been clear, and the courts of appeal that had considered this sort of issue had been unanimous that where you have a taking by a state against people who were residing within it, but whom that state at the time of the taking did not consider to be its own people, considered to be foreigners, that does not constitute a domestic taking under the FISA. And Hungarian Holocaust survivors actually had been ruled to be in that category in a DC Circuit case. So I'm also hoping that perhaps the next draft of the restatement will take a clearer position on these. Certainly, Jews in 1944 in Hungary, the class of people who are suing in Fisher, were considered to be foreigners by the government that allegedly expropriated the property at issue. And I think one needn't say allegedly. I think that those facts are not contested in this case. Okay, so now I would like to move on to the way in which Fisher can be seen as consistent with a larger trend in U.S. law recently. And these are Supreme Court decisions which have considerably altered the landscape for transnational litigation, and in human rights and in other kinds of litigation. And I would say that the common ground among all of these cases is an evolution away from extraterritorial jurisdiction. So you might consider the case of Kobel versus Royal Dutch Petroleum, which ended extraterritorial suits under the Alien Tort Statute against most foreign and domestic defendants alike, whenever the conduct at issue took place abroad. And then you had Daimler versus Baumann, which restricted the exercise of general personal jurisdiction, except in undefined exceptional situations, which were noted in a footnote almost in passing. And it restricted the exercise of general jurisdiction to where a defendant's place of business or place of incorporation is in the forum state. And in Daimler, for those of you who may not have it fresh in your memories, a parent company could not be sued in California for harm created by caused by its Argentinian subsidiary when that conduct occurred outside of the United States. Now, what's going on here? You have actually in many of these cases now a unanimous vote. You do have concurring opinions, but a unanimous vote. So why is that? On the one hand, some members of the United States Supreme Court have been anxious to avoid having the U.S. become a haven for plaintiffs of the world to come and bring their human rights violations claims in our courts. And so for as far as the ATS, the Alien Tort Statutes, is concerned, they have shifted the analysis from the terrain of human rights. The ATS has been a human rights statute since for 30 years since the Filartiga case, although the statute itself has been on the books for 200 years. But it reversed a decades-long accepted understanding that this statute was about human rights, and it shifted it onto the terrain of commercial law by analyzing the jurisdictional issue in terms of analogies to cases like McIntyre, so cases that were in product liability, that were in securities law. And on the other hand, you have other members of the court who are anxious to harmonize U.S. law with the law principally of other Western countries, and who are concerned about international comity. So their views don't overlap 100%. As I said, you'll get sometimes you will get a dissenting opinion. Generally speaking, you'll get concurring opinions. Often you're getting unanimous votes. With respect to Daimler, the court's interest in international comity was made explicit. Justice Ginsburg, in other cases as well as in Daimler, had talked about how seriously one must consider the issue of hauling a foreigner into court in the United States. I would like to mention that in thinking about how to handle the situation after Daimler, other countries are also grappling with this issue. Daimler was intended to bring U.S. law into line with EU law. And in France today, there is legislation pending. The lower house of parliament has actually approved it. The upper house hasn't voted yet, to make large multinational corporations, they would have to have quite a large number of employees, liable for human rights violations, the parent company liable for the conduct of subsidiaries. So that is something that is taking hold as an idea. Whether that goes through, we don't know. So although Justice Ginsburg was trying to bring U.S. law into line with EU law, in fact, she didn't quite do this, because in our personal jurisdiction cases, we restrict jurisdiction in ways that the EU would permit jurisdiction. So in fact, after Daimler, we now have a more restricted jurisdiction situation than is the case in Europe. On the other hand, what we can note is that just as the U.S. is restricting its extraterritorial jurisdiction, often with references to that being the practice in the rest of the world, and especially at oral argument in the Kiobel case, you had a number of justices talking about that. We find that in other countries, courts are growing warmer to the idea. And for example, a court in the Netherlands recently accepted jurisdiction in a civil case involving alleged extraterritorial international human rights violations by a multinational corporation. So we certainly hope that with respect to the confusion over the FISA, the Supreme Court will pronounce itself, despite having for the moment denied cert in the Fisher case. The general trend to restrict extraterritorial jurisdiction in the United States does seem to be here for a while. It probably will be staying here for a while. If there are going to be modifications, it probably would come from legislation. To see legislation modify the situation is probably not realistic, at least for the moment, for the foreseeable future. On the other hand, more likely would be to see from a transnational perspective that other courts in other countries might be picking up where the U.S. has been has been stopping or maybe retreating a bit. So I think I will end my remarks there. I don't know if we have time for a question or two. Good.
The title of our panel, of our presentation, also had to do with corporate responsibility. And I did want to point out somewhat, our little twosome here is called Litigating International Human Rights Cases and Corporate Responsibility. And I want to point out two examples of corporate responsibility that, in my experience, have taken place rather exceptionally, since we were often suing in these Holocaust-related cases, we were often suing corporations. One was in the Bodner case that I started with. That case involved centrally a lawsuit against 23 French banks, banks that still existed decades after the original wrongdoing during World War II. Banque Nationale de Paris, very familiar names. When you watch the French Open, you'll see the BNP, you'll see these various banks sponsoring events, who do huge amounts of business within the United States. We also sued two American banks, Chase and JP Morgan, which were not at that time merged, and a British bank, Barclays. We had very good evidence at the beginning of the case that these three non-French banks had also ripped off their Jewish clients, corporate and personal, in France during World War II. JP Morgan and Barclays separately decided, upon the showing of a very small amount of evidence, but I think it counts as a smoking gun, that they would internally research their own potential wrongdoing without waiting for a court to insist during a discovery process that they do this. This was a remarkable show of corporate responsibility, and they invested in the 7 figures to find out what had actually happened in France on their own, and they came back after finding that there had been a small number, an important number of instances, indeed, of banking theft by them on French soil during World War II, and they separately sued, or asked, it would be the better word, to settle. JP Morgan and Barclays settled separately, while Chase and the 23 French banks, so to speak, played hardball until the outcome of the case that I mentioned to you earlier, which was a quadrilateral settlement with the help of Stuart Eisenstadt. And the second example has to do with these very same French bankers who hated, I think it's not even a strong enough verb, who hated at first the whole idea of this litigation, as did the French government with whom we negotiated, but who, after the treaty was signed, became active agents. These are the same French banks, basically, through their agency, work with me and with members of the United States State Department, and became active agents in the day-to-day process of restitution and reparation in France. So it's an example of the most harshly or fiercely adversarial process winding up with the help of good luck and a lot of other things, some judicial opinions, resulting in what I would call a very high level of ethical corporate responsibility in the long run. And I hope that those corporate lawyers sitting in this room, we're not expecting kumbaya moments when corporations, as was mentioned by one of our earlier speakers today, not expecting a lot of hugging and kissing with plaintiffs' lawyers, but it is possible to take a view, particularly in these human rights case areas, that is more harmonious with those that I mentioned to you in these two examples. And a lot of it has to do with who the lawyers are. Thanks very much.
Thank you, Richard and Vivian. Now going to have Paul Harrop join me for the final part here. And with all due respect to my colleagues, we now come to the most exciting topic of the day: jurisdiction and the recognition and enforcement of judgments. Now, we had originally titled this Basics of International Litigation, Jurisdiction and the Recognition of Judgments. We're really going to focus on, bringing judgments to U.S. courts or taking U.S. judgments abroad. We're going to focus on recognition of judgments. Now, Paul and I both worked with Jeff in 2005 on the completion of the Choice of Court Convention in The Hague, and we've lost Jeff to that effort, but we've continued to work in The Hague and now are working on the possibility of a broader judgments recognition convention. But what I want to do is look at U.S. law on this very quickly and a little history. But what I want to try to demonstrate is that the law has been the same in the United States for quite a long time on this, but the source of the law has changed, and that may not necessarily have put us in a very good position domestically and is creating problems right now. And then I think Paul will follow up on some comments how those problems might be reflected outside our borders as well. But in the United States, we really have two types of foreign judgments. One is dealt with within the Constitution in Article 4, and those are sister state judgments that, and under Article 4, each state must give full faith and credit to the judgments of other states. And so we get free movement of judgments throughout the United States, both state court judgments and federal court judgments. And that's a process that works, and it binds us together and ties us together and prevents duplicative litigation in courts. The other area of foreign judgments is the area that we really are talking about, and that's foreign country judgments, and when they come to the United States. And then in terms of history, the history begins with federal common law and international law. 1895, Justice Gray, in the case of Hilton versus Guillot, there was a French judgment brought for recognition and enforcement against a U.S. citizen in the United States. And Justice Gray relied on comity and reciprocity. Ultimately, under comity, he said we should respect and enforce judgments from foreign countries, but under reciprocity, he said we should do so only if they do it for us. And he ultimately found that France didn't do it for us, so he didn't do it for them. But the legacy of Hilton versus Guillot is really in two parts. First, he broke down the types of judgment. He said a judgment rendered either against a citizen of the forum state or against a party that initiated litigation in the foreign state should be given effect in other states. So in other words, if a judgment comes from France and it's against a foreign citizen, or if it was brought by a U.S. citizen and the judgment was against the person who had brought the action, then we should either, it's against the party that's the home team, or it's against the party that chose the court. And in either of those cases, it makes sense to recognize that judgment. He said, though, on the other hand, when a local Frenchman brings a case against a U.S. citizen in a French court and gets a judgment and then brings it here, that's a bit different, and that's a more difficult case, he says. But when he looked to the law applicable, he said the law applicable is international law, including private international law. And then he went on to give us the rules that are still the rules today in the United States on the recognition and enforcement of judgments. They're just stated in different places. But he said if the court had competent jurisdiction, had regular proceedings in a system that would secure an impartial administration of justice and there was no fraud, then we should recognize and enforce that judgment. In other words, it's not as far as full faith and credit, but it's comity. We give respect to the in this case, judicial actions of the foreign state. Now, what happened with that? We have to realize that 1895, Hilton versus Keogh, this was in the era of Swift versus Tyson, okay? General federal common law. And that's what Justice Gray was applying, okay? But in 1926, the New York Court of Appeals began to show us what was going to happen, and in a case that actually had, again, a judgment from France, and it was one of the easy cases under Justice Gray's analysis because it was against the French citizen. They said, well, we know Hilton versus Keogh is out there, but we don't see any reason to apply federal law on this. We will apply state law on this. But they went ahead and recognized the judgment. And then came Erie, right? Erie changes everything. And in Erie, what we learn is that there is no general federal common law, but that's what Justice Gray was applying in Hilton versus Keogh. And that the Rules of Decision Act requires that federal courts in diversity cases, including alienage diversity cases, look at state law, both legislative and common law, for the rules of decision in the cases, okay? So we look to state law. And the combination of Johnston and Erie then afterwards led to just about every state and federal court considering the issue to say that this is a matter of state law, the matter of recognition of a foreign judgment, okay? Then we began to have what I call evolution with confusion, but it's also some codification here. In 1962, the Uniform Law Commissioners adopted the Uniform Foreign Money Judgments Recognition Act, which basically codified the rules of Hilton and the substantive rules, but as a state statute. And some states began to enact that, not very many, though. 1986, the ALI and the restatement basically said, well, the common law, in their restatement of the common law, said that the substantive law is basically the same as the rules in Hilton, which is basically the same as the rules in the 62 Uniform Act. And then in 1992, the U.S. Department of State requested negotiations at the Hague Conference on Private International Law to move toward or consider a convention on jurisdiction and the recognition and enforcement of judgments. Now, three things happened in 2005, okay? First thing was that the Hague Convention on choice of court agreements was completed in The Hague. That convention provides three basic rules. One is that if parties have chosen a court to decide their disputes, that court shall have jurisdiction. The second is that if somebody brings the case in a non-chosen court, it shall defer to the chosen court. And the third rule is that if the chosen court takes the case and renders judgment, that judgment shall be recognized in all of the contracting states to that treaty. Okay? So, well, Also in 2005, the Uniform Law Commissioners revised their 62 Uniform Act and now had the Uniform Foreign Country Money Judgments Recognition Act. Interestingly enough, even with those two acts out there, one of them available for over 60 years, there's still at least a third of the states that have not adopted either one of them and rely on the common law, the restatement expression of it. And in 2005, something that really was in conflict with the Uniform Act. The American Law Institute proposed a federal statute on the recognition and enforcement of judgments. Now, and then in 2012, the Uniform Law Commissioners completed a Uniform Choice of Court Agreements Implementation Act, which, if the structure were adopted, would be used to implement state by state the 2005 Hague Convention, which means we would have the treaty, we'd have a federal statute, and then in every state we would have a state statute. Think about that for just a minute, but not more. That created a problem, and it put the ULC, the Uniform Law Commissioners, clearly at odds with the American Law Institute, clearly at odds with a federal approach, but it put the ULC where the law was, because the law was state law after Erie, all right? Harold Coe, then the legal advisor at the Department of State, got together some representatives from the Uniform Law Commission, from the ALI, and from the various departments in the government that were interested in this, and said, let's try to work this out. Okay, let's try to use, and the focus was on something that was being called cooperative federalism, working, and it has worked on some treaties in the family law area in particular that have come out of the Hague Conference. But that wasn't successful, okay? But what has happened is that Mexico acceded to the convention, and this year the European Union ratified the convention, and it goes in effect for the 28 member states of the European Union and Mexico on October 1st of this year. Now, what's likely to happen? A lot of states have been waiting on both the EU and the US, and what's likely to happen is a lot of other states now are going to follow suit with the EU. And if that happens, what does that mean? If I'm drafting a contract and I can choose the London courts and know that it's going to get recognized and enforced everywhere, but if I choose New York courts, I'm not going to get that because the US is not a party to the convention. It's pretty clear what's going to start happening in contracts and where the litigation is going to go in that process. Now, there are some other problems of non-uniformity in the United States. I want to use these two cases to indicate these problems, the problems that exist because what began as federal common law in one source in Hilton versus Guillot has now become, well, the European Union has had kind of a magnetic effect and put everything into one place, and we've seen that elsewhere today. What has happened is in the United States, what I call the centrifuge effect. It's all been spun out to the states, and the law can differ from state to state. And here's two examples. The Standard Chartered Bank case. A judgment from Bahrain was brought to New York. New York courts entered a judgment of recognition. That judgment of recognition was taken to Pennsylvania courts, and under the full faith and credit clause was given recognition. Not recognition of the Bahraini judgment, but of the New York judgment. The New York judgment was taken to the DC courts, and under the Uniform Foreign Country Money Judgments Recognition Act was rejected and not given recognition. And the DC court said, look, first of all, the New York courts have a different rule on jurisdiction for recognition cases. They took it when we wouldn't have, and our law is enough different that we would have had a different outcome. We will not give full faith and credit to the New York judgment. In the Alberta Securities Commission case, a securities debt in Ontario was turned into a judgment in Ontario. It was taken to Arizona, where it was recognized. It was then taken to Delaware to try to get enforcement because there was stock in Delaware. And the Delaware court said, this is ridiculous. We would never have recognized this judgment because it's not the type, it is a revenue judgment and a penal judgment for the government, and we don't give recognition to that. But because of the full faith and credit clause, we have to give recognition to this judgment, so we do. So what you see here is problems. You see an area of the law that really is a foreign relations matter that's being, I think, messed up because we've got scattered different rules. Basically the same rules we have from Hilton, but they're enough different from state to state that what you can do then, it creates a litigation forum shopping situation where you really have to think about, well, can I get jurisdiction here and can I get recognition? Or should I get recognition somewhere else and then come and get enforcement where the assets are? So you don't just go directly to where the assets are, you may play games and funnel it around. And that's a system we probably shouldn't have. A couple of final comments. Two other issues here, recognition, jurisdiction. The Lenshishan case in New York State has said, well, when you're bringing a judgment for recognition, you don't need personal jurisdiction over the judgment debtor, the defendant, nor do you need to have assets in the state. If you have either of those, that's okay. Now, the ALI and everybody else has said, well, you need either personal jurisdiction over the defendant or the assets. Interestingly enough, last Friday, the Supreme Court of Canada decided a case where the argument was there was no personal jurisdiction over the party against whom the judgment was to be recognized, and they said you don't need personal jurisdiction in that type of case because we're not making the principal determination of liability. Okay? And there's a related issue of forum nonconvenience in some recognition of arbitral award cases. The Second Circuit has in effect said if somebody's coming to bring the arbitral award here for recognition and enforcement, you can get it dismissed on the basis of forum nonconvenience. Okay? So what you see here is a situation where we have a problem of federalism conflicting with a problem of international relations, but it's a matter of private international law. Okay? And I think it gives us a situation where we have to ask, it affects what we do in the international sphere, and I'm going to, at that point, turn it over to Paul to discuss his thoughts on that.
Thank you, Ron, and I want to repeat what virtually everyone else has said. Congratulations on the 20th anniversary of the center. Job well done. As Ron has indicated, I'm going to talk about some of the international aspects of particularly recognition and enforcement, but there are also some jurisdictional and general PIL tails to this. I am going to focus primarily on the issue of treaty making, and after Ron's rather discouraging description of the situation in the United States domestically, I'm not going to be all that much more optimistic internationally, but I do want to hold out certain hopes in this area. The first thing I want to note historically is that in 1890, when the Hague Conference on Private International Law was established, or in the process of being established, its founder, Tobias Asser, made a list of major problems of private international law for which treaties were desperately needed, and I think the first item on the list was a recognition and enforcement convention. For 110 years, virtually no progress was made. There are some very good reasons for that that I'm going to get into. Nonetheless, I think things began to change in terms of underlying realities in the late 1990s or early 2000s. I think there may be some hope. I think we may be entering into a period of transition in this area, and I will quickly explain why. But let me give the usual lawyerly caveats. I know that the field of history is covered with trumpeted transitions that never happened. This could be the case here as well. Some of that is simply people involved in situations mistake a good deal of sound and fury for real movement. that could happen here. Sometimes there is movement and you simply slip back to something like a prior status quo. That could happen here as well. Nonetheless, I think we do have some foundations for some movement forward. But in order to talk about a transition, everything, of course, is a transition from something to something else. And I want to describe what I think the salient characteristics of what might be called the ancien regime in this area were. I'm going to take this and distill it from a 2-hour conversation I and Hans von Lohen, who was the Secretary General of the Hague Conference, had with Arthur von Mehren, who was the U.S. delegate for 30-some years. Arthur's last appearance, Hans and I sat down with him and had a very long discussion. But distilling Arthur's reminiscences, and I should begin by making proper genuflection to the Cathedral of Learning, because I'm going to have some unkind things to say about academics, Ron accepted, of course. But the usual approach until the 1990s was that we and virtually anyone else who was participating in this kind of endeavor would send an academic to The Hague. For years it was Willis Reese, then Arthur. There would be a conclave of a group of 12 to 14 professors. They worked, if at all, at a leisurely pace. Arthur described these meetings as basically a 4-hour daily seminar. Everyone who was involved was either from Western Europe or the United States or the UK. What they would do on the chosen topic was examine their own national laws, and invariably, because there was a plurality of representatives from either France or French-influenced countries, some solution, which was basically a knockoff of the French Civil Code, was cobbled together. This was presented as a draft international treaty, and of course, it gathered dust in file cabinets. File cabinets at the State Department are full of this stuff. The simple fact was that the people who wanted this particular instrument didn't need it. It was already their domestic law, and anyone who might arguably need it didn't want it precisely because it was French domestic law, and that was it. And finally, and this is an important point, this was private law. There was a rather quaint notion that the role of the state members who would ultimately be ratifying these treaties would simply, if you will, put their chop on whatever the instrument was and provide all the resources needed by way of courts, infrastructure, and so on to make it happen, and the states really shouldn't be that interested in content. Well, while none of that has entirely vanished, each of those elements of the ancien regime is greatly attenuated, thank God. First, we now have far more diverse participation with a great variety of private interests and governments actively engaged in these kinds of negotiations. The simple fact is that people are beginning to realize that this stuff actually is important and it's getting attention. Now, there are at least two components of that importance, or the realization of its importance. The first is the brute fact that we have more people, more goods, more ideas crossing borders every day, and quite often in relatively small doses. Now, one of the great triumphs of private international law, treaty making in a sense, is the New York Convention in the field of arbitration, but usually that involved very, very large commercial interests and still does involve commercial interests. I have always thought that for middling level participants in family law issues and smaller commercial transactions, well, you can complain about the burdens of transnational litigation. If you really want to oppress someone, send them to international arbitration. It's a lot more expensive and a lot more difficult. So we're having a greater and greater demand at the middling and smaller level for something like litigation solutions and more interest. The second point is there's a great deal more direct government litigation. This was somewhat alluded to in the previous panel, but a lot of it is more mundane stuff. Many of the issues in this litigation involve the traditional grist of private international law, questions of jurisdiction, questions of choice of law, questions of recognition and enforcement of judgments. Now, I would say that when you're dealing with states, in some respects, these doctrines are best treated as having a very strong, if not complete, public international law component, but that's part of a very large volume that I haven't written yet, and we'll set it aside. I would also make one other comment on the nature of this interest, because at least in the commercial sphere, we are dealing with somewhat smaller transactions, somewhat smaller interests. It does and has generated a kind of collective action paradox in that no one has a sufficiently great stake in the outcome of these treaty negotiations to throw themselves off a parapet for the final result. But if there is one group with an intense opposition to the product, it can really gum the works up. I'm going to just notice that very quickly and pass on. The result, however, of this greater interest and realization in the importance in the area is a far greater intensity and scrutiny in treaty negotiations and treaty making that goes to issues of domestic consultation, negotiation of treaties, and also drafting. It also, by the way, means that the results are frankly somewhat uglier than the rather bare bones and very general old regime solutions. For example, in the Choice of Court Agreement Convention, which Ron and Jeff are intimately familiar with, there's a provision on leasing that's in there, and rentals, because the Germans didn't want to change their domestic law on the subject, and that was a necessary part of the compromise. There's something on maritime law which reflects Portuguese shipbuilding subsidies. You get a lot more of almost a traditional U.S. congressional log rolling result, which probably is not desirable in an international convention, but there it is. The third point that I want to make is that because we are getting this increasing participation, and just as an example of this, at one point in the Choice of Court Agreement conventions, the largest delegation was the Ukraine with 13 members. We are now having in the current round of negotiations with the working group very heavy Latin American participation, particularly Brazil, a very active Korean delegation. The Chinese are very prominent. These are going to have to be world conventions. No longer will there be a Western European consortium with a U.S. add-on. And I should add that one of the things that has actually in some ways made things simpler is that rather than 26 or 28 individual European countries, we now have the EU asserting competence, and we have one point of contact with Europe with whom we have to deal, although the EU Commission obviously is responsive to its individual members and their interests as well. So, and one last point I would like to make on underlying, if you will, the underlying conditions which may lead to a transition, and that is this brooding omnipresence in the sky, which Professor Graves referred to earlier when he was talking about the civil code view of national statutes as somehow distilling some sort of universal fundamental principle of law which should bind everyone, is becoming diminished, if not entirely eliminated. There are still some who actually believe in this, but we are, in some respects, in a positivist age. People are now seeing that much of the legislation of individual states reflects policies and practices in that individual state. And this is leading to a further recognition that you simply cannot take national legislation and send it broadside into some sort of general treaty. And I would simply, seeing that I'm close to the end, note the title of a book by Stephen Kuttner, a great historian of canon law, lectures delivered at St. Vincent College in Latrobe called Harmony from Dissonance, describing what medieval law did in Kuttner's view. That basically is what we are going to have to do as well. Our success will depend on finding approaches which accommodate the realities of truly global and diverse interests and constituencies, while trying to minimize the disruption of various domestic legal orders. And what that is going to require, in my view, and this tags on to something that was said in one of the earlier panels as well on the global commons, was what I think will be emerging necessity of really good comparative law foundations and in the search for global conventions. We need to understand the doctrines and beliefs of our partners. We need to look for areas of common results, system by system, and frankly, damn the doctrine. One of Harrop's laws is man has an infinite capacity for rationalization. If with our comparative law inquiry we can identify common results, we can work out rationales. We'll get there. Another point is that, quite frankly, we are not going to get European-style comprehensive code resolutions to everything. We will have to settle for results that are going to be somewhat more modest. We'll have to do what we can do globally, and if we can't, we should not be trying to force things that we cannot get. And we need to be inclusive and also leave room for future adaptation and joining of conventions by countries that might not be in a position immediately to join, what I would call lock and key conventions, which basically open doors between systems rather than trying to transform various domestic legal orders. Another thing that we are going to have to start doing is to encourage regional experimentation. One of the most heartening developments is an agreement between Australia and New Zealand, the Trans-Tasman Agreement, where they're actually trying certain things out, and we can see what works between them and what doesn't. But we are also going to have to be realistic, because the likely results of this kind of work are not going to be the spectacular global conventions that some people want. Various national governments are going to have hard choices as to how much by way of resources they can allocate to get to a number of limited conventions. And this is going to be difficult, it's going to be tough, but it's ultimately what those government offices are paid to do. Let me finally stress that I'm talking about possibilities only. This could come a cropper. I will leave you with the words of one of those true freaks of nature, a sagacious Frenchman, who observed that the future disappoints because it is so surprisingly different. Who knows, but I'm hopeful we may be looking at a transition period here.
Thank you, Paul. That ends our afternoon session of Pitt faculty and friends. Paul, I'm going to let you retire to the softer seat, and I'm going to invite Chancellor Emeritus Mark Nordenberg to come for some closing remarks. But first, Mark, let me introduce you. It's very special to have Mark Nordenberg here to give the closing words this afternoon, the final words of this. He is in many ways responsible for most of what has happened around here in lots of ways. Mark came to the University of Pittsburgh as a visiting assistant professor, quickly was hired on the tenure stream, became law school dean, became acting provost and senior vice chancellor, became acting chancellor, and then became for 18 years chancellor of the University of Pittsburgh. And I think it's safe to say that he probably, at least over the time that I've been in academic life, has been one of, if not the most effective chancellor presidents of a university in the United States. He took the University of Pittsburgh from what was really a regional university to a national presence in a way that was very, very dramatic. That said, this is still his home at the law school, and he was a scholar who had an impact. He was on the U.S. Supreme Court Federal Rules Committee and the Pennsylvania Supreme Court Rules Committee. I guess there probably are those who, when he went into administration, were happy because he was the guy who always won the student Excellence in Teaching Award. It left it open for some of the rest of us now and then when he went on to someplace else. But he is the consummate teacher, scholar, university administrator combination. And I must say that it's personally rewarding and perhaps a conflict of interest for me to introduce Mark because Mark was chair of the Faculty Appointments Committee the year I was hired here. He was dean the year I received tenure. He was dean the year I was promoted to full professor. And I have the honor currently of holding the Chancellor Mark A. Nordenberg University professorship. That is a special honor that results from the trustees using not university money but their own personal money to endow that position in Mark's honor as a sign of the respect they had for him, and it certainly is an honor for me to hold that title. So here to speak to us, Chancellor Emeritus Mark Nordenberg.
Thank you very much, Ron. You're far too kind. It is great to be back in the law school, particularly for such an auspicious occasion. And it is nice to look out into the audience and see the faces of so many people with whom I have worked in the past and for whom I have such high regard. And because trial advocacy was one of my principal professional interests as a faculty member, it also is nice to be back in this room. I spent a lot of time here in the literal sense, and I see John Burkhoff looking off to his left. A few years ago, I became kind of a full-time occupant of this space when my portrait was hung in this room. There is a little bit of a story that goes along with that. There was a tradition here in the law school of hanging all of the portraits of the former deans in what then was the faculty lounge. I was not here, but as history has been shared with me, a concern was expressed that that particular display, consistent with the history of the school at that point in time, consisted only of white males. And so in the dead of night, those portraits were removed and stuffed into a closet someplace. You might call it the mass incarceration of the decanal portraits, and only two were spared. One is Ed Sell, and because Ed was the dean who built this building and secured the naming gift for the courtroom, hanging him on the wall here made a great deal of sense. In my own case, I always thought it was less a matter of merit and more a matter of studied risk avoidance. I picture someone saying, you know, as long as this guy is the chancellor, why run the risk of some form of retribution? We better find some place to hang his portrait. Why don't we put it next to Ed? And whether it makes sense any other time or not, actually, it does strike the right chord today, I think, because I do want to go back in time, and not even back in time 20 years to 1995, which is about the time of that portrait, but 10 years earlier to 1985. At that point in time, I was a young, brand new law school dean. Professor Brand was a young, untenured member of the faculty. Professor Fleckner was even more junior than Ron. And I don't think anyone else who spoke this afternoon was yet on the faculty. Vivian would have been next, but she did not join the group for several years. And at that point in time, it would be fair to say, and John Burkhoff will remember this, in terms of international law, you might have described the Pitt School of Law as a vast and barren wasteland. There had been, in fairness, institutional investments made in international law in the late 1970s and early 1980s, and there was a widely shared belief within the faculty that those investments had not produced a fair return, either in terms of educational programs or in terms of scholarship. As a result, and this may seem surprising on a day like today, some faculty members were of a mind that we never should make another investment in international law again. And in a sense, we didn't for a while. It is true that Ron was permitted to do some teaching in the international business transactions area, but we really hired him as an estates and trust professor. And Jules Lobel was permitted to do some teaching in the public international law area, but we really had hired him as a constitutional law professor. And so to the extent that international law was reflected in the course offerings of this school, that really was more a concession to the interests of individual faculty members than it was an institutional curricular commitment of any kind. And so in my mind, the single most important force in effecting a change in that attitude, and the triggering force in taking us from 1985 to this day, was the uncontrollable desire of Ron Brand to stop teaching estates and trusts, which is something to which almost all of us can relate. But Ron did have his aiders and abettors, and giving historical credit where it is due, the most important institutionally was the late Burkhard Holzner, then the director of the University Center for International Studies. Usus, without question, really was a jewel of the university, a center of impact that was being copied with different levels of success by other fine universities, and Burkhard, who became a good friend, was an accomplished scholar, an able administrator, and a real man of the world, which might lead you to wonder why he had any interest at all in a couple of unsophisticated Midwesterners like Ron Brand and me. Whatever the reasons, Burkhard came to the law school and he met with me and he discussed the opportunities for the center and the law school to partner. And perhaps most important, Burkhard came with more than ideas. He came with the possibility of money. The USIA was about to sponsor a grant competition associated with the bicentennial of the United States Constitution. The law schools that were successful in that competition would receive funding that would support a program of faculty exchange between the American university and its international partner for a period of years. Burkhard gave us a grant writer. We put together a proposal. We won. He had suggested that because the university already had a strong university-to-university partnership with the University of Augsburg, they might make an appropriate partner. Everything began to unfold from that point. I had involved Ron in drafting the grant proposal. He became the first member of the Pitt faculty to travel to Germany and to teach for the better part of a summer. Several Pitt faculty members, including people in this room, subsequently made trips, and we regularly hosted German colleagues who came to teach our own students and to interact with us. And some of those relationships now have been in place for a quarter of a century. I think the creation of that exchange really was a milestone event in terms of international law in this law school, because it led to the development of a new appreciation for international programs within the faculty. As faculty members traveled to Germany or as they interacted with the German professors who came here, they became aware of the heightened richness that all of this could mean, both for the lives of faculty and perhaps more importantly for the lives of students. And that was true, whatever the more focused interests of the particular law professor might have been. The second of the events that I think made a real difference occurred a couple of years later, and it involved a visit by Ron to my office as dean. He came in and basically he said to me, Mark, the State Department desperately wants me to participate with the team that is going to be negotiating treaties in The Hague, but they don't have any money to support my travel expenses or anything else. And if my mood had been different on that day, I might have said, hey, Ron, give me a break. If the United States government wants you desperately to participate in this process, I bet they can find money for your airfare. But instead, I saw the opportunity as Ron did, and that is a special opportunity for the development of his career and for new ways of strengthening the school. And it really was through that process that Ron began building both an incredible network of important colleagues and also began developing his own reputation in this area. And so this is how a young man from rural Nebraska who practiced law in Elkhorn, Wisconsin, and was hired as an estates and trusts professor, came to build an international law empire here at the University of Pittsburgh. Now, Ron, of course, would say that he had plenty of help, and I know that's true. I know most directly about the work of Professor Fleckner and of Professor Curran, but I know that many, many others have been involved in a broad range of ways, and I think all who have aided in the quest to create this center as a center of excellence. Whether you're from the University of Pittsburgh or a returning friend, should be proud because this really is an out-of-the-ashes kind of story. And just think, you have helped transform this school from one in which there was almost no interest in international law to a school in which that interest is strong, a school in which the activities are vibrant, and really a school in which international law strengths have become one of the defining qualities of the institution. You've taken program ideas that first were delivered to us from the University Center for International Studies and built programs of distinction that have added strength not only to the school but to the center and to the university as a whole. You know, Ron mentioned the fact that he holds the chair that bears my name. When I first sat down with Alberta Sabraja, who then was the director of both our European Studies program and our European Union Center of Excellence, to say to her that I would like her to be the first person to hold the chair, she looked at me and she said, I thought you were going to ask me whether I thought Ron would be a good person because he really would be so worthy. And the truth is that during the years that Alberta held the chair, the single largest slice of investment she made from the endowed fund were into the Center for International Legal Education because she thought, with her university-wide responsibilities in the centers that she led, that this was the place that was producing the greatest returns on those investments, which really was a credit to Ron and to the center. And it certainly is a far cry from where we were in 1985 or in 1995. You've also made this a far more interesting home for faculty members, a place where there is really an incomparable breadth in terms of new opportunities from which they can make their teaching and their research and their service contributions. And most important of all, you've created an unbelievable array of special opportunities for students. When I looked over Ron's CILE by the numbers, I was really almost overwhelmed. 252 LLM students from 69 countries, 10 SJD students from 7 countries, study abroad opportunities for 279 students in 50 countries, internships for 150 JD students in 50 countries, 158 internships for LLM students at 57 different firms or organizations, and since we're in a courtroom, I could not possibly leave out support for 217 students participating in 59 international moot teams. It really is an incredible record of impact when you look at it by the numbers, but what we all know is that the numbers don't begin to measure the kind of human impact that this is going to have on the lives of those who directly participate, and then also on the lives of those they touch. You know, it would be nice enough if we were getting together today to celebrate the fact that this center has made it for 20 years. But really what we're celebrating is something much more than that. We're celebrating the fact that this is a center that really has made it big. It is a center that has made a huge positive difference in the lives of countless people over the course of the last 20 years. And as Vivian said in making her remarks, with the foundation that is in place, there's every reason to be confident that much more good work of impact is yet to come. And so again, I congratulate and thank each and every one of you who has contributed in any way. I have been a proud witness to it all, and I do extend gratitude to you all from myself and from the university. Thanks and congratulations, and happy birthday, Ron.
Thank you, Mark, and thank you all for being here to celebrate with us. And I hope you'll continue that celebration with us by going up from here to the second floor. We have a reception, and you can be the first people to tour our rooftop garden outside and see the new facilities there. A couple of housekeeping announcements, and Austin, make sure I get all of these right. Number one, recycle your name tag in the box. Number two, if you have a yellow sheet for the CLE credit, leave that as well. And number three, if we could have the speakers join us up here for just a moment for a photo, we would like to do that as well. Did I get all the announcements, Austin? Okay. And please join us on the second floor. And again, thank you so much for coming.